I have a submission, ma'am.
Yes.
Appeal was filed on 6th of this month, and all the office objections have been complied with scrupulously on 9th. And additional objection that was raised yesterday, there was also complaint, madam. But the matter is yet to be posted before this court. This urgency is going to be.
That's kindly one submission, Lord, sir. Jumla petition 6544/24. The co-accused was granted on the bail, my lords. The matter was the last date of the hearing listed on the third list. The matter was not reached, my lords. Kindly have it on tomorrow for hearing, my lords.
Where is the memo?
The
Number? You filed the memo?
65, yes, ma'am.
Memo file ಮಾಡಿದ್ದಾರೆ. Yes.
The adjournment, list 2, page 2, serial number 10, page 3, serial number 11 to 17.
Serial number 17. I will play for 2 weeks time.
You are for respondent.
Respond.
2014 matter, sir. Final hearing.
What did I engage
wait for
senior?
Wait for some time.
I wanted to
You
engage.
should get ready. No, in all these old matters will not grant time.
I wanted to engage senior counsel.
Maybe.
2 weeks.
Whatever you want, you do it. I am not coming in the way, but please address the argument last time. Either you address or let the senior counsel address the argument. That's all. Next.
Page 4, serial number 18 to 24.
Which one?
Serial number 24.
24. 24. Ah.
2 days.
24. You are representing whom, sir? Ah. What is the difficulty? Where is Mr. Shivramu?
Not keeping well. Yesterday from
ಯಾಕೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಅಂತ ನಾಟ್ ಕೀಪಿಂಗ್ ವೆಲ್ ದೆನ್ ಅದಕ್ಕೆಲ್ಲ ಈಸ್ ಫೈನ್. ಈ ಕೋರ್ಟ್ ಮುಂದೆ ಬರೋದಕ್ಕೆ ನಾಟ್ ಕೀಪಿಂಗ್ ವೆಲ್. ಯು ಆರ್ ಫಾರ್ counsel for the petitioner prays for time. Then counsel for respondent opposes the move. The petition is of the year 2021. When a counsel for the petitioner undertake to address his argument on the next date of hearing, without fail, submission is placed on record. List on. No further adjournment on any ground. ಅದಕ್ಕೆ you are seeking time. Subject to the above condition, interim order is extended.
Senior number 13, sorry, 13.
Date will be given, sir. Court officer will give the date.
13, 1-3.
13, ಅದು ಒಂದು ನಿಮಿಷ. ಮತ್ತೆ next.
Sir, 29, my lord.
29.
Please, my for petitioner, my lord. Weeks time will be granted, my lord.
Counsel for the petitioner prays for time. Next.
My lord, list number 3, serial number 3, my lord. That minor corrections is there, my lord. Office objection. Only in respect of initial, my lord. JP gave PJ and ಹಾಕಿದ್ದೀನಿ.
Comply with that.
Today it's up. Pending.
ಮಾಡಿ.
ಮಾಡಿ.
ಅದಕ್ಕೇನು ಯಾರು ಮಾಡ್ತೀನಿ ಅಂದ್ರೆ ಕೊಟ್ಬಿಡಿ ಮಾಡ್ಲಿ. Yes, comply with that.
I'm
Date
moving
may be
this.
fixed for first time.
First comply with that.
I was in criminal petition. There was in the similar case, accused number 1 had
I
gotten
file
the
it, file. Yes.
My lord, list number 3, serial number 6, my lord. Complaints ಇದೆ ಸಮಯ ಅದು little bit 1 week grant time.
ಮಾಡಿ ಸರಿ, ಎಷ್ಟು ಕಂಪ್ಲೈಂಟ್ಸ್ ಇದೆ ನೋಡಿ.
4 ಇದೆ ಇಲ್ಲೇ ಮಾಡ್ತೀನಿ.
ಮಾಡಿ. Next.
ಮತ್ತೆ ಅದರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಹೇಳಿದ್ರೆ 6.
First comply with that.
Yes, my lord.
Later I will let.
Number 3, serial number 1, my lords. List number 3, serial number 1, my lords. For further arguments, I have VC at 2:30, my lords. If my lords permitting me, I'll come and argue in the end of the list, or kindly have it on tomorrow, my lords.
ಯಾಕಿದು? What is this further arguments?
Yesterday, my lords, yesterday's 302, 3.
302.
Yes, my lords, 279 and 302.
279 is converted into
I'm
302.
ready, my lords, but I have to attend VC, my lords.
ಆಯ್ತು, after completing that you come back.
My lords, if it is not possible, matters ಇದೆ 15 to 16 matters ಇದೆ, heavy matters ಇದೆ, my lords.
Yes, who is for the petitioner?
V. Anand.
No, he is also not there. Let me see.
Yes, my lords. my
Petitioner,
lords,
madam.
is going to accommodate
Ah.
tomorrow.
She is
Abhiyan.
serial number one.
Serial number one, list number three.
Okay, she is praying for time till tomorrow.
Tomorrow, my lords.
Because yesterday also
Yes,
she argued
yes.
extensively.
Today it seems she is having some VC matters at 2:30.
Please, madam.
Yes, tomorrow.
Much obliged.
Next,
List number 2, serial number 13.
serial number?
13, my lord. I'm for respondent counsel. Matter, Narayan Swami. Matter is like to be settled, my lord, may be taken after 2 weeks.
Settlement ಎಲ್ಲ ನೀವು ಹೊರಗೆ ಮಾಡ್ಕೋಬೇಕು. I am not concerned about that.
2 weeks time.
You are for respondent number?
Respondents counsel, Narayan Swami.
Counsel for respondent number 2, praise for time. Next.
Please.
List one, page one, non-compliance of office objection for first time, serial number one, Nayak Ashok Kashinath.
Counsel for the petitioner is absent, no representation. List down.
Non-compliance for second time, serial number 2 to 10.
Lordship, serial number 2, I appear for the petitioner here in Lordship. We have no instructions from the party, but when we went to the trial court records, we got to know that the matter has been quashed before the trial court, Lordship.
Matter has been?
It has, the other accused had filed 2 writ petitions. As per the same, the matter is not, it's
So
been
now this
closed.
petition has become rendered
Infructuous.
infructuous. Learned counsel for the petitioner submits that the man is already rendered infructuous and same may be dismissed.
My lords, serial number
But-
5, my lords.
Submission is placed on record, petition is dismissed as the
Serial
same
number
is rendered infructuous. Huh?
Serial number 5.
5, yes.
Judgment has been pronounced, my lord. It has ended in acquittal dated 31/7/2023, my lord.
31/7/2023.
Yes, my lords. Serial number 6 also, my lords.
5, who is the petitioner?
Nanda Kumar BL.
There, the accused is acquitted.
Yes, my lords. All the accused are acquitted. CC 20776 of 2017.
I'll pass over, pass over beda. It's
Serial number.
Serial number
Done
6
it,
also.
additional SPP. Yeah. Submits that. The accused were tried before the trial court and they are acquitted with a judgment dated 31/7/2023. In view of the above, the petition is dismissed as the same
Serial
is
number
rendered
6, my lords.
infructuous. Next, serial number 6.
Ended in acquittal, my lords. 3/11/2023, my lords.
3/11/2023. That's a change. Acquitted, yes. Next.
Serial number 7 will be taken up on Monday, my lords, while verify whether my lords will continue with the proceedings or not, my lords. Otherwise, I'll withdraw it on Monday, my lords.
Counsel for the petitioner pays for time till Monday to make his submission.
Serial number 10, my lords. Charge sheet has been filed, my lords. CC 3186 of 2020.
PC number?
3186 of 2020. He has challenged FIR, my lords.
That is pass over. Then. ಉಳಿದಿದ್ದು, 1, 3, 4, 8, 9. Counsel for the petitioner is absent, no representation, list down.
Serial number 20, my lords. Charge sheet has been filed.
Serial number?
20, my lords. List 1. Charge sheet has been filed. CC number 24838 of 21.
24838
of 21.
Yes, third time, serial number 11.
Non-compliance for third time, serial number 11 to 16.
Counsel for the petitioner are absent, no representation. The petitions were filed during 2020. The office objections raised on the same are not
Serial number
one complied with, even though the same is listed for the third time. I do not find any reason to adjourn the matter. However, for final opportunity, list down. 11 and 14. ನಾನು ಹೇಳಿದ್ದು 11 and 14 ಗೆ. 12, 13, 15 and 16. ಅದಕ್ಕೆ Counsel for the petitioner is absent, no representation. Office objections are not being complied in spite of the matter being listed for the third time. The order sheet dated so and so reads as under. I do not find any reason to adjourn the matter. It appears petitioners are not petitioner or petitioners verified. Not interested in prosecuting the petition, hence petition dismissed.
Non-compliance for fourth time, serial number 17, Rajarajeshwari TS.
Counsel for the petitioner is absent, no representation. Petition is of the year 2020. Office objections are not complied, even though the matter is listed for the fourth time. The order sheet dated so and so reads as under. In spite of that, there is no progress in the matter. It appears the petitioner is not interested in prosecuting the petition. Petition is dismissed.
Serial number 18, Sri Malarao.
To same petition of the year 2021 dismissed. Next.
Serial number 19, NR Lokesh. Non-compliance for fifth time.
How many objections? Counsel for the petitioner is absent, no representation. How many objections are there? Petition was filed in the year 2020. Office has raised objections. The same are not complied with, even though the matter is listed for the fifth time. Previous date preliminary. It appears petitioner is not interested in prosecuting the petition, hence petition is dismissed. Next. 20, counsel for the petitioner is absent, no representation. The office objections are not complied with, even though the matter is listed for the fifth time. When additional SPP submits that the investigation is completed, charge sheet is already filed. The matter is pending in CC 24838 of 2021. Hence, petition stand dismissed. Stands dismissed. Yes.
These two, serial number 1, Raghavan P.
It will become infructuous, my lords.
Counsel for
This has been entered in acquittal, my lords, on 2nd of March 2022.
the petition. It's placed on record, petition is dismissed. Next.
Serial number 2, Mohammad Nazaruddin. Permission go, CF man.
Yes, challenge the cognizance order, my lords.
Here for second respondent was in 2.2 minutes.
Hmm.
The copy has to be served on the respondent. It has not been served minutes.
No, you have to take it.
That's
It is already 6 years have
It's
lapsed.
a direction minutes from this court. my lords.
ಇದ್ರೆ ತಗೊಳ್ಳಿ. ಏನಾಯ್ತು? 2, furnishing of PF petition copy. ಅದು, who is the respondent number 2 in other cases, connected matters?
I'm not appearing for that, my lord. Notice has yet to be raised.
Why?
Sorry.
You are Mr. Shan,
Please, my lord. I appear for respondent number 2 in 2.2, my lords.
ಎಲ್ಲದ್ರಲ್ಲೂ ಬೇರೆದ್ರಲ್ಲಿ. Same respondent number 2 ಇದ್ರೆ ಅವರು appear. ಬೇರೆ. ಮತ್ತೊಂದು ಇದೆಯಲ್ಲ, ಮೂರನೇದು. ಈ 6588 ಅಲ್ಲಿ ಯಾರು? ಇನ್ನೊಂದು ಹಸ್ಬೆಂಡ್ ಯಾರು? ಯಾವ್ದ್ರಲ್ಲಿ? You have to take notice for respondent number 2 in 4363.
Yes,
The
I'll
same
take
respondent,
I'll take instruction.
same respondent.
I'll take instructions, my lord.
Instructions ಏನಿಲ್ಲ. I am directing you to take notice.
Please.
ಅದಕ್ಕೆ instructions ಏನಿದೆ?
ಅಲ್ಲ, ಅದು
ಒಂದ್ರಲ್ಲಿ you are filing
ಅಲ್ಲ.
ವಕಾಲತ್, in other case instructions.
ಇಲ್ಲ, ಅದ್ ಒಂದ್ ಮಾತ್ರ ಅವ್ರಿಗೆ ಗೊತ್ತಾಯ್ತು.
Must be some reasoning.
My lords, my lords,
Yes.
I'm not denying. that.
Take note.
Please, my lord.
ಇದರಲ್ಲಿ 2.1 ನಲ್ಲಿ learned counsel Shri Prashant PN takes notice for respondent number 2 and takes to file wakalat. Next to 2 ನಲ್ಲಿ counsel for the petitioner is absent, no representation. PF for issuance of notice is not paid. ಯಾವಾಗಿಂದ ಕೊಟ್ಟಿಲ್ಲ ನೋಡಿ. Order dated 23/6/2024. The week's time is granted to pay PF for issuance of notice to respondent number More than a year has lapsed, but till today the PF is not paid. Hence petition against respondent number 2 is dismissed. Huh? Husband ಗೆ ಹಾಕಿ ಬೇಡ dismissed as per default. R2 dismissed. Next.
Figure number 3, Nagaraja S.
My lord, so this will become infructuous, my
And
lords.
appear.
They have filed the petition in the year 2020, my lords, and they have challenged the FIR, my lords.
Counsel for
And the charge
petitioner.
sheet has came to be registered on 39/2019, my lords,
Amendments accepted, petition is dismissed.
before filing of this petition, my lords.
Yes, dismissed. Ali, ನಿಮಿಷ. Serial number 2 ನಲ್ಲಿ R2 ಗೆ dismiss ಮಾಡ್ಬೇಕಾ full dismiss ಮಾಡ್ಬೇಕಾ? Government ಮಾತ್ರ ಇದೆಯಲ್ಲ. Without serving the notice and responding number 2, how can it be quashed? ಯಾರು? ಅವ್ರ ಹಸ್ಬೆಂಡ್ ಇರೋದು. ವೈಫಿಗೆ ನಾವು ಕಂಪಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಏನು ಕೊಟ್ಟಿಲ್ಲ. ವೀಕ್ಸ್ ಟೈಮ್ ಬೇಡ, ಅದರಲ್ಲಿ ಡಿಸ್ಮಿಸ್ಡ್ ಅಂತ ಬೇಡ. Not paid PF till today. I do not find any reason to adjourn the matter. It appears the petitioner is not interested in prosecuting the petition. So for final opportunity, let's start. It is made clear that if PF is not paid within next date of the hearing, the petition will have to be dismissed. Then.
Figure number 4, P. Prasanna Kumar.
The respondent, your lordship, in this
Hmm.
R1 is ACB, your lordship. I have filed objection stating for R1.
Hmm.
Now they have amended the cost title and made R3 as located, your lordship.
Hmm.
That's the only objection that is raised, your lordship, and will file wakalat for R3.
Ratification. R1 is,
R1 is ACB.
so that is not in existence now.
Please, lordship. They have made R3 as located.
So you are filing wakalat for respondent number 3.
3, please, lord.
Our ಹೆಸರು ತಗೊಳ್ಳಿ. So and so undertakes to file wakalat for respondent number 3.
Grateful.
It is stated that respondent number 1 is not in existence, hence petition against respondent number 1 is dismissed.
PB Patil. I'll file.
Office objections ಏನಿದು? This statement of objection you have to file on behalf of respondent number 3.
3, please, lordship.
Ah.
I'll change the cost title of statement of objection and
Counsel for
file.
respondent number 3 seeks permission to make necessary corrections in the statement of objection filed on behalf of respondent number 1 to treat it as well as the objections and filed on behalf of respondent number 3. He is permitted to do so. Yes.
Grateful.
Figure number 5, S.A. Ahmad, K. Narsegowda.
My lord, I appear for the respondent in this matter. The respondent has expired, my lord, and I have filed the death certificate. 138 proceedings na challenge mad hakidare swami. Complainant was the petitioner was the accused and respondent was the complainant.
No, respondent was the complainant.
Out.
So complainant died.
Yes, ma'am.
Now what is to be done? For it to
My
be
lord,
quashed
yeah,
into-
keeping all contentions open, the matter can be disposed of. This is what I would suggest, but
No, why are you not furnishing the details of the legal representatives?
my lord, they are not responding, the legal representatives.
Learned counsel for respondent submits that the respondent complainant, when he died,
27/9/23.
27/9/2023. She further submits that she is not receiving any instructions regarding the availability of legal representatives for the deceased respondent. and expresses her inability to furnish the information. Counsel for the petitioner is absent, no representation. Virtually, there are no respondent in the petition. To afford final opportunity for the counsel for the petitioner to make his submission list tomorrow, day after, Monday. Monday. Monday.
Serial number 6, Surendra Kumar N. P.S. Nageshayana.
Counsel for the petitioner is absent, no representation. For the order. PF for issuance of notice to respondent is not paid. Even the hand summons ordered by this court against respondent is not taken. It appears the petitioner or petitioners are not interested in prosecuting the petition. However, to afford final opportunity, final opportunity list on Monday, next Monday. Date note for next Monday into the meeting.
Serial number 7, Anand Mutalli.
R3 by.
Hmm?
R3 by me, they are formal part. I'm R3, my lord, Mahadev. I'm only a formal party, my lord. Allah, our Madhavak.
Counsel for the petitioner is absent. No, that pass over. I'll pass over, let him come.
Serial number 8, Satish K.
But I have filed a memo for withdrawal for this reason, my lord. The Anti-Corruption Bureau's constitution is under challenge, which is already, my lord, declared as unconstitutional. Therefore, my lord, I have sought for,
File the memo.
I have filed memo with liberty to file fresh petition, my lord, challenging, my lord, no other grounds are urged except the,
Your fault, sir. Again and again, liberty cannot be reserved.
my lord, the,
I will dismiss this without making any observation.
But,
That's all. I will not reserve any liberty.
my lord, I have,
No, no.
ಅಲ್ಲ ಲೋಕಾಯುಕ್ತ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಾಗತ್ತೆ.
Whatever it is, that is your lookout. No.
Lord, kindly appreciate.
4 years have lapsed. And again, you want to take 4 or 5 years.
No, Lord, I within weeks time, my lord, I'll file.
File memo, kodi. What is the memo he filed? Counsel for the petitioner filed a memo seeking permission to withdraw the petition. In the memo, he has sought for liberty to file fresh petition challenging the complaint and the FIR. I do not find any reason to reserve the liberty as petition dismissed. Next.
Lord, your lordship may, Lord, kindly,
No, sir, sorry.
but I'll be deprived of remedy, my lord.
Next.
In that event, my lord, I'll argue on merits, my lord. ಅಲ್ಲ ಲಿಬರ್ಟಿ ಕೇಳ್ತಾ ಇದೀನಿ, my lord, for filing fresh
I
petition.
have rejected your prayer.
But in that event, my lord, I'll withdraw my memo for withdrawal, my lord.
Then argue the matter today itself. Counsel
ಅಲ್ಲ
for the
lord,
petitioner
ಅಲ್ಲ lord,
submits that the memo.
ಒಂದೇ ಒಂದು ನಿಮಿಷ
Text point show.
lord,
Withdrawn,
ಅಲ್ಲ ನೋಡಿ
dismissed as withdrawn, pass over.
lord,
Yes.
may I request this, my lord?
Hmm.
My lord, your lordship may, my lord, permit me to make only one submission, my lord. I have challenged the constitution of his,
Understood that, sir.
lord, constitution.
Understood. You cannot reserve your liberty to raise fresh grounds one after the other.
Yeah, so may,
It is absolutely abuse of process of court.
My lord, I have,
Already 4 years have lapsed after filing this petition. Now you are seeking dismissal of the petition with liberty to file fresh, one more ground, another 4-5 years.
your lordship,
Mean,
your lordship may bear with me for 1 minute.
I understood, I perfectly understood your submissions.
Not 14/3/2016 order is already quashed. Not all these grounds are urged attacking those government orders, which is therefore, my lord, practical difficulty, my lord. Your lordship may appreciate.
Actually, your petition becomes infructuous in view of that order. You need not have to file a memo. I can straight away dismiss that. Address the argument, pass over. Next,
Allah, my lord,
next.
your lordship may say this, my lord.
Sir, you cannot dictate the code.
I am not dictating, my
Yes,
lord. I am
I
request.
perfectly understood your point.
I am
Please address the argument when your terms come. If you are ready, I will take up.
Hearing on
I
IA,
think, in terms of memo, my lord, your lordship, my lord,
What is that?
memo for withdrawal.
I will not reserve liberty. I will
Aye,
dismiss the petition as not pressed.
so.
Yes.
Without, my lord, may I request this, my lord, at least reject ಮಾಡಬೇಡಿ memo liberty na. Your lordship may dismiss simplicity, my lord.
Counsel for the petitioner filed a petition seeking when counsel for the petitioner submits that the petition may be dismissed as not pressed in view of the order passed by the division bench of this court with regard to the validity with regard to the constitution of ACB. Submission is accepted, petition is dismissed as not pressed. Next.
I'm sorry, my lord, for bothering the court, my lord, I'm sorry.
Next.
hearing on IA, serial number 9, K. Nagaraja.
My lord, I appear for the appellants, my lord. I have maintained successive applications seeking suspension of sentence in respect of accused number 1, my lord. Lord, earlier, application seeking suspension of sentence against A1 was rejected, my lord, for want of a record. Now, my lord, record has come, my lord. Now I am seeking suspension of sentence in respect of A1, my lord. The material, my lord, do not sustain the conviction. My lord, the case based on circumstantial evidence. Even the circumstances which called out and addressed by the trial court, my lord, do not point out the guilt of the accused.
Now, why your prayer was rejected, sir?
For want of a record, my lord, at that time,
Record.
trial court record, my lord.
Then why it was allowed in respect of appellant number 2?
But there was no material, my lord, so far as A2 is
If
concerned.
there was no trial court records, it would apply to appellant number 2 as well. Here the order says the prayer of accused number 1 is rejected.
Yes, my lord.
2 is allowed.
Yes,
How
my
could
lord.
it be?
At that time, Lord, the trial court record was not come, my lord.
Then
Therefore,
how, sir,
my lord, that is only, my lord, that.
if trial court record is not available, it will be applicable for all the accused, not to only one accused. It is rejected.
But
in favor of
accused
the-
number 2, my lord, he was on bail during the trial. But A1 was not bail, my lord. That is one more aspect. Then my lord, that in the judgment itself, there was.
Continuously in the judicial custody.
Yes, my lord, from 21/5/2022, my lord.
Yes.
But my lord, I cordially invite your lordship attention at page 144 of the judgment, my lord. The circumstances which
No, I will have to consider it on merits. Piecemeal Hegman.
leave to my lordship.
Please address the argument and get away with that. If you are having merits on your side,
Please, my lord.
please address the arguments on merits.
Yes, my lord. I leave it to your
It
lordship.
will be the easiest method.
Please, your lordship.
Yes. Third and counsel for the appellant on IA2 of 2024. It is found that the accused was in judicial custody when the matter is pending, when the matter was pending before the trial court. Taking into consideration this said fact, prayer for the suspension of sentence in favor of accused number 1 was rejected with an order dated 9/5/2024. Next one. Now the application IA2 of 2024 is filed seeking similar relief in favor of accused number 1. I do not find any reason to accept the contention. Counsel for the appellant submits that He is having strong grounds in support of the appeal, and he undertakes to address his arguments on merits. When will you argue?
Whenever your lordship.
No, the date. Please address the arguments on merits. 21st.
Please.
Preliminary hearing B group, serial number 10, Prasanna Kumar S.
ಇದೆಯಲ್ಲ ಎಸ್ ಇದು ಹೇಳಿದ್ರು ಅದನ್ನು ಡ್ರಾಫ್ಟ್ ಕೊಡಿ ಪೆನ್ನಲ್ಲಿ ಕೊಡ್ಬೇಡಿ 10 pass over.
Serial number 11, Suyoga Area.
For the petitioner, your lordship, request for a passover, your lordship, is held up in another court.
Then I may.
Wakalat is not filed. Petitioner, for petitioner, have you filed wakalat?
I'll verify the same, your lordship.
We called next week, my lord. I'll file objection. We filed wakalat last week, my lord.
Counsel for respondent, prays for time.
A date may be given, your lordship.
Next, yes.
Serial number 13, sorry, 12, Natraj Ballal, Prasanna VR.
The other day, my lord, I have mentioned that, my lord, the first respondent had also filed the criminal petition challenging the very same order in which, my lord, dishonorable court was pleased to dispose of the petition, confirming the order passed by the learned session judge, my lords. I have produced the copy of the order of dishonorable court in criminal petition 67 of 2018, white document number 2, my lords, along with the memo. Earlier, the petitioner, my lord, has challenged the very same order in criminal appeal 60/2018. Dishonorable court was pleased to permit him to convert the said appeal into criminal petition. He has not got it converted, but he filed a fresh writ petition. The present writ petition is one. On the other hand, the first respondent.
Now, what is the prayer in this case?
Please, annexure, yes, challenged, my lord, annexure E. Annexure E, page number 10 of the writ petition, lords. Wherefore, petition respectively prays that the Honorable Court pleased to issue writ of certiorari quash the order dated 9/11/2017 passed by the Principal District Judge Udupi in criminal revision petition 82/2016. That is annexure E, my lords.
Annexure E, page number.
Please, page number 102, my lords. 102. Criminal revision petition 82.
Order.
In this order, the learned sessions court, not while dismissing the revision petition of the first respondent, not directed that the custody of the articles belongs to the temple should be with the Assistant Commissioner of Hindu Religious Endowment and Charitable Institutions. Yes.
That was
But
rejected.
I have contended that I am entitled, being a president of the managing committee of the temple, whereas the petitioner hearing not contended that he is the trustee of the temple.
Now,
That-
now you have produced this
Yes.
criminal appeal, order in criminal appeal 60/2018.
60, my lord, the said order was challenged, my lords, by the petitioner in criminal appeal 60/2018. That was disposed of on 8th August 2019, permitting the petitioner to convert it into criminal petition, my lords, instead of criminal appeal. So he should have filed a criminal petition by getting it converted. Instead of that, my lord, he has presented the present writ petition. That too, my lords, after 3 years, my lords, 2 years. On the other hand, I being the petitioner before the learned session judge, my lord, challenged the very same order in criminal petition number 67 of 2018, that was, my lord, decided on 27/4/2018. This honorable court was pleased to hold that kindly see, my lords, page number 10 of the said
It
judgment.
was also dismissed.
Yes, my petition was dismissed, confirming the order of the learned session judge, holding that it is the assistant commissioner who should hold the custody of the articles of the temple, because it is the temple which is a notified institution and my term is expired.
Whether there is reference to the earlier petition, criminal appeal filed by.
No, my lords, the writ petition that they have not referred.
Then counsel for the petitioner is absent, no representation. Then counsel for respondent number,
I am the first respondent.
respondent number, filed the memo producing a copy of the order dated 8th August 2019, passed by this court in criminal appeal number 60 of 2018, and submitted that the very same petitioner had filed the said appeal before this court seeking similar relief for quashing Annexure E, the order passed by the learned principal sessions judge Cruelty in the criminal division petition number 82 of 2016. This court, by passing the order dated 8th August 2019, permitted the present petitioner to convert the appeal into criminal petition. And the appeal was going to be disposed of. However, no steps were taken to convert the appeal into criminal petition. Now, after lapse of instead, fresh writ petition is filed where there is no reference to the criminal appeal referred, and the order passed by this court as today order dated 8th August 2019. Then counsel respondent number 1 also produced copy of the order dated 27th April 2018, passed by the body.
May I make one submission, my lords? He has referred, my lords. He has referred, my lords. Kindly see page number 8 of the writ petition.
It is referred.
He has referred, my lords, but
No reference.
instead of,
There is no reference to the appeal, I don't think. Yes.
after 2 years, he has filed the present writ petition.
After 2 years, 2019 itself it is filed.
20, well,
20 na.
20.
When it is filed?
Lord, it was filed on 2 December, 2nd December 2019, but numbered in the year January 2020.
Filing December.
Yes, yes.
Criminal petition number 67 of 2018, dismissing a similar petition filed by the respondent herein under section 482 of CRPC, seeking to quash the very same order dated 9/11/2017, filed in criminal division petition 82 of 2016. Thus, he would submit that the petition is likely to be dismissed. Counsel for petitioner is absent, no representation. It appears the petitioner is not interested in prosecuting the petition in view of the above. However, to afford final opportunity is done. Monday, Tuesday. Yes, next time.
Please.
Serial number 13 Arjun, 14 for final hearing, Sharat Eltoda, Indumati. Okay, Harish.
Say for the petition.
Respondent number 2, my lord.
Yes.
482 petition. Petitioner is arraigned as accused number 1. Offences alleged are 420, 468 and 471 of IPC.
How many accused are there?
But totally there are 6 accused.
What about other accused?
They are not before this one.
What is the stage?
Stage, my lord's charge sheet is not filed.
Not yet filed. Interim order is there.
Interim order is there as against this petitioner.
Yes.
Lord, the allegation is this, my lords. Lord, the complainant second respondent claims to have purchased site bearing number 70 under registered sale deed dated 25/3/2006. From the second respondent complainant alleges that she has purchased site bearing number 17 under registered sale deed dated 25/3/2006 from one GPA holder Venkatesh, who is none other than the husband of the complainant. And this Venkatesh acted as the agent of the erstwhile landowners Pooja Bhairappa and Pooja Bailappa. Pooja Bailappa and Pooja Bhairappa are the erstwhile landowners.
From them, how the complainant came in possession.
Complainant, my lords, only says that she has purchased under the sale deed dated 25/3/2006, executed by the power of attorney holder of the erstwhile landowners.
Landowners are
Pooja Bailappa and Pooja Bhairappa.
Pooja Bailappa.
Bhairappa and Pooja Bhairappa.
Yes.
This is, and she says, one more person by named Venkatesh, also claiming to be the power of attorney of the erstwhile landowners, Pooja Bailappa and Pooja Bhairappa. They have executed sale deed dated 7/12/2018 in favor of the first petitioner, that is the, in favor of accused number 1.
In favor of the petitioner.
Yes, madam, in favor of the petitioner. And the complainant says that when she started to put up construction work for foundation in her property,
Yes.
these petitioner and others started interfering with the possession.
Yes.
And subsequently, there is another document dated 25/1/2019, which is the consent deed executed by legal heirs of Pooja Bailappa and Pooja Bhairappa in favor of this petition, confirming the sale of this petition.
Confirmation deed.
Yes, ma'am.
Dated
25/1/2019.
by LRs of the erstwhile owners.
Erstwhile owners.
Yes.
Notes. Admittedly, both the second respondent as well as the petitioners are claiming through GPA holders of the erstwhile landowners.
Yes.
And both the GPA holders' name is fortunately or unfortunately Venkatesh. And so far as my but they are different persons. That is available on record.
Yes.
And my GPA, my lords, I have produced at annexure H, page 68. This was of the year 15/6/1985. This document is not disputed even now in the complaint. E GPA now dispute madadre subsequent on dispute madre.
GPA deed dated
15/6/1985. And this GPA is accompanied by way of an affidavit. That is page 76, which reflects that a consideration of rupees 22,500 in those days, 1985, has been given to the original landowners.
What is the date of the GPA?
That date of GPA is silent in the complaint, so far as the second respondent is concerned. But I have able to trace it. It is dated 16/10/1986, madams. But in the complaint, it is not available.
1986.
86. E GPA 16/10/1986 GPA holder yaru alla. E complainant and husband. So husband and wife sale matter 2006. But the dispute is purely civil in nature.
This has to be adjudicated by the civil court, whether my GPA is genuine or whether his GPA is genuine. And along with their GPA, they are not giving any supportive documents to show that their GPA is coupled with interest, such as agreement to sale or affidavit. There is nothing. Whereas, before I purchase this very same site, your lordship may kindly appreciate that I have given a public notice, paper notice, at page 78 if your lordship turns. If your lordship turns to page 78. Your lordship, what? Left bottom corner, public notice. General public are hereby informed that my client, Shri H.M. Basavaraju, son of late Marigowda, intends to purchase the residential site property more fully described in the schedule here below from the owner, namely Venkatesh, son of Chinnappa, resident of Sulkatkatte, Vishwanidam Post, Bengaluru, and in furtherance of it, they have entered into
He is
agreement
described
of-
as owner, not as GPA holder.
in furtherance of which they have entered into agreement of sale dated 16/11/2018, registered as document number so and so. Any person claiming any rights, charges, mortgages whatsoever, understand along with support may raise their objections. Ultimately, this is what, my lords, if you had intention of defeating or creating any third party rights, paper publication would not be given. That is the reason I am producing this document. ಮೋಸ ಮಾಡೋ ಉದ್ದೇಶ ಇತ್ತು ಅಂತಂದ್ರೆ ಶಾಮೀಲಾಗಿ, I will not invite objections from the general public if at all someone had interest. Then, my lords, my CLD, if your lordship sees, 7/12/2018, which is at page number 29, that is for a valuable consideration of rupees 30 lakhs. And the transfer of amount under my sale deed is through online check. That your lordship will get at page 33. The online transaction of the check amount.
Yes.
If at all I had the intention of cheating, I would not have transferred this amount. Then your lordship may kindly come to page 39.
Yes.
But as there were two GPA holders as contended by the second respondent, I had to call upon the erstwhile landowners to execute this confirmation deed. This is a registered document. This is only bettering my title. This is not creation of a document amounting to any fraud or forgery. No, the signature of the second respondent is not forged here. Or I have no intention to deceive right from the inception, which is the requirement under section 420. And I have got Kata mutated to my name. And in fact, I had filed a KVA anticipating that they may file a civil suit at page 79, my lords. This KVA is dated 31/12/2018.
No civil suit is filed.
Lords?
No civil suit is filed.
Civil suit is filed by the erstwhile landowners against me seeking for partition. After the suit was filed, they executed this confirmation deed. Therefore, they deleted me from the array of parties. But after that, this person was there. He was there as defendant number 19. Respondent number 2 was there as defendant number 19. He had filed a counterclaim against me for setting aside this sale deed. My lords, I was deleted. I was unaware of that. That suit is OS 9223 of 2018. 9223 of 2018.
223 of 19.
Yes. Now the civil court has decreed the counterclaim filed by defendant number 19 in my lords?
Against whom?
Against me in my absence. It has set aside my sale deed. But I have not contested. Therefore, I filed RFA number 1689 of 2024 and brought to the notice of this honorable court that the counterclaim being decreed is in my absence without my knowledge. And the honorable high court, noting all this, has granted an interim order. RFA 1689 of 2024, my lords. Please get that interim order in RFA
1689 now.
2024. It is not here. From the net website you have to get. 1689 of 2024. But the dispute is no, my lords. Therefore, there is no, till date, there is no adjudication as to the.
What is the judgment in the counterclaim? How it was decreed?
Well, let's
What's the
stop.
decree?
In the counterclaim, the defendant number, the second respondent was placed as defendant number 19. Defendant number 19 sought for a counterclaim, they saying that the CLD dated 7/12/2018 executed in favor of this petitioner is null and void. But by that time, this counterclaim got prosecuted, I was deleted from the array of parties. I was unaware of this. In my absence, the trial court said, because there is no opposition, plaintiff has not led this evidence, and the defendant number 17 has not.
Of the judgment with you?
My lords, I will just I'll just produce. And therefore, my lords, after based on that decree, after so many years in recently 2024, they tried to change the kata, my lords. At that point of time, I got intimated about this judgment because I was deleted. I did not defend the suit at all.
Yes.
Then I filed RFA number 1689 of 2024. And in RFA, I submitted all these things, factors. Then this honorable court appreciated that and granted an interim order of status quo regarding possession as well as in all respects.
Yes.
My lords, therefore, my lords, on merits, till date, there is no adjudication of the fact whether his GPA is genuine or my GPA is genuine. On merits, there is no adjudication. It's only on the fact that I remained absent in the suit. And my lords, the caveat, my lords, which I filed is dated 31/12/2018 as against the second respondent. Complaint is lodged on 13/3/2019, subsequent to filing of the KVL. Let's see if I have to cite the judgment. The dispute is purely civil in nature. And my lords, registration of FIR, there is a delay in filing the complaint as well as in registration of the FIR. Complaint is dated 1/3/2019. FIR is registered on 13/3/2019. There is 13 days delay in registration of FIR. And your lordship will kindly appreciate that signature of this second respondent has never been forged anywhere. It is only who the erstwhile landowners executed GPA, whether in favor of the complainant's husband or in favor of another Venkatesh, who is my vendor.
Where is the relevant portion in this?
My lords.
Who are the other accused? Who is accused number 2? Who are the other accused?
Accused are the erstwhile legal heirs who executed the consent deed.
Accused number 2 to 6.
Accused number 2 is the GP holder.
3 to 6.
RFA.
3 to 6 are the
Accused number 2 is the GPA holder. Accused number 3, 4, 5, and 6 are the LRs of Puja Bailappa and Puja Bailappa who have executed the Oppige Patra at Annexure D. Print. I want the print. You go to the, this thing and get it. Court judgment. Lots. And so as to attract 420 my lords, there must be intention to deceive.
ಇದು ಯಾಕೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
ಅದು ಸಿವಿಲ್ ಅಂತ ಹೇಳಿ.
Where is the relevant portion?
Para 27 my lords. I'm sorry, para 34.
That is a breach of contract. It is
After
not
that,
a
lords,
case
they-
of breach of contract.
There, my lords, in the right side, it is true that a given set of facts may be civil wrong as well as criminal offense and only because civil, but itself cannot be a ground to quash it. The real test is whether the allegation disclose the criminal offense of cheating or not. There is nothing to show that at the very inception, there was inception on behalf of the accused to cheat. In similar lines, my lords,
Yes.
here again, same, my lords, so far as cheating, the intention to deceive must be there from the inception.
Where is
And
it?
that is there at para 12 minutes.
That is a definition.
Deception is what the court says.
Definition of the cheating is extracted there. So first, when you rely on some decision, you should be firm
Please.
why you are relying on
Please,
that.
please,
After citing the judgment, you cannot search for the.
I'm sorry. my lords.
Then what was- That's
it.
all. Yes.
The dispute is civil in nature is basically.
My lord, the respondent number two's source of title is like that. On 6/10/1986, one Bhairappa and Pooja Bhairappa.
All the fact
they-
he has already discussed.
No, my source of title. R2's source of title. On 6/1/1986, GPA coupled with affidavit was executed in favor of C. Venkatesh. 6/10/1986,
Yes. In favor of your husband,
C. Venkatesh, my lord.
your husband.
Yes.
Ah.
Later, on 25/3/2006,
Both the
Said it-
GPS are not the registered GPS.
unregistered GPS.
Ah.
GPA executed coupled with affidavit, your honor. Possession was also handed over. Amount, consideration amount was also paid,
What do you say regarding his submission that it is a purely a civil dispute?
but my lord, kindly turn to page number 18, my lord. Complaint of the respondent number 2. Second paragraph. ಅದಾಗಿ ಹೀಗಿರುವ ಸಂದರ್ಭದಲ್ಲಿ ಎಂ ಬಸವರಾಜು, that is the petitioner, my lord, ದಿವಂಗತ ಮಣಿಗೌಡರ ಮಗ, ವಾಸ ನಂಬರ್ 30/1, 2ನೇ ಮುಖ್ಯ ರಸ್ತೆ, ನಿಸರ್ಗ ಸ್ಕೂಲಿನ ಬಳಿ, ಹೆಗ್ಗನಹಳ್ಳಿ, ವಿಶ್ವ ನೀಡಂ ಅಂಚೆ, ಬೆಂಗಳೂರು 91. ಇವರು ಯಾರೋ ಇನ್ನೊಬ್ಬ ವ್ಯಕ್ತಿಯೊಂದಿಗೆ ಸಾಮೀಲಾಗಿಕೊಂಡು ಸದರಿ ಇನ್ನೊಬ್ಬ ವ್ಯಕ್ತಿಯ ಹೆಸರನ್ನು ವೆಂಕಟೇಶ್ ಎಂದು ತೋರಿಸಿ ಸದರಿ ವೆಂಕಟೇಶ್ವರವರು ಅಧಿಕಾರ ಪತ್ರ ಹೊಂದಿದವರೆಂದು ಮೋಸದಿಂದ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ ದಿನಾಂಕ 7/12/2018 ಶೆಡ್ಯೂಲ್ ಸ್ವತ್ತಿನ ಬಗ್ಗೆ ಕ್ರಾಯಪತ್ರ ಎಂದು ಹೇಳುವ ದಾಸವೇಜನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಸದರಿ ಕ್ರಾಯಪತ್ರ ದಾಸವೇಜು ಡ್ಯಾಶ್ ಅಂತ. It's a specific allegation that impersonation and creation of documents.
Which is the document created? GPA deed?
Sale deed.
You are not disputing the GPA deed.
I'm also disputing that
Where is
GPA.
it? Where you have stated?
ಇಲ್ಲಿ ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸದರಿ ವೆಂಕಟೇಶ್ವರ ಅವರು ಅಧಿಕಾರ ಪತ್ರ ಹೊಂದಿದವರೆಂದು ಮೋಸದಿಂದ ದಾಖಲೆಗಳನ್ನು ಸೃಷ್ಟಿಸಿ
ಎಲ್ಲಿದೆ?
ಅದೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಲ್ಲಿ 5ನೇ ಲೈನ್ ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
There is no reference to the date 6/10/1986.
1985, my lords, my GPA.
No, his GPA.
Date was not
GPA is not
date was
mentioned
not
at all.
mentioned. Date was
GPA they have not
done, but
mentioned.
this specific
Per GPA is 15/6/85.
Yes,
Is there any reference to that?
that is also not there here in the complaint.
There is reference to GPA, but not the date.
not referred. GPA not referred. Date not referred, my lord.
Hmm.
The allegations
ಅಧಿಕಾರ
are
ಪತ್ರ
specific.
ಹೊಂದಿದವರೆಂದು
You have not initiated any civil action.
No, I am the first purchaser, my lord.
Maybe you have to safeguard your interest.
Yes, my lord.
Why you have not?
In the partition suit, I contested and
The partition suit, you are the defendant.
yeah, depend number 19 and
Counterclaim.
yeah, I filed counter claim and
Yeah,
suit was
very
declared.
ಯಾ ಅನ್ನುವಂಥದ್ದು ಇಲ್ಲ.
Sorry,
ಸ್ಟೂಡೆಂಟ್ಸ್ ರೀತಿನಲ್ಲಿ ಇಲ್ಲಿ ಬಂದು ಹೇಳ್ಬೇಡಿ ದಯವಿಟ್ಟು.
sorry, madam.
Yes. How can that counterclaim be decreed in his absence?
No, they deleted his name. They colluding with the original owners.
Opposed deletion of the name.
I opposed, my lord.
Where is it? Do you have the
Uh,
order sheet with you?
I filed objection to that.
How can the
deletion.
counterclaim be decreed in his absence?
fresh notice at least ought to have been issued. Get this, ma.
Yes, do you have the judgment?
No, sir, yeah.
ಇಬ್ರ ಹತ್ರನೋ ಇಲ್ಲ ಏನೋ ಒಂದು ಹೇಳೋದು.
Sorry.
Yes, anything?
My lord, in the only FIR was registered, my lord, investigation was stayed. In the complaint, my lord, there is a specific allegation that the documents were created. And the complainant was in possession of the property. She has paid the tax also with respect of the.
No, Khata stands in the name of the petitioner.
Yes.
But the tax
It
paid
is his
is.
contention that a paper publication was issued before purchase
Vikata stands in the name of the respondent number 2, man.
and a public notice was issued before purchase.
But it was not in the knowledge of
Maybe,
the.
but he has produced it. If, as rightly put, say, if there was an intention, he would not have published it. Prima facie, there is no intention.
He has not filed any suit.
Hmm?
He has not filed any suit.
Because he is having this.
He has the knowledge.
Confirmation deed, everything is in his favor.
The original owners also given me the confirmation date. They also executed the confirmation in favor of respondent number 2.
I think it is the original owners who have cheated you,
Yes,
both of you.
For them, they have to file a complaint against,
Should proceed against them.
they have to file complaint against the original
Unfortunately,
owners.
both of you are inter se dispute, quarreling just.
But holding this sale deed, they are.
Because he is
there
the
is-
beneficiary also, my lord.
Huh?
Because the petitioner is the beneficiary of that sale deed also. So how crime is registered against him also. Sale deed was executed by the GPA holder, my lord. They say that there is an impersonation of that GPA holder. The complaint.
Complaint, there is no specific reference to GPA deed dated 15/6/85.
That
What
documents
allegations
were
are made?
created showing some other person.
ಹೇಳಲೇಬೇಕು.
That is the allegation.
That is to invoke 420, they have stated so. But admittedly, there is a suit for partition filed by the legal representatives wherein both were parties. Later,
He was
dealing
dealing.
was dropped by executing the registered confirmation deed. If at all, both of you should proceed against the original owner if she is not there, against the legal representatives. How the 420 against the petitioner will. But this petition is only by accused number 1. Of course, other accused, they are the legal representatives. Let them contest it. But not against the petitioner. Yes. Go ahead. Petitioner being accused number one in crime number 173 of 2019 on the of Rajgopal Nagar Police Station, registered for the offence punishable under section 120, 419, 420, 468, 465, 471, 474, 467 of IPC, is seeking to quash the criminal proceedings initiated against him in the interest of justice. Heard so and so. The counsel for the petitioner contended that the petitioner is therein as accused number one in the above criminal proceedings initiated on the basis of the first information lodged by respondent number two for the aforesaid offences. The counsel submits that respondent number two said to have purchased site number 17 under the registered sale deed dated 25/3/2006 from the general power of attorney holder of the original owners. General power of attorney holder by name Sri Venkatesh, representing the original owner. But in fact, the said Venkatesh is none other than the husband of respondent number two. And counsel for the said. In fact, the original owner had executed PPA deed dated 15/6/1985. 1985 you were reading.
Yes, my lords.
1985. Along with the affidavit. And the said GPA is coupled.
I have
with
produced the
interest-
GPM, Annexure H.
Coupled with interest. As a petitioner had paid rupees 22,000 in favor of the owner. Pursuant to. In fact, had paid that. The GPA holder had paid rupees 22,000 in favor of the owners. Pursuant to the GPA deed dated 15/6/1985. The attorney had executed the registered sale deed dated 7/12/2018 in respect of the same site number 17 for a valuable consideration of rupees 30 lakhs, which was paid. Counsel also states that the paper publication was published in the daily newspaper, inviting the objections from the general public for purchasing the site. But no objections were received, and thereafter, petition number one purchased the property under the sale deed. Then the counsel submits that the conduct of the petitioner discloses that he had no intention to commit cheating, as otherwise he would not have published the public notice before purchase of the property. And he would not have paid the consideration amount through check. And counsel submitted that. And then the legal representatives of the original owners have filed two quotes 9223 of 2009, wherein the petitioner and respondent number two were defendants. During the pendency of the suit, legal representatives
One page, where is that page?
owners executed a registered confirmation deed dated 25/1/2019, confirming execution of the sale deed dated 25/3/2006. Confirming the sale deed dated 7/12/2018. Later, petition number one, name of petition number one was deleted from the suit. However, respondent number two has filed the counterclaim in the said suit, The effect that the sale deed executed in favor of the petitioner is null and void. The said suit was, the said counterclaim was came to be decreed in the absence of the petitioner on record. And the said judgment is challenged before this court. by
Got the copy
filing
of the judgment.
RFA number 1689 of 2024. The same is pending consideration. Therefore, the learned counsel submits that the dispute between the parties is purely of civil nature. And the facts and circumstances of the case discloses that there was no intention on part of the petitioner to commit cheating at the inception, which is the basic requirement of law to invoke section 420 of IPC. He has placed reliance on the decision of the Honorable Tax Court in Vijay Kumar Ghai and others versus State of West Bengal and others. AAR online 2022 SC 380 in support of his contention. And therefore he prays for allowing the petition. Per contra, and counsel for respondent number 2 opposing the petition submitted there. Respondent number 2 is the original purchaser of the site in question under the registered sale deed dated 25/3/2006 from the general power of attorney holder of the original owners. It is thereafter this petitioner managed to get the GPA in the name of one Venkatesh and to get the sale deed executed through him. Because the first GPA holder was also named Venkatesh. And with the same was with an intention to commit cheating. Next paragraph. When counsel submits that the suit OS 9-2 suit paragraph. The counterclaim in OS 9223 of 2019 is declared. And therefore, attention of respondent number 2 is further strengthened. Under such circumstances, the petition against petition is liable to be dismissed. Accordingly, place for dismissal of the petition. Learned LCGP, on the other hand, submitted that except filing, except registering the FIR, no further development, there is no further investigation in the matter, since there was the interim stay granted by this court. However, she prays for passing appropriate orders on the petition. Review the materials under point for consideration. My answer to the point in the affirmative for the following reasons. The admitted facts of the case are that respondent number 2 purchased site number 17 through the GPA holder Venkatesh, who incidentally is her husband, under the sale deed dated 25/3/2006. It is stated that the original owners have executed the GPA in favor of her husband on 6/10/1986. It is the contention of the petition that the original owners have executed the GPA in favor of another Venkatesh on 15/6/1985 after accepting an amount of rupees 22,000, and therefore the said GPA is coupled with interest. And the GPA holder had executed the registered sale deed in favor of the petitioner, on 7/12/2018. After accepting the valuable consideration of rupees 30 lakhs paid through checks. Copies of the sale deed are produced for perusal of the court. Next one. The other undisputed facts of the case is that the legal representatives of the original owners filed the suit was 9/223 of 2019, seeking partition and separate possession, including the site bearing number 17. Petitioner and respondent number 2 are the defendants in this action. Admittedly, the the name of the petitioner was came to be deleted after the legal representatives of the original owner executed registered confirmation deed confirming execution of the sale deed dated 7/12/2018. However, it is stated that respondent number 2, being one of the defendant in the said suit, filed the counterclaim. And strangely, the said counterclaims to have been decreed in the absence of the petitioner. It is stated that RFA 1689 of 2024 is pending consideration before this court, wherein an interim order of stay is granted for the decree passed by the trial court.
Your mobile disorder.
With all these admitted facts and circumstances, then counsel for the petitioner has also produced exhibit Annexure J, copy of the paper publication to contend that before proceeding to get the sale deed dated 7/12/2018 executed to the GPA holder, a public notice was issued in the Kannada daily newspaper inviting the general public to raise any objection with regard to the scheduled property. I do find considerable force in the contention taken by the learned counsel for the petitioner, that if the petitioner was having the guilty and he had an intention to cheat, this public notice would not have been given in the newspaper. Paper. When counsel for the petitioner placed reliance on the decision of the apex court in rejection of the High Supra, wherein the Honorable Apex Court, referring to its earlier decision in Visa Holdings Private Limited and another versus State of Kerala and others, 2015 Part 8 SCC 293, extracted para 13, held that the real test is whether the allegations in the complaint disclose a criminal offense of cheating or not. On facts, it is held that there is nothing to show that at the very inception, there was any intention on behalf of the accused to cheat, which is a condition precedent for to constitute an offense under section 420 BC. The materials on record placed before the court, if considered in the light of the tribal contentions and the admitted facts, I am of the opinion that there are no prima facie materials to contend that there was an intention at the inception, the part of the petitioner to commit cheating. Of course, it is for the parties to settle their disputes for the civil court by leading evidence in support of their contention. But I do not find any prima facie material to attract the penal provisions against the petitioner. Hence, I am of opinion that the criminal proceedings initiated against the petitioner is liable to be quashed as otherwise it would amount to abuse of process of law. The delay of this of the point in the affirmative and proceed past the point. Petition is allowed. Criminal proceedings is required initiated against the petitioner is required.
Serial number 15, Makappa, HP Leeladhar.
petitioner. Appellant.
Complainant's appeal.
What is the offense?
138 euros.
Good. Tell me the facts.
Fact, your worship, is the case of the appellant, who is the complainant, claims to have lent a loan of rupees 10 lakhs undated in cash.
When?
He has not stated anything about that aspect.
Then
According to him, he has not paid the amount, subsequently has issued a check bearing number 315595 dated 17/5/2006.
17/5/2006.
Check number 315595
Yes.
dated 17/5/2006. And the check claims to have presented return insufficient of fund. Legal notice issued on 24/6/2006.
Yes.
Notice return received on 25/6/2005.
Served on
Yes,
the
sir.
case.
Yes, sir.
No reply.
No. And thereafter, your lordship,
What is your defense?
defense, your lordship, one is, I have not at all issued the check in question. And the check has been given to one Vishwanath, who are running chit funds. And he has handed over the said check to the complainant. There are other two cases also pending in criminal appeal number 326/2014, 328/2000.
326.
326/2014, 328/2014. Same complainant.
Criminal case.
Criminal appeal, your Honor. Both criminal appeal.
That is filed by
138.
same complaint.
Same complainant, same.
Against?
Against the different persons. Filed by the complainant himself. Are pending before this honor.
Those complaints were also came to be dismissed.
Yes. ಇದು ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಬರ್ತಾ ಇದ್ದು, ಬಟ್ ಇದು ಇವತ್ತೇನೋ ಇದು ಇವತ್ತು ಬೇರೆ ಬಂದಿದೆ. And further, the complainant has filed another two cases against husband of the complainant, the respondent hearing, and also her mother. The complaint filed another two cases. CC number 21647/2016, 21647/2006. And another case number CC 21644/2006. Against mother and wife.
Mother and wife of?
Yes, yours.
Mother devdu, wife devdu.
Respectively 21647/2006 against mother.
Mother of respondent.
Yes, your. And another case filed. CC number 21644/2006.
Against the wife.
Yes, sir.
What is the offense?
138.
What happened to those?
Those two cases also dismissed.
What is the finding of the trial court?
Findings of the trial court on two counts on your lordship is, that is internal page 3 in the impugned judgment. Whether the complainant proves that the accused has committed an offence punishable under 138 of the NI Act. The second, your lordship, whether the accused has proved check in question Exhibit 1 was not issued by her in favor of the complaint towards the legally enforceable debt. The first issue, your lordship, whether the accused proves that the check in question was not issued by her in favor of the complainant towards the enforceable debt is affirmative. Then point number 2, whether the complainant proves that the accused has committed an offence under 138 negative. It starts from internal page 4. Finding, reasoning.
Accused is examined as DW1.
Yes, yours. Complainant examined himself as PW1 and marked exhibit P1 to.
Wait. Then the counsel for the appellant is absent, no representation. Or should better. The appellant being the complainant in CC 14485 of 05 has filed the private complaint alleging commission of the offence punishable under section 138 of NI against the respondent. And appellant being the complainant filed the private complaint in PCR 10781 of 2006 against the respondent complainant alleging commission of the offence punishable under section 138 of NI. The learned magistrate took cognizance of the offence and registered CC number 21644 of 06. Sorry. Private complaint number B. The private complaint against the respondent number B. Took cognizance of the offence and registered CC number 14485 of 05. Command the accused. The appellant being the complainant in the CC 14485 of 2005 and the file of 16th additional CMM Bengaluru is impugning the judgment dated 6th October 2006, acquitting the accused for the offence punishable under section 138 of NI. These are referred to as per. The facts of the case are that the complainant has filed the private complaint against the accused alleging commission of the offence punishable under section 138 of NI. It is the contention of the complaint that we have lent an amount of ₹10 lakh in cash to the accused during February 2006 towards repayment of the said loan amount. The accused had issued a check as exhibit P2 in 2006. When the check was presented for encashment, same was honored as there was insufficient funds in the account of the accused. Legal notice as per exhibit P5 was issued and the same was served on the appellant, served on the accused. In spite of that, the accused had not repaid the check amount and thereby he has committed the offence punishable under section 138 of NI. Accordingly, he prayed the trial court to take cognizance of the offence. Trial court took cognizance of the offence and summoned the accused The accused has denied the charges leveled against him for the aforesaid offense and claims to be tried. The complainant examined himself as PW1, court marked exhibit B1 to 12 in support of his contention. The accused has denied all the incriminating materials available and examined himself as DW1. Court marked exhibit B1 to 8 in support of his defense. The trial court, after taking into consideration all these materials on record, formed an opinion that the complainant has not proved the lending of the amount to the accused. Also, existence of legally the accused. The impugned judgment being reviewed by the same. The counsel for the appellant is absent or representation. The order sheet dated 19/2/2024 reads as under. Deposit of the cost not before the due date. And again, the counsel is absent. Circumstances, the argument of the learned counsel for the appellant is taken as nil. Or learned counsel for the respondent. There is materials, including the trial court reports. Point for consideration, my answer to the point in the negative for the following reasons. Is the specific contention of the complainant that he had lent huge amount of rupees 10 lakh in cash to the accused. During February 2006. It is the contention of the complainant that in discharge of this exhibit, the accused had issued a check as per exhibit PT. So issuance of legal notice is not disputed by the respondent. On the other hand, it submits that exhibit P9 is the reply given by the accused at the initial stage. Whether any reply is issued?
You, what happened? Your notice has not been served. Notice has not been served. Exhibit P4, that the exhibit P6 is the acknowledgement. And the exhibit P1 is the check to your lordship. You see, signature can be seen that this check is not, notice has not been served.
It should be. Is disputed by the learned counsel for the respondent. And he further submits that exhibit, the signature found on exhibit P6, the postal acknowledgement is not that of the accused. The accused the complainant examined himself as PW1 by filing the affidavit in lieu of examination in jail. During cross-examination, witness denied the assertion that he never lent any amount to the accused, and he was not having financial capacity to lend such huge amount. The complainant admitted that he had lent lakhs of rupees to various persons. And he admits that he has filed CC number 21647 of 2006 as the mother of the respondent, and CC number 21644 of 06 as the wife of the respondent, alleging commission of the offence under section 138 of. It is also contended by the learned counsel to the respondent that the complainant has filed similar complaint against two different persons, and all the four complaints came to be dismissed. This goes to show that the complainant is in the habit of filing false complaint without any basis.
Para number 15, it has been discussed about the check in question. Para number 15, the improved judgment. That has been discussed.
During cross-examination, PW1 categorically stated that he had not inquired about the financial condition of the accused, nor he had inquired about the husband of the accused. He had lent huge amount of rupees 10 lakh by cash without obtaining any document and without inquiring as to whether the accused will be in position to repay the check amount.
Para number 19, service of notice ಬಗ್ಗೆ discuss ಮಾಡ್ತಾರೆ sir.
Yes. What is stated, service of notice?
Yes, notice ನಮ್ಗೆ ಸಿಕ್ಕಿಲ್ಲ, ಅದು wrong address
That
ಹಾಕಿ.
is your defense.
Pardon?
That is your defense.
Yes, and the court also come to the conclusion, when the signature has been disputed, postman has not been examined. That is internal page 19.
The conduct of the accused and his contention regarding lending of the amount do not get support in the light of the defense taken by the accused. At the first instance, the accused is disputing service of notice, service of legal notice. The signature of the accused found on the acknowledgement, when compared with the admitted signatures, they do not appear to be similar. Moreover, the accused has stepped into the witness box and have taken a specific defense that she had not given the check exhibit P2 to the complainant, but on the other hand, she had issued the said blank check to one Vishwanath alias Vishwas as a security, as he was running a chip business. During cross-examination, nothing has been elicited from the accused to disbelieve her version. From these materials and records, I am of the opinion that even if the presumption under section 139 is to be drawn in favor of the complainant, I am of the opinion that the complainant has failed to probabilize his contention regarding lending of the amount and issuance of the check by the accused towards discharge of the legally requireable. And under such circumstances, the presumption under section 139 of NMA did not arise in favor of the complainant. Next, I do not find any. I have gone through the impugn judgment of acquittal passed by the trial court. I do not find any illegality or perversity in this regard. This is the point in the negative and proceed past the follow. Please dismissed.
Machu.
Number 16, K.S. Prasad, Santosh Kumar MB.
It's a divergent finding, my lord, it's a complaint appeal. Trial court convicted the respondent. And the first appellate,
Offense 13, 713 1B.
no, my lord, it's a 498A, 3 and 4 of DP Act. Trial court, my lord, convicted the respondent husband for the offense punishable under section 498A, 3 and 4 of DP Act. It's a fine of 1,14,000. Against that order, my lord, in trial court, my lord, both parents and the husband made us accused, but convicted only accused number 1. As against that order, my lord, they filed an appeal. Appeal, my lord, reverse the order and
For one.
accused number 1, husband, acquitted the respondent.
Appeal was allowed.
Yes, ma'am.
Now complainant appeal.
Pardon?
Complainant is before this court.
Yes, ma'am. Main statement, my lord, is in trial court, my lord, rightly considered the evidence of PW1, PW4, 5.
Who is PW1?
PW1 is complainant.
Then PW2.
PW2 is a major witness, recovery punch major witness. PW3 also,
What was recovered?
it's photos and other articles. Like marriage, it is not in dispute, my lord, it's a marriage and all, it's not in dispute.
Then why all those marriage, mother and all?
PW4,
Who is 3?
3 also major witness.
4 is?
4 is the father of the appellant.
Then?
And 5 is brother. 6 to 9, my lord, turned hostile.
They are the? Who are they?
As a recovery punch, my lord,
What was recovered? Only photos and marriage invitation.
in other articles, my lord,
When marriage is admitted, why are those witnesses?
they recorded.
All are Mahazar witnesses. How many Mahazars?
Two, more than 8, 3 major.
All recovery.
All recovery. PW9, my lord, is a is not a major witness, but depose about the dowry amount, but it turned hostile. PW 10 is a mother. PW 11, my lord, relative of the appellant. It also speaks about dowry. And the independent witness, my lord, he's a PW 11, 12, is a relative of the accused. He stated before the court, my lord, regarding the dowry.
How many witnesses you have examined?
20
more-
witnesses.
20 witnesses.
20,
20 witnesses.
fit case for dismissal,
Pardon?
fit case for dismissal.
No, it's a merits is there for 498 days, merits is there.
Why sir, 21 witnesses?
Because only I have to prove that, my lord, 498A, my lord, there's a demand and demand of dowry. And all witnesses, my lord, stated clear about the ಮಾತುಕತೆ ಆಗಿತ್ತು, ಅವತ್ತಿನ ದಿವಸ ಇಷ್ಟು ಕೊಡ್ಬೇಕಾಗಿತ್ತು. And the most important PW 17,
Date of marriage,
3/2 to 2002,
4/7,
2002. One female kid is there.
date of complaint,
14 to 2007. Most important witness is PW 17.
who is 13?
13 also, my lord, the marriage, ಇದು dowry ಮಾತುಕತೆ ಆಗಿತ್ತು. 14 also same.
Depending on the evidence of which witness? PW?
PW 1,
PW 12 to 15 minutes. They attend the marriage minutes and states about the demand of dowry minutes.
PW 1, 4, 5, 10. And the 17 is most important doctor evidence for harassment is
Doctor, what he speaks,
PW 17.
what he says.
Injury on the same day, my lord, their statement was recorded in the hospital. Page number PW 17, Doctor Ratnama. And also, my lord, the respondent also examined the witness, 5 witnesses. PW 17, one moment, can you see? Before that, when they harassed the complainant and assaulted, immediately, my lord, she came to the house of his brother. And immediately they admitted to hospital.
Yes.
Doctor evidence, my lord. 2000 ಮೆಗ್ಗನ ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹಿರಿಯ ಕಣ್ಣಿನ ಶಾಸ್ತ್ರ ಚಿಕಿತ್ಸಕರಾಗಿದ್ದು ಈಗ ಸಹ ಪ್ರಾಧ್ಯಾಪಕರಾಗಿ ಕೆಲಸ
ಆಯ್ತು,
ಮಾಡ್ತಾರೆ.
ಅದೆಲ್ಲ ಆಯ್ತು. Exhibit P11 is the wound certificate.
Yes, ma'am.
Is cross examination.
Yes, ma'am. Exhibit P11.
Cross examination.
ನಾವು ಹಲ್ಲೆಗಳಾದ ಗಾಯಗಳಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಪ್ರತ್ಯೇಕ ನೋಂದಣಿ ಪುಸ್ತಕ ನಮೂದು ಮಾಡುತ್ತೇವೆ ಎಂದು ಸರಿ. ಸದರಿ ಪುಸ್ತಕವನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರು ಮಾಡಿಲ್ಲ. ನಿಶಾನೆ P11ರಲ್ಲಿ ಹಲ್ಲೆ ಮಾಡಲು ಕೈ ಹಾಗೂ ಕಾಲುಗಳನ್ನು ಬಳಸಿದ್ದಾರೆ ಎಂದು ಮತ್ತು ಕೋಲುಗಳನ್ನು ಉಪಯೋಗಿಸಿರುವುದಾಗಿ ನಮೂದಿಸಿರುತ್ತಾರೆ. ನಿಶಾನೆ P11ರಲ್ಲಿ ಕಾಣಿಸಿರುವ ಗಾಯ 1 ವಾರದಷ್ಟು ಹಳೆಯದ್ದು, ಎದೆ ಸೋನ್ಸು, ಗದ್ದೆ ಕೆಲಸ ಮಾಡಿದರೆ ಬಾವು ಬರುತ್ತೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಕೈ ಕಾಲ ಮೇಲೆ ಮತ್ತು ಬಾವು ಒಬ್ಬ ವ್ಯಕ್ತಿಯ
ಒಂದು ವಾರದ ಹಳೆಯದ್ದು ಹೇಗೆ?
because frequently he is assaulting the complainant. ಇನ್ನಿತರೆ ಕೆಲಸ ಮಾಡಿದರೆ ಆತನ ಆರೋಗ್ಯ ಅವಲಂಬನೆ ಊತ ಆಗಬಹುದು ಅಥವಾ ಆಗದೇ ಇರಬಹುದು. ನೋವು ಒಬ್ಬ ವ್ಯಕ್ತಿ ಹೇಳಿದ್ರೆ ಮಾತ್ರ ನಮಗೆ ಗೊತ್ತಾಗುತ್ತೆ, ಇಲ್ಲಿಂದ ಗೊತ್ತಾಗುತ್ತೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. ಒಬ್ಬ ವ್ಯಕ್ತಿ ಕೆಳಗೆ ಬಿದ್ದ 1 ರಿಂದ 7 ಗಾಯಗಳು ಆಗಿರಬಹುದು ಎಂದರೆ ಸರಿ. ಸುಳ್ಳು ಮಾಹಿತಿ ನೀಡಿದ್ದರಿಂದ ಸರಿಯಲ್ಲ. ಶಾಸ 1ರ ಮೇಲೆ ಕೊಯ್ದ ಅಥವಾ ಯಾವುದೇ ಸುಟ್ಟ ಗಾಯಗಳನ್ನು ಕಂಡು ಬಂದಿಲ್ಲ. 1ರ ಮಾತು ಕೇಳಿ ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದೇನೆ, ಸರಿಯಲ್ಲ. One moment, then my lord, is a complainant evidence.
No, why the appellate court acquitted the accused?
appellate court, my lord, only on the basis of their evidence, my lord, she used to demand to separate house and all. On that basis, my lord, the different defense evidence,
Defense evidence, ಯಾರ್ಯಾರು
ಗಂಡ ಮತ್ತೆ
DW1,
DW5, DW1 to DW5. DW1 is accused,
accused number 1.
accused number 1.
DW,
DW2 father.
Hmm.
And DW3 sister. DW4 doctor who treated the accused number 2 father. And DW5 is the mother. And clearly admitted, my lord, in a cross examination of DW1, he already married another and one kid is also there, my lord. Even then, my lord, we produced the document. Para number 4, para number 3.
yes, proceed.
One moment, kindly see, my lord, complaint evidence. The harassment.
ಒಂದು ನೋಡಿ.
DW1. DW1, para number 3. ದೋಷ ಸಾಕ್ಷಿ ಒಂದು ದಾವಣಗೆರೆ ನನ್ನ ವಿರುದ್ಧ ಒಂದು ಪ್ರಕರಣ ದಾಖಲಿಸಿದ್ದು ಅದನ್ನು ಹಿಂಪಡೆಯುವಂತೆ ಒತ್ತಾಯ ಮಾಡಿ ಯಶಸ್ವಿಯಾಗಿದ್ದೇನೆಂದರೆ ಸರಿಯಲ್ಲ. ದೋಷ
3 ನಲ್ಲಿ ಇಲ್ಲ.
ಪಡ
DW1.
DW1.
ರಾಘವೇಂದ್ರ.
ರಾಘವೇಂದ್ರ. Para number 3, cross examination.
Yes.
Para number 1 in the relevant. ನನ್ನ ಹಾಗೂ ದೋಷಾರೋಪಣೆ ಸಾಕ್ಷಿ ಒಂದರವರ ಮದುವೆ 4/7/2000 ಆಗಿರುತ್ತದೆ. ಮಾತುಕತೆಯಲ್ಲಿ 1,20,000 ಹಣ, 5 ತೊಲ ಬಂಗಾರ, ಬಟ್ಟೆಗೆ 4,000. ದೋಷಾರೋಪಣಾ ಸಾಕ್ಷಿ ಒಂದರವರ ಮದುವೆ ಖರ್ಚನ್ನು ಹಾಕಬೇಕೆಂದು ಮಾತುಕತೆಯಾಗಿತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆಗ ನನ್ನ ತಂದೆ ತಾಯಿ ಹಾಗೂ ದೋಷಾರೋಪಣಾ ಸಾಕ್ಷಿ ಒಂದರವರ ತಂದೆ ತಾಯಿ ಸಂಬಂಧಿಕರು ಸೇರಿದ್ದರು ಎಂದರೆ ಸರಿ. ಮದುವೆಗೆ ಮುಂಚೆ ದೋಷಾರೋಪಣಾ ಸಾಕ್ಷಿ ಒಂದರವರ ತಂದೆ 70,000 ನೀಡಿದ್ದರು ಎಂದರೆ ಸರಿಯಲ್ಲ. ಮದುವೆ ದಿನ 5 ತೊಲ ಬಂಗಾರ ಬಟ್ಟೆ ನೀಡಿದ್ದಾರೆ ಎಂದು ಸಾಕ್ಷಿ ಬಟ್ಟೆ ಮಾತ್ರ ನೀಡಿದ್ದು ಬಂಗಾರ ನೀಡಿಲ್ಲ ಎನ್ನುತ್ತಾರೆ. ನಂತರ 2005-6ರವರೆಗೆ ದೋಷಾರೋಪಣಾ ಸಾಕ್ಷಿ ಒಂದರವರು ಚೆನ್ನಾಗಿದ್ದೇನೋ, ಮದುವೆಯಾದ 6 ತಿಂಗಳು ಚೆನ್ನಾಗಿದ್ದು ನಂತರ ದೋಷಾರೋಪಣಾ ಸಾಕ್ಷಿ ಒಂದರವರಿಗೆ ಕಿರುಕುಳ ನೀಡಲು ಪ್ರಾರಂಭಿಸಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಹೆಚ್ಚಿನ ವರದಕ್ಷಿಣೆ ದೋಷಾರೋಪಣಾ ಸಾಕ್ಷಿ ಒಂದರವರಿಗೆ ತೊಂದರೆ ನೀಡುತ್ತಿದ್ದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ಮದ್ಯ ಸೇವಿಸಿ ಬಂದು
All the suggestions are denied.
denied. But only thing is para number 3 after 4 line. ನಾನು 2ನೇ ಮದುವೆ ಆಗಿದ್ದು ನನಗೆ ಮಗು ಜನಿಸಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು 2ನೇ ಮದುವೆ ಆಗಿದ್ದು ಒಂದು ಹೆಣ್ಣು ಮಗು ಜನಿಸಿದೆ. ಸದರಿ ಬಗ್ಗೆ ವಿವೇಕಾನಂದ ನರ್ಸಿಂಗ್ ಹೋಮ್ನಲ್ಲಿ ದಾಖಲೆ ಇದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಜನನ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಗುರುತು ಮಾಡಲು ಆರೋಪ ಪರ ವಕೀಲರು ತಕರಾರು ಮಾಡಿರುತ್ತಾರೆ. ಸದರಿ ದಾಖಲೆಗಳು ಸಾರ್ವಜನಿಕ ದಾಖಲೆಯಾಗಿದ್ದು ದಾಖಲೆಯನ್ನು ಗುರುತು ಮಾಡಲು ತಕರಾರು ತಳ್ಳಿಹಾಕಿ ಗುರುತು ಮಾಡಲು ಅವಕಾಶ ನೀಡಲಾಗಿದೆ. ಜನನ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ನಿಶಾನೆ P15 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ನಿಶಾನೆ D11 ಹಾಗೂ ನಮೂದಿಸಿದ ಪ್ರಕರಣ ಸದರಿ ಪ್ರಕರಣಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ ಅಂದರೆ ಸರಿ. ದೋಷಾರೋಪಣಾ ಸಾಕ್ಷಿ 1 ನನ್ನ ಮಗುವನ್ನು ನಿರ್ಲಕ್ಷ್ಯ ಮಾಡಿದ್ರಿಂದ ನಿಶಾನೆ P10ರಂತೆ ಜೀವನಾಂಶ ಬಗ್ಗೆ ನಿಶಾನೆ P10ರಂತೆ ಆದೇಶ ಮಾಡಿರ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನನ್ನ ತಂದೆಗೆ ಹುಷಾರಿಲ್ಲದೆ ಇದ್ದರಿಂದ ದೋಷಾರೋಪಣಾ ಸಾಕ್ಷಿ ನೋಡಿಕೊಳ್ಳದೆ ಹೋದರೂ ಸುಳ್ಳು ಹೇಳುತ್ತಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ದೋಷಾರೋಪಣಾ ಸಾಕ್ಷಿ 1ರವರಿಗೆ ಮಾನಸಿಕ ಹಾಗೂ ದೈಹಿಕ ಹಾಗೂ ವರದಕ್ಷಿಣೆ ಕಿರುಕುಳ ನೀಡಿದ್ದೆಂದರೆ ಸದರಿ ದಾವೆ ಹಾಕಿರುತ್ತದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ.
What is there in exhibit P15?
P15.
P15.
Then is a
birth certificate.
Birth certificate.
birth certificate of the child. Straight away I will come to the relevant point of relevant portion, my lord, is a PW1 complainant.
Yes.
PW1 complaint.
Yes, proceed.
With regard to the harassment, may I read the third line. 2002 ಜುಲೈ ಕುಂಕುಮ ವೀರಭದ್ರೇಶ್ ದೇವಸ್ಥಾನದಲ್ಲಿ ನನ್ನ ಹಾಗೂ ಆರೋಪಿ ಮದುವೆ ಆಯಿತು. ನಮಗೆ ಒಂದು ಹೆಣ್ಣು ಮಗು ಇದೆ. ಮದುವೆಯಾದ ಮೊದಲ 6 ತಿಂಗಳ ದಾಂಪತ್ಯ ಅನ್ಯೋನ್ಯವಾಗಿತ್ತು. ನಂತರ ನನ್ನ ಗಂಡ ಬೇಕಾಬಿಟ್ಟಿ ತಿರುಗಾಡಲು ಪ್ರಾರಂಭಿಸಿದ. ಮನೆಗೆ ಮದ್ಯಪಾನ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದ ಮತ್ತು ಸಿಗರೇಟ್ ಸೊ ನೀನು ನನ್ನ ತಂದೆ ಮನೆಯಿಂದ ಹಣ ಇಸಿಕೊಂಡು ಬಾ, ನನಗೆ ಹಣ ಬೇಕು ಅಂತ ನನಗೆ ಚಿತ್ರಹಿಂಸೆ ಕೊಡಲು ಪ್ರಾರಂಭಿಸಿದ. ನಾನು ಗರ್ಭಿಣಿಯಾಗಿದ್ದ ನನ್ನ ಮನೆಯಿಂದ ಹೊರಗೆ ದಬ್ಬುತ್ತಿದ್ದ. ಮಗು ಆದ ಮೇಲೆ ಸರಿ ಹೋಗಬಹುದೆಂದು ನಾನು ಚಿತ್ರಹಿಂಸೆಯನ್ನು ಸಹಿಸಿಕೊಂಡಿದ್ದೆ. ಆದರೆ ನನಗೆ ಹೆಣ್ಣು ಮಗು ಆದ ಮೇಲೂ ಆರೋಪಿ ಚಿತ್ರಹಿಂಸೆ ಕೊಡುವುದನ್ನು ನಿಲ್ಲಿಸಲಿಲ್ಲ. 1 ಮತ್ತು 2ನೇ ಆರೋಪಿತರು ಒಟ್ಟಿಗೆ ಸೇರಿ ಮನೆಯಲ್ಲಿ ಮದ್ಯಪಾನ ಮಾಡುತ್ತಿದ್ದರು. 3 ಜನ ಆರೋಪಿತರು ಸಮಾಲೋಚನೆ ಮಾಡಿ ಕೊಂಡು ತವರು ಮನೆಯಿಂದ ಹಣ ತರುವಂತೆ ಪೀಡಿಸುತ್ತಿದ್ದರು. ನಾನು ಕಿರುಕುಳ ಸಹಿಸಲಾರದೆ ನನ್ನ ತವರು ಮನೆಗೆ ಹೋಗುತ್ತಿದ್ದೆ. ಆದರೆ ನನ್ನ ತವರು ಮನೆಯವರು ಬಡತನ ತಿಳಿದುಕೊಂಡು ನನಗೆ ಹಣ ಕೇಳಲು ಆಗುತ್ತಿರಲಿಲ್ಲ. ನಾನು ವಾಪಸ್ಸು ಗಂಡನ ಮನೆಗೆ ಬರುತ್ತಿದ್ದೆ. ಹಾಗೆ ಬಂದಾಗ ನನ್ನನ್ನು ರೂಮ್ನಲ್ಲಿ ಕೂಡಿ ಹಾಕಿ 3 ಜನ ಆರೋಪಿತರು ನನಗೆ ಎಲ್ಲ ಒಟ್ಟಾಗಿ ಹಲ್ಲೆ ಮಾಡುತ್ತಿದ್ದರು ಹಾಗೂ ನಾನೇ ಆತ್ಮಹತ್ಯೆಗೆ ಪ್ರಯತ್ನ ಎಂದು ಸುಳ್ಳು ಹಬ್ಬಿಸುತ್ತಿದ್ದರು. ನಾನು ದೂರು ಕೊಡುವ ಮೊದಲು ನನ್ನ ಮಾವನಿಗೆ ಎಕ್ಕೆನಹಳ್ಳಿಗೆ ವರ್ಗವಾಗಿತ್ತು. ಅಲ್ಲಿಯೂ ಸಹ ಆರೋಪಿ ನನಗೆ ಕಿರುಕುಳ ಕೊಡುತ್ತಿದ್ದರು. ನಂತರ ನನ್ನ ಮಾವನಿಗೆ ವಿಗಡೂರಿಗೆ ವರ್ಗ ಆಯಿತು. ಅಲ್ಲೂ ಸಹ ಆರೋಪಿತರು ನನ್ನ ಮೇಲೆ ಹಿಂಸೆ ಮಾಡುತ್ತಿದ್ದರು. ಆ ಮೊದಲು ನಾನು ದಾವಣಗೆರೆ ಮಹಿಳಾ ಠಾಣೆಯಲ್ಲಿ ದೂರು ದಾಖಲಿಸಿದ್ದೆ. ಆರೋಪಿತರು ಇನ್ನು ಮುಂದೆ ಹೊಂದಿಕೊಂಡು ಹೋಗುವುದಾಗಿ ಮುಚ್ಚಳಿಕೆ ಬರೆದುಕೊಟ್ಟು ನಾನು ನೀಡಿದ ದೂರನ್ನು ವಾಪಸ್ಸು ಪಡೆಯುವಂತೆ ಮಾಡಿದರು. 13/2/2007 ನನ್ನ ಅಣ್ಣ ವಾಪಸ್ಸು ನನ್ನ ಗಂಡನ ಮನೆಗೆ ಬಿಟ್ಟು ಹೋದಾಗ ಬೆಳಗಿನ ಸಂಜೆವರೆಗೆ ಆರೋಪಿತರು ಒಟ್ಟಾಗಿ ನನಗೆ ಚಿತ್ರಹಿಂಸೆ ನೀಡಿದರು. ನಾನು ಹೇಳಿದರು, ನೀನು ದುಡ್ಡು ತರಲಿಲ್ಲ, ಬದಲಾಗಿ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ದೂರು ನೀಡಿದ್ಯಾ, ಈಗ ನಿನಗೆ 3 ಹಂತದಲ್ಲಿ ಚಿತ್ರಹಿಂಸೆ ನೀಡುತ್ತೇವೆ ಅಂತ ಹೇಳಿ ನನಗೆ ಬೆಳಗ್ಗೆ ಮಧ್ಯಾಹ್ನ ಸಂಜೆ 3 ಹಂತದಲ್ಲಿ ಚಿತ್ರಹಿಂಸೆ ನೀಡಿದರು. ಆರೋಪಿತರು ನನಗೆ ಬ್ಲೇಡಿನಿಂದ ಮೈಮೆಲ್ಲ ಚುಚ್ಚಿದರು. ನಾನು ಜಡೆ ಹಿಡಿದು ಗೋಡೆಗೆ ಗುದ್ದಿಸಿದರು. ನನ್ನ ಮೂಗಿನಿಂದ ರಕ್ತ ಬಂತು. ನಾನು ಆರೋಪಿತರ ಕಾಲುಗಳನ್ನು ಹಿಡಿದುಕೊಂಡು ಬೇಡಿಕೊಂಡು ಆರೋಪಿತರು ನನ್ನ ಮನೆಯಲ್ಲಿ ಕಣ್ಣು ತರಲಿಲ್ಲ. ನಾನು ಸಹ ಎದುರುಗಡೆ ಮನೆಗೆ ಹೋದೆ. 14/2/2007 ಸಂಜೆ 5 ಗಂಟೆಗೆ ಪುನಃ ನನಗೆ ಆರೋಪಿತರು ಹಲ್ಲೆ ಮಾಡಲು ಶುರು ಮಾಡಿದರು. ನಾನು ಸಹಿಸಲಾದ ವಿಶ್ವಣ್ಣನವರಿಗೆ ತಿಳಿಸಿದೆ. ಅವರು ನನಗೆ ಬಸ್ ಚಾರ್ಜ್ ಕೊಟ್ಟು ನನ್ನ ತವರು ಮನೆಗೆ ಕಳಿಸಿದರು. ನಾನು ಸಿದ್ಲಿಪುರಕ್ಕೆ ಹೋದಾಗ ರಾತ್ರಿ 11 ಗಂಟೆ ಆಗಿತ್ತು. ಮರುದಿನ 15/2/2007 ನನ್ನನ್ನು ಶಿವಮೊಗ್ಗ ಮೆಗ್ಗನ ಆಸ್ಪತ್ರೆಗೆ ದಾಖಲಿಸಿದೆ. 16/2/2007 ರಾತ್ರಿ 9:30 ಗಂಟೆಗೆ ನ್ಯಾಮತಿ ಪೊಲೀಸರು ಆಸ್ಪತ್ರೆಗೆ ಬಂದು ಇಶಾನ P1 ಪಡೆದುಕೊಂಡರು. ಒಂದು ಮದುವೆ ಲಗ್ನ ಪತ್ರಿಕೆಯನ್ನು ಇಶಾನ P2 ಅಂತ ಗುರುತಿಸಲಾಯಿತು. 3 ಫೋಟೋಗಳನ್ನು ಸೊ Then my lord is a cross examination.
Where is the allegation that even before marriage the dowry was obtained?
Yes, my lord.
Demanded. Where she stated?
ನೆಕ್ಸ್ಟ್ ಲೈನ್. ಸದರಿ ಅಮಾನತು ನಾಮೆಯನ್ನು ನಿಶಾನ P ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಮದುವೆ ಕಾಲದಲ್ಲಿ ಆರೋಪಿಗಳು 1.2 ಲಕ್ಷ ರೂಗಳನ್ನು ವರದಕ್ಷಿಣೆಯಾಗಿ ಪಡೆದಿದ್ದಾರೆ. 5 ತೊಲ ಚಿನ್ನ ಸಹ ಕೊಡಲಾಗಿತ್ತು. ಆರೋಪಿಗಳು ಈಗಲೂ ನನ್ನ ಇಟ್ಟುಕೊಂಡಿರುವುದಿಲ್ಲ ಮತ್ತು ನನ್ನ ಜೀವನ ಸಹ ಮಾಡುತ್ತಿಲ್ಲ. ಈಗ ನಾನು ನನ್ನ ತವರಿನಲ್ಲಿದ್ದೇನೆ. ಆರೋಪಿಗಳನ್ನು ನೋಡಿದರೆ ಗುರುತಿಸುತ್ತೇನೆ. ನನ್ನ ಗಂಡ ಹಾಲಿ ಮತ್ತೊಂದು ಮದುವೆಯಾಗಿದ್ದು ಅವರ ಹೆಸರು ಶಾಂತ ಅಂತ ಇರುತ್ತದೆ. ನನ್ನ ಗಂಡ ಸದರಿ ಶಾಂತ ಒಟ್ಟಿಗೆ ಇರುವ ಭಾವಚಿತ್ರ ಮೊಬೈಲ್ ಮುಖೇನ ತೆಗೆಸಿ ಅದನ್ನು ಡೌನ್ಲೋಡ್ ಪ್ರಿಂಟ್ ಮಾಡಿಸಿದ್ದು ಸದರಿ ಫೋಟೋನ ಅರ್ಜಿಯೊಂದಿಗೆ ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. ಸದರಿ ಫೋಟೋವನ್ನು ನಿಶಾನ P7 ಎಂದು ಗುರುತಿಸಾಯಿತು. ಫೋಟೋ ತೆಗೆದು ಸದರಿ ಮೊಬೈಲ್ ನಂಬರ್ ಸೊ 1ನೇ ಆರೋಪಿಯು ಸೊ ನನ್ನ ಸಿಗರೇಟ್ನಿಂದ ಸುಟ್ಟ ವೈದ್ಯರ ಹತ್ತಿರ ತೋರಿಸಿದ್ದೇನೆ. ಇನ್ನು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. 2003-4 ಆರೋಪಿ ನನಗೆ ಸಿಗರೇಟ್ನಿಂದ ಸುಡುತ್ತಿದ್ದ. ಆ ಬಗ್ಗೆ ನನ್ನ ಮೈ ಮೇಲೆ ಕಲೆಗಳಿವೆ. ಈ ಬಗ್ಗೆ ನಾನು ವೈದ್ಯರಿಂದ ಪ್ರಮಾಣ ಪತ್ರ ಪಡೆದುಕೊಂಡು ಹಾಜರುಪಡಿಸಿದ್ದೇನೆ. ಈ ಬಗ್ಗೆ ನಾನು ಪೊಲೀಸರಿಗೆ 1ನೇ ಆರೋಪಿಯು ನನ್ನ ಗೆ ಪೊಲೀಸರಿಗೆ ಮಾಹಿತಿ ನೀಡಿದ್ದೇನೆ. ಅದನ್ನು ಪೊಲೀಸರು ಬರೆದುಕೊಂಡಿದ್ದಾರೋ ಇಲ್ಲವೋ ಗೊತ್ತಿಲ್ಲ. ಈ ಬಗ್ಗೆ ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿಕೆ ನೀಡಲಿದ್ದು ಸಹ ಆರೋಪಿಗೆ ಶಿಕ್ಷೆ ಕೊಡಲು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಆರೋಪಿ ಮದ್ಯಪಾನ ಮಾಡಿ ಸಿಗರೇಟ್ನಿಂದ ಎಂದು ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ನಾನು ನನ್ನ ವೈದ್ಯಕೀಯ ಪ್ರಮಾಣ ಪತ್ರಗಳು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಲಿ ಎಂದರೆ ಸರಿಯಲ್ಲ. 1ನೇ ಆರೋಪಿ ನನ್ನ ಗರ್ಭಿಣಿಯಾಗಿದ್ದಾಗ ಹಾಗೂ ನನ್ನ ಮಗಳು ನನಗೆ ದೈಹಿಕ ಮತ್ತು ಮಾನಸಿಕ ಹಿಂಸೆ ನೀಡಿದ ಬಗ್ಗೆ ದೂರಿನಲ್ಲಿ ಹೇಳಿಕೆಯಲ್ಲಾಗ್ಲಿ ನಮೂದಿಸಿಲ್ಲ. ದಿಸ್ ಆಲ್ ಡಿನಯಲ್ ಅಂಡ್ ಆಲ್ ಮಲ್ಲ. And connected to this, my lord, exhibit P, sorry, doctor evidence.
Memorandum. Yes, memorandum of appeal memorandum. Why he was acquitted by the appellate court?
Appellate court, my lords, acquitted and the judgment per number 19. Because birthday celebrate ಮಾಡಿದಾಗ ಇವರಿಬ್ರು ಇದ್ರು, ಸೊ ಚೆನ್ನಾಗಿದ್ರು. ಅರ್ಲಿಯರ್ ಇನ್ಸಿಡೆಂಟ್. Now, my lord, is a complaint residing alone, my lord, with child, my lord. She is doing some coolie work. Trial court order, my lord, can you see page number 19, my lord? Para number 19.
Yes.
Because that incident is not stated before the police, but why is stated before the, why they are considered before at the time of passing this judgment? Para number 19.
Yes, proceed.
ಅಭಿಯೋಜನೆಯವರು ವಿಚಾರಣೆ ಮಾಡಲ್ಪಟ್ಟ ಇತರ ಸಾಕ್ಷಿದಾರರ ಮತ್ತು 13 ಆರೋಪಿತ ಹಿಂಸೆ ನೀಡಿರುವುದನ್ನು ಹೇಳಿದ್ದಾರೆ. ಅದೇ ರೀತಿ ಈ ಬಗ್ಗೆ ಪಂಚಾಯತಿ ಮಾಡಿರುವುದಾಗೂ ಸಹ ಹೇಳಿದ್ದಾರೆ. ಸಾಕ್ಷಿ 4 ಮತ್ತು 10ರವರು 1ರವರ ತಂದೆ ತಾಯಿ ಇವರು ಸಹ ಆರೋಪಿತ ಹಿಂಸೆ ನೀಡುತ್ತಿದ್ದ ಬಗ್ಗೆ ಸಾಕ್ಷಿ 1ರವರ ಮೇಲಿಂದ ಮೇಲೆ ತಿಳಿಸುತ್ತಿದ್ದು, ಇದು ನಾಳೆ ಅವರ ಸಂಸಾರ ಸರಿ ಹೋಗುತ್ತದೆ ಎಂದು ಭಾವಿಸಿ ಹಾಗೂ ಮಕ್ಕಳಾದ ನಂತರ ಬದಲಾಗಬಹುದು ಎಂದು ಸಾಕ್ಷಿ 1ರವರು ಆರೋಪಿತ ಮನೆಗೆ ಕಳುಹಿಸಿಕೊಡುತ್ತಿದ್ದು ಬಗ್ಗೆ ತಿಳಿಸಿದ್ದಾರೆ. 10ರವರು ತಮ್ಮ ಪಾಟಿ ಸವಾಲಿನಲ್ಲಿ ದೋಷಾರೋಪಣೆ 1ರವರು ಸ್ವತಃ ಬಿದ್ದು ಗಾಯಪಡಿಸಿಕೊಂಡೆಂದರೆ ಸಾಕ್ಷಿ ಆರೋಪಿ ಪ್ರತಿದಿನ ಹೊಡೆತಿದ್ದು, ಸಿಗರೆಟ್ನಿಂದ ಅವರಿಗೆ ಸುಡುತ್ತಿದ್ದು, ಕೈಗಳಿಂದ ಅವುಗಳಿಗೆ ಏನನ್ನು ಹಾಕಿಕೊಂಡು ದೋಷಾರೋಪ 1ರವರ ಕೈಗಳ ಮೇಲೆ ಗೀರುತ್ತಾನೆ ಎನ್ನುತ್ತಾರೆ. ಸಾಕ್ಷಿ 10ರವರ ಸಾಕ್ಷ್ಯವನ್ನು ಪರಿಶೀಲಿಸಾಗಿ ಸಾಕ್ಷ್ಯ 1ರವರ ಆರೋಪಿ ಹಿಂಸೆ ನೀಡುವುದು ಮೇಲಿಂದ ಮೇಲೆ ತನ್ನ ತಾಯಿಗೆ ತಿಳಿಸಿದೆ ಎಂಬುದನ್ನು ಸ್ಪಷ್ಟವಾಗುತ್ತದೆ. ಸಾಕ್ಷಿ 3ರ ಸಾಕ್ಷಿ ಪ್ರಶ್ನಾತೀತವಾಗಿದೆ. ಅವರನ್ನು ಆರೋಪಿತ ಪಾಟಿ ಸವಾಲು ಮಾಡಿಲ್ಲ. ಸದರಿಯವರು ಆರೋಪಿತರ ಸಾಕ್ಷಿ 1ರವರ ಇವರಿಗೆ ಚಿತ್ರಹಿಂಸೆ ನೀಡುವುದನ್ನು ಮತ್ತು ವರದಕ್ಷಿಣೆ ಕಿರುಕುಳ ನೀಡುವುದನ್ನು ತಮ್ಮ ಸಾಕ್ಷಿ ಸ್ಪಷ್ಟವಾಗಿ ತಿಳಿಸುತ್ತಾರೆ. ಸಾಕ್ಷಿ 4 ಮತ್ತು 10ರವರು ಆರೋಪಿತರ ವರ್ತನೆ ಬದಲಾಗುತ್ತಾರೆ ಎಂದು ಸಾಕಷ್ಟು ಸಮಯ ನೀಡಿದರೂ ಸಹ ಅದರಲ್ಲಿ ಯಾವುದೇ ಬದಲಾವಣೆಯಾಗಿಲ್ಲ. ಹೀಗಾಗಿ ಕೊನೆಯದಾಗ ಆರೋಪಿತ ಹಿಂಸೆ ಹೆಚ್ಚಾಗಿದ್ದರಿಂದ ಸಾಕ್ಷಿ ಒಂದರವರು ದೂರು ನೀಡಿರ್ತಾರೆ. ಸಾಕ್ಷಿ ಒಂದರವರ ಚಿಕಿತ್ಸೆ ನೀಡಿದ ವೈದ್ಯರಿಂದ ಬಂದ ಮನವಿ ಮೇರೆಗೆ ಪೊಲೀಸರು ಆಸ್ಪತ್ರೆಗೆ ಹೋಗಿ ಸಾಕ್ಷಿ ಒಂದರ ಹೇಳಿಕೆ ಪಡೆದ ಪ್ರಕರಣ ದಾಖಲಿಸಿದ್ದಾರೆ. ಪ್ರಕರಣದ ದಾಖಲಿಸಿದ ಸನ್ನಿವೇಶವನ್ನು ಸಹ ನೋಡಬೇಕಾಗುತ್ತದೆ. ಇನ್ನು ಒಂದನೇ ಆರೋಪಿಯಾದ ಹಣ ಪಡೆದುಕೊಳ್ಳುವ ಸಲುವಾಗಿ ಆತನನ್ನು ಶಿಕ್ಷಿಸುವ ಸಲುವಾಗಿ ಸುಳ್ಳು ಪ್ರಕರಣ ದಾಖಲಿಸಿ ಸುಳ್ಳು ಸಾಕ್ಷಿ ಹೇಳುತ್ತಿದ್ದಾರೆ ಎಂದು ಹೇಳಿದ್ದಾರೆ. ಸಾಕ್ಷಿ ಒಂದರವರು ಸುಳ್ಳು ಪ್ರಕರಣ ದಾಖಲಿಸುವ ಉದ್ದೇಶ ಹೊಂದಿದ್ದರೆ ಒಂದನೇ ಆರೋಪಿಯ ತಾಯಿ ಹಾಗೂ ಇನ್ನಿತರ ಸಂಬಂಧಿಕರು ಪ್ರಕರಣದಲ್ಲಿ ಸೇರಿಸಬಹುದಾಗಿತ್ತು. ಅದೇ ರೀತಿ ಮದುವೆಯಾದ ತಕ್ಷಣ ತವರು ಮನೆಗೆ ಹೋಗಬಹುದಾಗಿತ್ತು. ಸುಮಾರು 5 ವರ್ಷಗಳು ಸಂಸಾರ ನಡೆಸಿ ಒಂದು ಹೆಣ್ಣು ಮಗು ಜನಿಸಿದ ನಂತರ ಅವನ ವಿರುದ್ಧ ಸುಳ್ಳು ಪ್ರಕರಣ ದಾಖಲಿಸುವ ಉದ್ದೇಶವಾದರೂ ಏನೇ ಎಂಬುದು ಅರ್ಥವಾಗುತ್ತಿಲ್ಲ. ಯಾವುದೇ ಹೆಣ್ಣು ಮಗಳು ತನ್ನ ಜೀವನದ ಬಲಿಗೊಟ್ಟು ಹಣಕ್ಕಾಗಿ ದಾಖಲಿಸಿದಳೆ ಎಂಬುದು ಆರೋಪಿತರ ವಾದ ಸಮಂಜಸವಲ್ಲ ಹಾಗೂ ನಂಬುವಂಥದ್ದಲ್ಲ. And para number 24 man. ದೊಡ್ಡಪೇಟೆ ಗುರ್ಲಿಂಗೆ ಎಸ್ಐ ಅವರು ತಮ್ಮ ಸಾಕ್ಷಿ ಶಿವಮೊಗ್ಗ ದೊಡ್ಡಪೇಟೆ ಠಾಣೆಯಿಂದ ಬಂದು ಮಾಹಿತಿಯನ್ನು ನಡೆಸಿ ಮೆಗನ್ ಆಸ್ಪತ್ರೆ ಹೋಗಿ ನಿಶಾನೆ P1 ಸಾಕ್ಷಿ ಅವರ ಹೇಳಿಕೆಯನ್ನು ಪಡೆದುಕೊಂಡು ಬಗ್ಗೆ ಸಾಕ್ಷಿ ನುಡಿದಿರುತ್ತಾರೆ. ನಂತರ ಆರೋಪಿಯ ವಿರುದ್ಧ ಪ್ರಕರಣ ದಾಖಲಿಸಿಕೊಂಡು ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳದಲ್ಲಿ ಇವುಗಳನ್ನು ಒಪ್ಪಿಕೊಂಡಿದ್ದಾರೆ. ಸಾಕ್ಷ್ಯದ ಆಧಾರದ ಮೇಲೆ ಅಭಿಯೋಜನೆ ನಿಶಾನೆ P8 ರುಜುವಾತುಪಡಿಸಿದ್ದಾರೆ. ಸಾಕ್ಷಿ 19 ಸಾಕ್ಷಿ 1 ಬರು ಹೇಳಿಕೆ ನಿಶಾನೆ P13 ಹಾಗೂ ದೋಷ ಸಾಕ್ಷಿ 20 ಹೇಳಿಕೆ ಪಡೆದುಕೊಂಡು ಸಾಕ್ಷಿ ನುಡಿದಿದ್ದಾರೆ. Demand discussion similar 28 page number para number 28.
Yes.
ಅಭಿಯೋಜನೆ ಪ್ರಕರಣ ಏನಂದ್ರೆ ಒಂದನೇ ಆರೋಪಿಯ ಸಾಕ್ಷಿ 1 ಸಂದರ್ಭದಲ್ಲಿ ಒಂದನೇ ಆರೋಪಿಗೆ 1,20,000 ರೂಪಾಯಿ ಹಣವನ್ನು ವರದಕ್ಷಿಣೆಯಾಗಿ ನೀಡುವ ಮಾತುಕತೆ ಆಗಿತ್ತು. ಅದರ ಪ್ರಕಾರ ಸಾಕ್ಷಿ 1 ತಂದೆ 1,14,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದು 10,000 ರೂಪಾಯಿ ಬಾಕಿ ಉಳಿಸಿಕೊಂಡಿದ್ದರು. ಇದಕ್ಕೆ ಬಡ್ಡಿ ಸೇರಿ 50,000 ಹೆಚ್ಚು ಏರಿಕೆ ಮತ್ತು ತರುವಂತೆ ಆರೋಪಿಗೆ ಒತ್ತಾಯಪಡಿಸುತ್ತಿದ್ದರು ಎಂದು ಆಪಾದಿಸಿದ್ದಾರೆ. ಈ ಬಗ್ಗೆ ನಿಶಾನೆ P13 ಪರಿಶೀಲಿಸಿ ಅದರ ಬಗ್ಗೆ ಸ್ಪಷ್ಟವಾಗಿ ನಮೂದು ಇರುತ್ತದೆ. ವರದಕ್ಷಿಣೆ ಹಣದ ವಿಚಾರವಾಗಿ ಸಾಕ್ಷಿ 1 ಸಾಕ್ಷಿಗಿಂತ ವಿವಾಹ ಪೂರ್ವದಲ್ಲಿ ಮದುವೆ ಮಾತುಕತೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿದ ಸಾಕ್ಷಿದಾರರ ಸಾಕ್ಷ್ಯ ಅತ್ಯಂತ ಮಹತ್ವವಾದ್ದು. ಈ ಬಗ್ಗೆ ಅಭಿಯೋಜನೆಯವರು ವಿಚಾರಣೆ ಮಾಡಲಾದ ಸಾಕ್ಷಿ 4 ಲಕ್ಷ್ಮಣ, ಸಾಕ್ಷಿ 1 ರವರ ತಂದೆ ಹಾಗೂ 1ನೇ ಆರೋಪಿಯ ಮಾವ, ಸಾಕ್ಷಿ 4 ಆನಂದಪ್ಪ, ಸಾಕ್ಷಿ 10 ಶಾರದಮ್ಮ, ಮಂಜಪ್ಪ, ಸೀನಪ್ಪ, ಕರಿಯಪ್ಪ, ನಾಗೇಶಪ್ಪ, ವೆಂಕಟೇಶ್ ಇವರು ಸಾಕ್ಷ್ಯ ಮಹತ್ವವಾದ್ದು. ಈ ಎಲ್ಲಾ ಸಾಕ್ಷಿದಾರರು ಮದುವೆ ಮುಂಚೆ 1ನೇ ಆರೋಪಿಗೆ ವರದಕ್ಷಿಣೆಯಾಗಿ 1,20,000 ರೂಪಾಯಿ ಹಣ ನೀಡುವ ಬಗ್ಗೆ ಮಾತುಕತೆಯಾಗಿತ್ತು ಎಂಬುದನ್ನು ಎಲ್ಲಾ ಸಾಕ್ಷಿದಾರರು ತಿಳಿಸಿದ್ದಾರೆ. ಸಾಕ್ಷಿ 4 ಸಾಕ್ಷ್ಯ ಅತ್ಯಂತ ಮಹತ್ವವಾದ್ದು. ಅವರು ತಮ್ಮ ಸಾಕ್ಷಿಯಲ್ಲಿ 70,000 ನೀಡಿದ ನಂತರ ಬಾಕಿ ಹಣದಲ್ಲಿ ಹೇಗೆ ಹೊಂದಾಣಿಕೆ ಮಾಡಿದರು ಎಂಬುದನ್ನು ವಿವರಿಸಿದ್ದಾರೆ. ದಿನಾಂಕ 25/3/2003 ಜಮೀನು ಮಾರಿ ಸಾಕ್ಷಿ 5 ಆನಂದಪ್ಪನೊಂದಿಗೆ ಹೋಗಿ 20,000 ರೂಪಾಯಿ ಹಣ 10/6/2003 20,000 ರೂಪಾಯಿ ಹಣ 1ನೇ ಆರೋಪಿ ತಂದು ಕೊಟ್ಟು ಬಂದಿದ್ದು. ಉಳಿದ 10,000 ರೂಪಾಯಿಗಳು ಬಡ್ಡಿ ಸೇರಿಸಿ 50,000 ರೂಪಾಯಿ ನೀಡುವಂತೆ ತೊಂದರೆ ನೀಡುತ್ತಿದ್ದಾರೆ ಎಂದು ತಿಳಿಸಿದ್ದಾರೆ. ಸಾಕ್ಷಿ 5 ಬಾಕಿ ವರದಕ್ಷಿಣೆ ಹಣ ನೀಡಲು ತಾನು ಸಹ ಹೋಗಿದ್ದೆ ಎಂದು ತಿಳಿಸಿದ್ದಾರೆ. ಸಾಕ್ಷಿ ಮಾತುಕತೆಯಿಂದ 1 ವಾರದ ನಂತರ ಸಾಕ್ಷಿ 4 ಆರೋಪಿಗೆ ತಂದೆಗೆ 70,000 ಹಣ ನೀಡಿರುತ್ತೇವೆ ಎಂದು ತಿಳಿಸಿದ್ದಾರೆ. ಸದರಿ ಸಾಕ್ಷಿಯಿಂದ ಮದುವೆಗೆ ಮುಂಚೆ 70,000 ರೂಪಾಯಿ ವರದಕ್ಷಿಣೆ ಹಣ ನೀಡಿದ್ದು, ನಂತರ 20,000, ಮತ್ತೊಂದು ಸಲ 20,000, ಹಾಗೆ ಬಟ್ಟೆಗಾಗಿ 4,000 ಒಟ್ಟು ಅಭಿಯೋಜನೆಯವರು ಅಪಾದಿಸಿದಂತೆ 1,14,000 ರೂಪಾಯಿಗಳನ್ನು ವರದಕ್ಷಿಣೆ ನೀಡಿರುವುದು ಸ್ಪಷ್ಟ. ಮದುವೆ ಮಾತುಕತೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿದ್ದ ಸಾಕ್ಷಿ 12 ಆರೋಪಿತರ ಸಂಬಂಧಿ ಇವರು ಸಹ ಆರೋಪಿತರ ವರದಕ್ಷಿಣೆ ಬೇಡಿಕೆ ಇಟ್ಟಿರುವುದನ್ನು ತಿಳಿಸಿದ್ದಾರೆ. ಸೊ ಮೋಸ್ಟ್ ಇಂಪಾರ್ಟೆಂಟ್ ಇಟ್ಸ್ ಎ engineer, he's a well educated, even he's a relative. There is no dispute in that family. Even then, my lord, he deposed before the court.
Yes.
ಸ್ವತಂತ್ರ ಸಾಕ್ಷಿದಾರರು ಮದುವೆ ಮಾತುಕತೆಯಲ್ಲಿ ಭಾಗವಹಿಸಿದರು. ಇವರು ಸ್ವತಂತ್ರ ಸಾಕ್ಷಿದಾರರು ಎಲ್ಲರೂ ಸಹ ಆರೋಪಿತರು ವರದಕ್ಷಿಣೆ ಬೇಡಿಕೆ ಇಟ್ಟಿದ್ದಾರೆ ಎಂಬುದನ್ನು ತಿಳಿಸಿದ್ದಾರೆ. ಸಾಕ್ಷಿ 1 ಮದುವೆಯಲ್ಲಿ ಮಾತುಕತೆಯಲ್ಲಿ ಇರಲಿಲ್ಲ ಅಂದರೆ ಮತ್ತೆ ವಿವರವನ್ನು 1ನೇ ಆರೋಪಿ ತನಗೆ ಫೋನ್ ಮುಖಾಂತರ ತಿಳಿಸಿದ್ದಾರೆ ಎಂದು ಸಾಕ್ಷಿಯಲ್ಲಿ ತಿಳಿಸಿದ್ದಾರೆ. ಆರೋಪಿತರು ಮಂಡಿಸಿದ ಲಿಖಿತವಾದದಲ್ಲಿ
the case of the prosecution, my lords,
She has to support, obviously, my lord, she has to support the complainant. But
Support
instead
the
of,
complainant when it's appellant, I'll go and admit the arguments.
Yes. You're right.
and most important, my lord, now, my lord, morning,
Number one, yeah, right.
Santosh Kumar MB.
Respondent number two. Yes.
morning I received information.
Hmm.
She's studying in first year engineering,
Who?
but daughter,
Daughter.
and the wife, my lord, has no mean.
ಆಯ್ತು ಮೇಂಟೆನೆನ್ಸ್ ಏನು ಕೇಳಿದ್ದೀರಿ?
Maintenance of 500 ಅದನ್ನು ಕೊಟ್ಟಿಲ್ಲ, 7 ವರ್ಷ ಆಯ್ತು, ತಂದೆ ತೀರ್ಕೊಂಡ ಮೇಲೆ.
You have to proceed.
In this case, my lord, 1,14,000 rupees fine imposed. 1,14,000, 7 ವರ್ಷದಿಂದ 8 ವರ್ಷದಿಂದ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ಲ. Trial court imposed a fine of rupees 1,14,000. My request, my lord, instead of sending it jail, compensation amount may be. Because he is having also 2 kids from the second wife.
I think ಕೊಟ್ಟಿದ್ದಾರೆ 1,14,000.
1,14,000 is a fine amount for section 3 of 5 years conviction and 1,40,000 rupees fine.
Yes.
Instead of sending jail, my lord, honestly,
ಹೇಗ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ? It cannot be converted into 125 proceeding.
no, the welfare of the
Sorry.
children, my lord, because he is also having 2 kids in the second wife.
What is the punishment prescribed?
5 years, it's
Three and four, DPF.
off the record, I have to argue both the complaint as well as the accused because of
The complaint in CC 290 of 2007. Of 2007 on the file of the complainant responded in criminal appeal number 83 of 2012 on the file of the learned principal district and sessions judge Davangere is impugning the judgment dated 3rd March 2017, acquitting the accused number 1 for the offense punishable under section 498A of IPC and 3 and 4 of Dowry Prohibition Act by setting aside the judgment of conviction and order of sentence dated 30/6/2012 passed in CC number 290 of 2007 on the file of the learned JMFC Honnali. The facts of the case are that the complainant filed the first information against accused numbers 1, 2. In all, how many accused?
total 3 accused, my lord.
1, 2, 3. Alleging commission of offense punishable under section 498A of IPC and under section 3 and 4 of the Prohibition Act. It is the specific contention of the complainant that she had married accused number 1 on 14/7/2002, and at the time of marriage, the accused have demanded dowry of rupees 1,20,000, out of which they have received rupees 1,14,000 on various dates. It is a further contention that even after marriage, she was being ill-treated by the accused by demanding additional dowry. It is the specific contention of the complainant that on 13th and 14th of February 2007, accused number 1 assaulted her all over the body and caused injuries, which is part of the cruelty meted to her. Thereby, it is stated that accused number 1 to 3 have committed the offense as stated above. On the basis of this statement of the complainant was examined as PW1, recorded while she was taking treatment in the Megan Hospital, Shimoga. The FIR was deemed to be registered against accused number 1 to 3 for the aforesaid offenses. And after investigation, charge sheet was deemed to be filed. The complainant examined herself as PW1 and got examined PW2 to /20 and got marked exhibit P1 to 15 in support of her contention. The accused have denied all the incriminating materials available on record and got examined DWs 1 to 5 and got marked exhibit D1 to 11 in support of their contention. The prosecution also identified MO1 in support of its contention. The trial court, after taking into consideration all these materials on record, came to the conclusion that the prosecution is successful in proving the guilt of accused number 1 for the offense punishable under section 498A of IPC and sentenced him to undergo simple imprisonment for three years and to pay fine of ₹2,000 and in default to undergo simple imprisonment for 1 month. He was also convicted for the offense punishable under section 3 of Dowry Prohibition Act and was sentenced to undergo simple imprisonment for 5 years and to pay fine of ₹1,14,000 and in default to undergo simple imprisonment for 3 months. He was convicted for the offense punishable under section 4 of DPA Act and sentenced to undergo simple imprisonment for 1 year, to pay fine of ₹2,000 and to pay for, and in default to undergo simple imprisonment for 1 month. It is also ordered that the fine amount collected by accused number 1 is to be out of the fine amount collected by accused number 1. The sum of ₹1,14,000 is to be paid to PW1 as compensation. However, the trial court acquitted accused number 2 and 3 for the offense. Being aggrieved by the same, accused number 1 challenged his conviction before the First Appellate Court in Criminal Appeal 83 of 2012. The First Appellate Court, on reappreciation of the materials on record, came to the conclusion that the prosecution is not successful in proving the guilt of the accused and accordingly allowed the appeal, set aside the impugned judgment of conviction, convicting the accused number 1. Being aggrieved by the same, the complainant is before this court. Heard so and so, so and so. Then counsel for respondent number 2 is absent and he has not, and his argument is taken as nil. Review the materials, including the trial court records. It is the specific contention of the prosecution that PW1 being the complainant married accused number one on 14/7/2002. This fact is not in dispute. It is the contention of the prosecution that accused number one had demanded dowry of rupees 1,20,000 at the time of marriage, and out of the same, 1,14,000 was paid by the complainant and her parents. To prove this contention, the complainant examined herself as PW1, her father as PW4, brother as PW5, an independent witness PW9, and her mother as PW10. Independent witness 9 and 13. All these witnesses consistently stated about the demand made by accused number one for dowry and receipt of rupees 1,14,000 on various dates as stated by them. Even though these witnesses were cross-examined at length, nothing has been elicited to disbelieve their version. The evidence of these material witnesses are consistent with regard to material particulars. Minor inconsistencies in the evidence is liable to be ignored as they do not go to the root of the matter. There is absolutely no reason as to why the independent witnesses have supported the case of the prosecution. It is pertinent to note that PW 11 and 12 have also spoken about the demand for a dowry, and PW 12 is the relative of the accused. Even though accused number one had stepped into the witness box and deposed as DW1, the version of the prosecution regarding demand and acceptance of dowry is not shaken by leading rebuttal evidence. Therefore, I am of the opinion that the prosecution is successful in proving guilt of accused number one for the offense punishable under section 3 and 4 of DPA Act, and he is liable for conviction. Next paragraph. The second contention taken by the prosecution is with regard to the treating of PW1 with cruelty. PW1 herself stepped into the witness box and deposed regarding ill treatment meted to her by the accused in general and by accused number one in particular. She states about the incident that had taken place on 13th and 14th of February 2007 and narrated in detail about the physical torture meted to her. Her contention was also reiterated by her father, mother, and brother, and also the other witnesses. It is pertinent to note that the statement of PW1 was recorded when she was admitted to Magan Hospital on 15/2/2007. The doctor who examined PW1 has issued the wound certificate as per Exhibit 11, which discloses that she had sustained as many as seven injuries, which are all simple in nature. However, the wound certificates fully corroborates the contention of PW1 that she was physically assaulted and tortured by accused number one. The author of Exhibit P11, that is the doctor working in the Magan Hospital, examined himself as PW17. Even though the witness was cross-examined at length, nothing has been elicited from him. the defense appears to be that in exhibit P11, PW17 has mentioned regarding the history of the injury as assault since for about a week. But it is the specific contention of PW1 that she was assaulted by PW1 on 13th and 14th of 2007, which is probabilized by exhibit P11 and evidence of PW15. PW1 and other prosecution witnesses have also spoken about the cruelty meted to PW1 on other occasions. There is absolutely no reason to disbelieve the version of the injured PW1 and PW5, the doctor who treated her on 15/2/2017. Next paragraph. It is pertinent to note that exhibit P15 is the next paragraph. Exhibit P15 is the copy of the birth certificate of a child on 14/9/2010, and the father being G. Raghavendra, who is said to be accused number 1, and mother being Shanta. PW1 categorically stated that accused number 1 had married one Shanta in second marriage and had begotten children. Exhibit P15 substantiates her contention in that regard. There is absolutely no explanation with regard to this document by PW1, by accused number 1. The cumulative effect of all these facts and circumstances necessarily go to show that the prosecution is successfully in proving the guilt of the accused for the offense punishable under section 498A of IPC as well. Therefore, accuser is liable to be convicted for the offense both under IPC as well as under DPA Act. Next. I have gone through the impugned judgment. I have gone through the judgment of conviction passed by the trial court. It has taken into consideration the oral and documentary evidence placed before it and had arrived at a right conclusion in convicting accused number 1 by holding that the prosecution is successful in proving the guilt of the accused number 1 and in acquitting the other accused. I have also gone through the impugned judgment of acquittal passed by the First Appellate Court. Even though the First Appellate Court referred to the evidence of various witnesses, it has given flimsy reasons for disbelieving the version of the prosecution, which cannot be sustained. When there are strong prima facie materials, such as wound certificate and the birth certificate of the child referred to have born to accused number 1 through his second marriage, which is coupled with the evidence of the injured PW1 and corroborated by the other prosecution witnesses, I do not find any justification for the First Appellate Court to ignore the clinching materials for the purpose of acquitting the accused. The First Appellate Court has given unreasonable weightage to the minor inconsistencies which resulted in grave injustice. Next, learned counsel for the appellant contended that even though the learned magistrate has passed an order for grant of maintenance, accused number 1 is successfully denying payment of maintenance amount, and thereby the complainant and her daughter are virtually in states, and they are at the mercy of others. Considering all these facts and circumstances, the conduct of accused number 1 appears to be not acceptable, and he is liable for conviction. Hence, I am of the opinion that the impugned judgment of acquittal passed by the First Appellate Court is liable to be decided. And the judgment of conviction and order of sentence passed by the First Appellate Court is liable to be restored. Accordingly, I answer the above point in the affirmative and proceed to pass the following. Appeal is allowed. Impugned judgment dated 3/3/2014, passed in criminal appeal number 83 of 2012 on the file of the learned principal district and sessions judge Davangere, acquitting the respondent number 2 is set aside. Consequently, the judgment of conviction and order of sentence dated 30th June 2012, passed in CC number 290 of 2007 on the file of the learned JMFC Honnali, convicting accused number 1 for the offense punishable under section 498A of IPC and 3 and 4 of DPA Act, and sentencing him with imprisonment and fine as stated supra is restored. Registry is directed to forward the copy of the judgment to the trial court for information and also for necessary action to secure the presence of accused number 1 and to deal with him in accordance with law. Yes, appeal is allowed. Trial court order, judgment is restored.
Much.
Serial number 17, V.S. Arbati, Manjunath AC.
Appeal arising out of not judgment of acquittal.
Then trap
Illa, raid. Disproportionate assets.
disproportionate. I will hear you at 2:30.
Very well.
Lord, I pray for 1 week time, Lord.
Okay.
Morning also I moved well. I want to take a senior.
Sir,
counsel.
disproportionate 2014, 10 years ಆಗಿದೆ.
Please, 1 week, I will ready to argue.
ಯಾವಾಗ ಕಂಪ್ಲೇಂಟ್ ಯಾವಾಗ?
Not 98. 98.
98.
FIR is 98.
ಅರ್ಧ ಕಾಲ್ ಶತಮಾನ ಮುಗ್ದಿದೆ.
Next week, Lord, I won't argue any date.
No further adjournment will be given.
Yes.
Learned counsel for the appellant is ready to address the argument. Learned counsel for respondent prays for time. He undertake to address his argument on the next date of hearing without fail. List on clear date ಕೊಡಿ, ಸ್ವಲ್ಪ ಕಡಿಮೆ ಇದ್ದೇನು ಕೊಡಿ. ಈಗ ಒಂದು ವಾರದಲ್ಲ, ಒಂದು 10 ದಿವಸ ಕೊಟ್ಟು. ಕೊಡಿ. Yes, date ಕೊಡ್ತಾರೆ. Yes. ಅವ್ರದ್ದೇನು? Mr. Vivacharya, which is your matter?
Matter, serial number?
Serial number 21.
516.
21.
21, my lord.
You are for the petitioner.
Petitioner.
Who is for the respondent? Only HCGP.
State is the respondent here.
State, only state is the respondent.
Only state.
Yes, only state is.
ಒಂದು ನಿಮಿಷ ತಗೊಳ್ತೀನಿ. Yes,
Please.
how much time you may require?
If your lordships agree with me, I am raising 2 points which are
Yes,
covered.
Please proceed. Who is the petitioner?
Petitioners, a company, my lord, which has got a mining lease. This is, my lord, manganese mining, not iron ore.
Okay.
Regarding which there is a lot of complications.
There are two accused.
Yes, sir. That is the partner and the person in charge of the mines.
It is a partnership firm.
Yes. They are from Bombay.
Yes.
This firm has been granted lease by the state government in the year 1971.
For how many years?
It was for periodical, but originally it was a large area. Then there was a revision to the government and all that. Half the area was given to another company, and I am given from 85, the present area, 79.64 acres.
79.
Right from
79.64 acres.
1985, then it was again renewed.
Yes.
In 2005, it is renewed for 20 years. And it will come to a close by after few months.
Yes.
Till 25. And my lord, because of the problem faced, my clients don't intend to continue. They want to surrender and go back.
Yes.
Now, all these years, my lord, there was absolutely no problem at all. They were carrying on their business properly. Somehow, in 2017, some people in the locality started giving trouble, and the forest department, mining department also started giving trouble, and I had to approach this honorable court at every stage, and this honorable court was giving me relief. Now, my lord, a private complaint is filed under 200,
Yes.
alleging offense under section 4 and 4A of the Act. According to me, my lord, no offense under 4 is there. Under section 4, the offense is you are having mining activity carrying on without a license. Admittedly, I have a license all through, and the lease is granted and renewed, my lord, by the state government itself. It is state government land with the approval of the central government also.
No, why section 4 and 4A are invoked?
Why section 4 and 4A are invoked?
Yes. No, 4 is
Mining operations to be under license.
under a license or lease.
Yes.
No, I have got a lease, registered lease.
No, what is the contention? What is the case made out by the prosecutor?
There is nothing. They just out of spite, because I approached this court and got it. The allegation is when they came for an inspection and they found out of these 79 acres, some good 30 guntas is encroached. And in outside the area, in 1 acre, some waste is dumped. These are the two allegations. Just for giving trouble, if I see the sequence, but my lord, I respectfully submit, it is unnecessary to go into the details because of two important legal points, my lord.
Yes.
Here, this, kindly see the order of the judge, my lord, at page 25.
Summons is issued.
Please,
Summons was issued.
no,
Ah.
check one.
Yes.
So on 29/12/17, complaint is filed, my lord. Complaint under section 200 presented by senior geologist Davanagere
Yes.
on 29/12/2007 for offense punishable under section 4(a) and 21. In fact, there is no subsection 4(a).
Hmm.
4 and 4(a).
Hmm.
4(a) separate section is there.
Yes.
That is termination of a mining lease by the government.
Yes.
So there is absolutely, one fails to understand what exactly is the point. Then, my lord, it says, complainant present and presented the complaint. Carried. Cognizance taken
Where is
order
it?
to register a special case and put up
Hmm.
on 30/11 and made over to additional judge. On 30/11 issue summons to accused.
Yes.
My lord, two important legal contentions I am urging, my lord, without going into details is, one is, my lord, it is settled law
Yes.
that under these enactment, my lord, though it was ordinary triable by magistrates, in view of the amendment, my lord, a special court is constituted, just like the Prevention of Corruption Act and
Yes.
Scheduled Tribes Atrocities Act, etc.
Yes.
Sessions judge alone is
Yes.
competent. But, my lord, unlike the Prevention of Corruption Act, this enactment doesn't provide for original jurisdiction to the sessions judge.
Yes.
Therefore, it has to be competent.
Yes.
The magistrate will have to commit the case to the session, then only the sessions judge can proceed with the matter.
Yes.
Now, here, this complaint, my lord, is straight away filed before the special judge. And this is the order he has passed. Two contentions. One is, it is wholly without jurisdiction because
There
it
is no
can't.
committal.
Yes.
There is no committal.
No
of-
complaint, they straight away, complaint dated 9/29, same day, cognizance is taken, summons issued.
Hmm. Yes.
The other is, my lord, total non-application of mine. Unlike a police report, my lord, where a detailed order is not necessary for taking cognizance in a private complaint under 200, my lord,
Yes.
the law is settled that it has to be at least application of mine, which section and what is the offense, at least very briefly indicating that is not there. So on these two grounds, my lord, this has to go.
Yes.
And this honorable court has held, if the special judge proceeds without jurisdiction,
Yes.
then the proper course is for the court, when it is pointed out, to return the complainant to the complainant so that he will present it before the jurisdictional magistrate who will commit the case. Is the ruling.
Yes.
No, my lord. This honorable court had considered this question in detail, my lord.
Yes. Good.
At page 62, my lord, the judgment starts.
Page number?
62.
Now, where is the beginning of the judgment?
Sir, 6-7.
I'm sorry, my lord. 6-7, 6-7.
6-7.
It looks like.
I'm sorry.
Yes.
At page 90, my lord. 990, para 28. Therefore, it is clear from the above that the sessions court designated as special court has no
No,
jurisdiction.
para number, paragraph number?
28,
Yes.
internal page 24.
Yes. 93.
Therefore, it is clear from the above, sessions court designated as special court has no jurisdiction to take cognizance directly for the offence under the MMDR Act and rules. The case can be tried only after committal proceedings, my lord. And my lord, at page 98 conclusion, the court had given guidelines wherever erroneously it has been done, what is to be done.
Yes.
At ink page 99, my lord,
Yes.
after a few lines, they also deal with the case of a police report, my lord, which is not permissible because it is to be complaint if it is MMRD Act.
Yes.
If any such complaint is erroneously received and pending, special court has to follow the procedure as contemplated under 201 and return the complainant for presentation to the proper court with an endorsement to the effect. Likewise, if any police report received, same has to be transferred. That's all. So this is a private complaint where it is erroneously received.
No, just now you read where it is in page number?
Which page number, sir?
Just now you read it. It is in page number?
Lordship, as it guidelines, my lords, it's.
Guidelines.
Influence, yes.
The first guideline, it overturns to the second page, my lords.
Hmm.
At the end of that, my lords, from bottom, 1, 2, 3, 5, 6. Seventh line from bottom, my lords.
Now, if
What's this? This one.
Melody, guidelines.
Yes.
Para 1. The special court constituted under the Act has no jurisdiction to take cognizance directly, offense under the MMRD Act.
Yes.
And KMMC rules.
Yes.
Even along with other penal offences unless the case is committed. It is made clear that special court has no jurisdiction to receive final report under 173 or receive any private complaint under MMDR Act directly from the authorized officer and take cognizance of offences either under the MMDR Act or other penal. If any such complaint is erroneously received and is pending, the special court has to follow the procedure as contemplated under section 201 and return the complainant to presentation for proper court with endorsement to that effect. Likewise, if any police report is received, so and so.
Yes.
Ours is only a complaint, my lord, There is no police report and
Yes.
no investigation. No, my lord, this judgment, my lord, was pronounced on 15/11/17, my lord.
Mm.
And present complaint is filed few days later on 29/12. Next month, 29/12.
outside.
Yes.
But my lord, then there is one. My lord, the second point I am urging is about the order taking cognizance, totally without application of mind, no reason, nothing.
Yes.
And nothing else. That will be more important in this case, my lord, because I have a duty, my lord, to bring to your lordship's notice the later judgment of the Supreme Court on this question, my lord.
Mm.
That is the one I have filed.
Yes. The first one,
Yes, first one.
Pradeep Wadiyar.
There, my lord, the Supreme Court agreed with the view that the special court under the MMDR Act has no power to
Yes.
take cognizance and proceed.
Mm.
But then they said it is only an irregularity,
Okay, then it can be cured.
which could be cured. And they said, where in that particular case, complaint, the revision or the 482 petition was filed before the High Court 2 years after the order of taking cognizance and issue of process, 2 years.
Yes.
Whereas here, I have filed, my lord, within 3 weeks of the date of taking cognizance. This criminal petition is filed on 18th of
January 2018.
Hmm?
January.
January 18th, date
19th January 2018.
19th January. 29/12 is the order of issue of process and
Where
take-
it is held, it is only an irregularity.
No, please see, my lord. Page 6/5, my lord, 6/5,
Yes,
conclusion,
yes.
because other portion, very lengthy judgment, so many points. First, 108(1).
Yes.
The special court does not have, in the absence of specific provision to that effect, the power to take cognizance of offence under the MMDR Act without the case being committed to it by the magistrate under section 209. Then the order of special judge dated so taking cognizance is therefore irregular. Then, my lord, they refer to section 465
Yes.
irregularity which can and all that. Then 108.3, my lord, 3. The decision in Gangula Ashok was distinguished in Rathiram based on stage of trial. The differentiation based on the stage of trial must be read with section 465(2). Section 465(2) does not indicate that only covers challenges to pre-trial orders after conclusion of the trial. The cardinal principle that guides 465 is that challenge to an irregular order must be urged at the earliest. This is the point. While determining if there was failure of justice, the court ought to address it with reference to the stage of this challenge, seriousness of the offense, and apparent intention to prolong proceedings along others. And then they say, in the instant case, cognizance order was challenged by the appellant 2 years after cognizance was taken. No reason was given to explain the inordinate delay. Moreover, in view of the diminished role of District Court has conferred to Swans. They did not wish to interfere. Then, my lord, 108, my lord, same page,
Yes.
item 108. Since the cognizance was taken by the special judge based on a police report and not a private complaint, it is not obligatory for the special judge to issue fully reasoned order if it otherwise appears that special judge has applied his mind on material. Now, on this question, my lord, at special page, my lord, I'll just point out one sentence, my lord. Page 52, my lord, page 52. Para C5, my lord, page 76.
Yes.
Counsel for appellant contended order special judge taking cognizance has not sufficiently demonstrated application of mind
Yes.
to the material on before him. To substantiate this, he relied on the following decisions. And the respondent argued that this court has made a distinction on application of mind by the judge for purpose of taking cognizance based on police report on the one hand and a private complaint under 200 on the other, and that the requirement of demonstrable application of mind in the latter case is higher. So in view of these enunciation, my lord, on these two principles, my lord, these two grounds, the order of taking cognizance has to be.
But when the Supreme Court held that it is only an irregularity, how can it be ordered to for a return of the complaint?
No, Supreme Court has not said that can't be done. They have said the stage of trial has to be seen and all that. No, my lord, in the life, my respectful submission is, I have a duty to bring to your lordship the latest ruling.
Yes.
But this doesn't go contrary to the principle laid down by the
Coordinate bench.
by the court, my lord. And on the facts of the case, my lord, I don't want,
Yes.
it is a case of sheer harassment. I can
Yes.
demonstrate that there is nothing in the case.
Milords, on the basis of the private complaint, Milords, it clearly shows that, Milords, there was an irregularities.
No, regarding here, the learned senior advocate has raised two technicalities. One is non-application of mind in taking cognizance. The other one is that the special court has no original jurisdiction.
Milords, the coordinate bench in that case, Milords, the coordinate bench has passed an order, Milords, in that in the cognizance arised in the jurisdiction, Milords. If suppose the file, the complaint has not arisen in the jurisdiction, Milords, it's not a relief sought for to quash the matter, Milords. The FIR contents
Not
may.
quash. He is not seeking that. He is seeking to quash the order taking cognizance by the learned sessions judge who has no original jurisdiction. That is one ground. Second one is there is non-application of mind.
Milords, in the complaint, private complaint, Milords, they have clearly stated, Milords.
He is not questioning that.
Please, Milords.
There is non-application of mind by the learned sessions judge.
I'll come up with a session, certain citations, Milords.
Citation ಏನು ಬರಲ್ಲ. ಇದು very
Irregularities.
clear case ಅಷ್ಟೇ.
Irregularities.
Clear case ಅಷ್ಟೇ. Yes, I will pass orders.
Please, please.
Petition is allowed ಅಂತ ಬರ್ಕೊಳ್ಳಿ. Petition is allowed.
Please.
Reasons for.
May I submit, Manu? List number 3, serial number 10. Rowdy sheeter, ನನ್ನೆಲ್ಲ ಮನೆ ಕ್ವಾಶ್ ಆಗಿದೆಯಂತೆ. It may have relevance for this anticipatory bill matter. Serial number 10, list number 3, my lord.
Yes, serial number 10.
Please, my lord.
Ah.
It seems therefore yesterday that rowdy sheeter case is quashed. So I've placed that it may have relevance for your lordship's consideration, my lords. Because that is the leg what the other side, I mean, intervener submitted.
Learned counsel for the petitioner prays for time to produce additional document to show that the proceedings And additional documents, just list down.
Obligation.
Serial number.
Next week anytime.
Serial, list number 2.
I'm sorry.
Yes, agenda.
List number 2, serial number 18, my lord, kindly have it taken up next week, my lord. So, well, my
Serial number
lord,
18.
18, my lord, kindly taken up next week, my lord, some personal inconvenience.
2015 matter, 9 years have lapsed.
Yes, no, small personal inconvenience, my lord, kindly next
Every
week.
day you will have
No,
personal
I'm
inconvenience.
seeking further adjournment, my lord, kindly next week, my lord.
You are for respondent.
I'm for the respondent, my lord.
Trap case idu.
Trap case, my lord. Kindly have it on next week, my definitely I'll do.
Counsel for respondent, 18.
18, my lord, say list number 2.
Counsel for, huh?
And one submission, my lord, literally, respondent advocate name showing my lord Rashmi Jadhav. Now she is additional SPP, my lord, kindly name showing Chetan Jadhav, my lord.
Whether he has filed wakalat?
Yes, my lord, I'll file wakalat in office.
Not yet filed.
File ಮಾಡಿದ್ದಾರೆ madam.
ನೀವು ಮಾಡಿರ್ಬೋದು ಅದೆಲ್ಲ ಬರಲ್ಲ. sir.
Kindly
You
next
have
week,
to
my
be-
lord, in case ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಅದು ನಾನು ಫೈಲ್ ಮಾಡಿಸ್ತೀನಿ, my lord.
Learned counsel Shri Chetan Jadhav submits that Rashmi Jadhav is no more representing the respondent, and the learned counsel undertake to file wakalat on behalf of the respondent, and also undertakes to address this argument on the next date of hearing without fail. The criminal appeal is of the year 2015. I do not find any reason to adjourn the matter. However, the undertaking given by the learned counsel is placed on record, list finally as the last chance. No further adjournment.
Please, my lord.
19, my lord. 18th I have.
You know, 18.
18th I have some person.
No, serial number 18.
Serial number 18.
Ah.
Post it on the 18th.
ಇಲ್ಲ ಇಲ್ಲ ಯಾರು ಹೇಳಿ
Date.
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ 18 ಸೀರಿಯಲ್ ನಂಬರ್ ನಾಟ್ ದಿ ಡೇಟ್
Date ಅಲ್ವಾ?
18 ಸಂಡೇ ಇನ್ಸಿಡೆಂಟ್ ಸ್ಪೆಷಲ್ ಸಿಟ್ಟಿಂಗ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ.
Serial number 27, my lords. ಒಂದು ವಾರ ಕಾಲಾವಕಾಶ ಬೇಕು.
ಯು ಆರ್ ಫಾರ್ ದಿ ಪಿಟಿಷನರ್.
Petitioner, sir.
ಇನ್ನು ಎಷ್ಟು ವರ್ಷ ಸರ್? 482 6 years ಆಗಿದೆ.
ಎಲ್ಲ ನಾನು ರೆಡಿ
ಯು
ಇದ್ದೇವೆ.
ಆರ್ ಎಂಜಾಯಿಂಗ್ ದಿ ಆರ್ಡರ್ ಇಂಟ್ರಿಯಂ ಆರ್ಡರ್.
ಅಲ್ಲ ಇಂಟ್ರಿಮ್ ಅದು ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಇಂಟ್ರಿಯಂ ಆರ್ಡರ್ ಇದೆ,
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆ.
ಅದನ್ನ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಲ್ಲ.
ಅಲ್ಲ ಒನ್ ಸಬ್ಮಿಷನ್ ಎನಿ ಡೇ ಇನ್ ದ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ರೀಸನ್ ಇಸ್
I will adjourn it.
ಅಲ್ಲ ಬಟ್ ಏನಂದ್ರೆ
As per your
ಅಲ್ಲ
convenience, but I will not extend the interim order.
I have come ready to argue the matter. One of my brother colleague is passed away. His body is dead body. ಅವರು ಹೆತ್ತೂರಿಗೆ ತಗೊಂಡು ಹೋಗ್ತಾ ಇದ್ದಾರೆ 3 o'clock.
Counsel
So
for
I have to-
petitioner.
1 week ಅಷ್ಟೇ ನಾನು.
ಹೌದಾ? ಫೈನಲಿ ಆಗೋಗಿದೆ. One or the other reason you will find.
ಇಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ it was first time it was came last time, my lord.
Please go through the order sheet.
Any
There
day-
was an undertaking to address the argument today.
My brother colleague had appeared that any day in the next week ನಾನು ಒಂದು ಡೆಡ್ ಬಾಡಿ ನೋಡಿ ಬರ್ಬೇಕಷ್ಟೇ. ಅದು ಕಾರಣ.
Counsel for the petitioner again
Sorry.
raised for time
Sorry for the inconvenience.
on personal grounds. Order sheet dated so and so reads as under. Petition is of the year 2018. I do not find any reason to adjourn the matter. However, to afford one more opportunity, list down. Next. First. Serial number.
ಮೇಡಮ್
ನಿಮ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟು?
ಇಂಟ್ರಿ ಮಾಡಿ ಕೊಡಲ್ಲ ನಾನು.
What? You will dictate later.
Again, one more question of law.
The session has no original, you can't take cognizance without being committed.
But ಒಂದು latest
ನೀವು ಹೇಳಿದ್ರ ಮೇಡಮ್ ಎಂಟ್ರಿ ಚೇಂಬರ್ ಅಲ್ಲಿ ಕೇಳ್ಕೊಂಬ ಸ್ವಾಮಿ ಒಂದ್ಸತಿ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ. ಸರ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಇದ್ರೆ
ನಾನು ಅದನ್ನೇ
ಅಲ್ಲ ಅಂಟಿಲ್ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಅಲ್ಲ ಅಂಟಿಲ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್.
Serial number 19. Nothing ಅಂತ ಹೇಳಿ ಅಲ್ಲ ಮಾಡಿ. Allowed. There is nothing.
Put up, sir. Put up, sir. Put up, sir.
Sir, ಹೇಳಿ sir.
Total serial number 21 ನಡೀತಾ ಇತ್ತು BB ಆಚಾರ್ ಮುಗೀತಾ ಅದು?
ಮುಗೀತು sir, ಮುಗೀತು.
ಯಾವ್ದು 20 ಯಾವ ತಗೊಳ್ತೀರಾ?
ಹೇಳ್ತೀನಿ sir, ಮೇಡಮ್ ಬರ್ಲಿ.
ಸಾರಿ ಹೇಳಿ ಬೇರೆ ಸೈಡ್ ಎಷ್ಟು ತಗೊಳ್ತೀವಿ ಇದೇ ಲಿಸ್ಟ್ ತಗೊಳ್ತಾರೆ.
ಮೇಡಮ್ ಬರ್ಲಿ, ಬಂದ್ಮೇಲೆ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ.
ಆಯ್ತು.
ಒಳ್ಳೆ ಕೇಸ್ 90 days ಒಂದು ವಾರ ಡಿಲೇ ನಾನು ಈಗ ಬೇಲಿ ಕಳಿಸ್ತೀನಿ ನೋಡಿದ ಒಳ್ಳೆ 162 ನಾನು ಹಾಕಿದ್ದೆ ಯಾಕೆ ಗೊತ್ತಾ ಅದು ಸೆಕ್ಷನ್ 90 days ಸಾಲ ಕೂಡ್ಲು ಮನೆ ಬೇಲ್ ಕೊಡ್ತಾರೆ ಅದನ್ನು ಫಾಲೋ ಮಾಡಿ ಈಗ ಮೊನ್ನೆ ಅಲಿಸಿಸ್ ಹೊಡಿಯಾಗಿ ಇದನ್ನು ಫಾಲೋ ಮಾಡಿ Article 21 gets delay ಅಂತ ಹೇಳಿ ಎಲ್ಲಿ 4 ವರ್ಷ ಇಲ್ಲೇ ಎಷ್ಟಾದ್ರು ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಮುಂದೆ ತಗೊಂಡು ಹೋಗ್ತಾ ಈಗ ಅದೇ ಆಗಿಲ್ಲ 6 ತಿಂಗಳು
These 230 matters, serial number 31, Maya Ola, BB Patil, Ramesh Chandra.
Petitioners counsel.
Filing the affidavit. And filing the affidavit of the principals.
Ordership.
Yes.
Please. Giving a list of dates, my lord. Synopsis.
It is already on record. This
Oh,
is the list.
Then it's all right. Lord, the Karnataka Milk Federation, my lord, petitioner, my lord, is the managing director, erstwhile managing director. He is now retired from service. It was, my lord, functioning from MG Road, my lord. It had a corporate office. It requested, my lord, serial number 3, my lord. On 22/11/1984, it requested state government to sanction a land to construct its corporate office.
Yes.
Pursuant to that, my lord, the government passed an order on 30/3/1998, granting 4 acres, 14 guntas of land in survey number 234 and 71 of Koramangala village.
Yes.
There were no precondition laid by the government while sanctioning the land that KMF, my lord, saying that you shall not do this or do that. Annexure C, page 55, my lord, if you are just have a look at the document. No imposition of any condition. In fact, my lord, I will also point out under law, whatever, my lord, they do also is of no consequence. Please come to, my lord, page 55. This was, my lord, the order of the government. Annexure C, page 55, my lord. ಸರ್ಕಾರದ ಓದಲಾದ ದಿನಾಂಕ 25/7/86ರಲ್ಲಿ ಪತ್ರದಲ್ಲಿ ಕರ್ನಾಟಕ ಸಹಕಾರಿ ಹಾಲು ಉತ್ಪಾದಕರ ಮಹಾಮಂಡಳಿ ನಿಯಮಿತ ಬೆಂಗಳೂರು ಇವರಿಗೆ ಬೆಂಗಳೂರು ಕೋರಮಂಗಲ ಸರ್ವೆ ನಂಬರ್ 234 ಹಾಗೂ 71ರಲ್ಲಿ ಒಟ್ಟು 4 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನನ್ನು ವರ್ಗಾಯಿಸುವಂತೆ ಇದರ ಬೆಲೆಯನ್ನು ಪಡೆಯುವ ಬಗ್ಗೆ ಪ್ರತ್ಯೇಕ ಆದೇಶ ಹೊರಡಿಸಲಾಗುವುದು. ಮುಖ್ಯ ಇಂಜಿನಿಯರ್ ಸಂಪರ್ಕ ಮತ್ತು ಕಟ್ಟಡ ದಕ್ಷಿಣ ಇವರಿಗೆ ಸೂಚಿಸಲಾಗಿತ್ತು. ಮೇಲ್ಕಂಡ ಜಮೀನನ್ನು ಈವರೆಗೂ ಸ್ವಾಧೀನಕ್ಕೆ ನೀಡಿಲ್ಲವಾದ ಕಾರಣ ಸದರಿ ಜಮೀನನ್ನು ಸ್ವಾಧೀನಕ್ಕೆ ನೀಡಲು ನಿರ್ದೇಶಕರು ಕರ್ನಾಟಕ ಸಹಕಾರಿ ಹಾಲು ಉತ್ಪಾದಕರ ಮಹಾಮಂಡಳಿಯವರ ಮೇಲೆ ಕ್ರಮಾಂಕ 2ರಲ್ಲಿ ಓದಲಾದ ದಿನಾಂಕ 4/2/98 ಪತ್ರದಲ್ಲಿ ಸರ್ಕಾರವನ್ನು ಕೋರಿರುತ್ತಾರೆ. ಅಧೀಕ್ಷಕ ಇಂಜಿನಿಯರ್ ಕಟ್ಟಡಗಳ ವೃತ್ತ ಬೆಂಗಳೂರು ಅವರು ಮೇಲೆ ಕ್ರಮಾಂಕ 3ರಲ್ಲಿ ಓದಲಾದ ದಿನಾಂಕ 11/3/98 ಪತ್ರದಲ್ಲಿ ಕೋರಮಂಗಲದಲ್ಲಿ ಜಮೀನಿನ ಉಳಿಕೆ ಬಗ್ಗೆ ಈ ಕಂಡಂತೆ ಮಾಹಿತಿ ನೀಡಲಾಗಿರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ ಟೋಟಲ್ ಇಸ್ 4 acres 14 guntas. ಮೇಲ್ಕಂಡ ಜಮೀನಿನಲ್ಲಿ ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರವು 80 ಅಡಿ ಅಗಲದ ರಸ್ತೆ ನಿರ್ಮಿಸುತ್ತಾರೆ. ಸರ್ಕಾರಿ ಆದೇಶ ನಂಬರ್ ಸೋ ಪರಿಶೀಲಿಸಲಾಯಿತು. ಬೆಂಗಳೂರಿನ ಕೋರಮಂಗಲ ಕೆಳಕಂಡ ಸರ್ವೆ ನಂಬರ್ ಒಟ್ಟು 4 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನನ್ನು ಕರ್ನಾಟಕ ಸಹಕಾರಿ ಹಾಲು ಉತ್ಪಾದಕರ ಮಹಾಮಂಡಳಿ ನಿಯಮಿತ ಬೆಂಗಳೂರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಲಾಗಿದೆ. ಮೇಲ್ಕಂಡ ಜಮೀನಿನ ಬೆಲೆಯನ್ನು ಹಿಂದೆ ನಿಗದಿಪಡಿಸಿದಂತೆ ಪ್ರತಿ ಎಕರೆಗೆ 50,000 ರೂಪಾಯಿಗಳಿಗೆ ನಿಗದಿಪಡಿಸಿದೆ. ಮೇಲ್ಕಂಡ ಜಾಗದ ಕೊಳಚೆ ನೀರು ಹರಿದು ಹೋಗಲು ಕೋರಮಂಗಲದಲ್ಲಿ ನಿರ್ಮಿಸಬಹುದಾದ ಚರಂಡಿ ಮೋರಿಗೆ ಹಾಗೂ ಇತರೆ ಅಭಿವೃದ್ಧಿ ಶುಲ್ಕದ ವೆಚ್ಚವನ್ನು ನೀಡುವ ಷರತ್ತಿಗೆ ಒಳಪಟ್ಟಿರುತ್ತದೆ. The only condition, my lord, that was imposed was that, my lord, drain and, my lord, whatever, my lord, drainage is required to be done, whatever the development charge, my lord, that has to be paid. ಈ ಆದೇಶವನ್ನು ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯ ಆರ್ಥಿಕ ಕೋಶದ ಅನಧಿಕೃತ ಟಿಪ್ಪಣಿ ನಂಬರ್ ಸೋ ಡೇಟೆಡ್ 7/10/86 ಅನ್ವಯ ಹೊರಡಿಸಲಾಗಿದೆ. In furtherance of, sorry.
Whether it is a lease or license.
My lord, grant, my lord, there is a sale deed. My lord, please come to, my lord, running page. My lords get that. And, my lord, one minute, my lord. I'll just tell you, lordship. ಅಷ್ಟೇ, ಇದಷ್ಟೇ ಗ್ರಾಂಟ್ ಮಾತ್ರ, ಅದ್ರಲ್ಲಿ ಮತ್ತೇನಿಲ್ಲ ಅದರಲ್ಲಿ. ಸಾರಿ, ದೇರ್ ನೋ ಲೀಸ್, my lord, ಸೇಲ್ ಡೀಡ್, my lord. I'm sorry, I stand corrected. It is granted subject to the condition that, my lord, I will, my lord, pay the charges, my lord, for drainage and development charge, my lord, in connection therewith. This is the only, my lord, condition that they had imposed. Thereafter, my lord, what happened was, my lord, we gave, my lord, this page 65, if your lords come to, my lord, sorry, page 65, 65, a board of KMF, my lord, passed a resolution, 65, my lord.
Yes.
NDDB, my lord, National Dairy Development Corporation, the central government organization. Serial number, my lord, my lords get that at serial number 6 of my list of dates. In terms of the 131st board meeting of KMF, resolved to entrust the National Dairy Development Board the responsibility of construction of the corporate office of KMF on the scheduled property. In furtherance of the above resolution, KMF entered into an agreement with NDDB regarding construction of the corporate office of the scheduled property at a cost of 167.29 lakhs, and the work order was issued in this regard. This is, my lord, the resolution at page 65. In furtherance of the above, KMF entered into an agreement with NDDB for construction of the corporate office of the scheduled property at a cost of 167.29 lakhs. Work order was issued in this regard. My lord, the KMF requested BBMP, serial number 7, my lord, to approve the building plan and grant license, and BBMP informed KMF to hand over the, to get the land converted for commercial purpose. Accordingly, KMF approached BDA seeking conversion of the land for commercial use. On 25/7/2001, BDA by its order dated 25/7/2001 accorded approval for the said conversion and permitted utilization of the scheduled property for commercial purpose, and BBMP, my lord, issued the license. Page 66 and 68, my lords get that, my lord. 68 is, my lord, the sanction plan. BBMP, my lord, has issued the sanction plan. My lords get that on the right column, my lord. Right hand alli, a last column alli baratte, my lord, my signature of the authorized, my lord, sorry. Director Technical Planning, Assistant Director Technical Planning, Bangalore Mahanagara Palike, my lord, has approved of this plan. Thereafter, my lord, we, my lord, had given this authority to NDBB to construct.
Yes.
Notwithstanding that, though, my lord, more than, my lord, the 3 years lapsed, NDDB, my lord, did not construct. Serial number 9, my lord, if your lords look at my list of dates. By this time, KMF had already constructed. My lord, what happened was there was an enormous delay in, my lord, getting the approvals, all that. By this time, my lord, we were in dire need of a corporate office. Therefore, my lord, by this time, KMF had already constructed its own building for housing its corporate office behind Bangalore Bangalore Dairy under the Dairy Development Project funds. Allocation of said building was logistically convenient for KMF to carry on its activities. Since the scheduled property was vacant, there were several attempts to trespass and encroach upon the scheduled property by encroachers, land grabbers, and erstwhile landowners. As a result of which several police complaints were lodged. One such police complaint is at page 72, my lord, where there were some encroachers, my lord, into this property, my lord. There were several of them. One such, my lord, complaint, my lord, we have placed before your lordships. Koramangaladalli, my lord, page number 72. My lords get the 73 nalli, my lord, typed copy hakidi.
Yes.
Koramangala survey number 71, 2, 3 ಮತ್ತು 4 ಒಟ್ಟು 4 ಎಕರೆ 14 ಗುಂಟೆ ನಿವೇಶನವನ್ನು ಕಹಾಮಕ್ಕೆ, ದಟ್ಸ್ ಮೈ ಲಾರ್ಡ್ ದ KMF, ವಹಿಸಿಕೊಡಲು ಸರ್ಕಾರದ ಆದೇಶವಿದ್ದು, ಅದರಂತೆ ಕಹಾಮ ನಿವೇಶನದಲ್ಲಿ ಸರ್ವೆ ಇಲಾಖೆಯವರು ನಿಗದಿಪಡಿಸಿದ ಚೆಕ್ಕುಬಂದಿಯಲ್ಲಿ ನಕ್ಷೆಯನ್ನು ಲಗತ್ತಿಸಲಾಗಿದೆ. ಶಾಶ್ವತ ತಡೆಗೋಡೆ ನಿರ್ಮಾಣಕ್ಕೆ ಕ್ರಮ ಕೈಗೊಂಡಿದ್ದು, ನಮ್ಮ ನಿವೇಶನದಲ್ಲಿ ಶಾಶ್ವತ ತಡೆಗೋಡೆಯ ನಿರ್ಮಾಣ ಮಾಡುತ್ತಿರುವ ಸಂದರ್ಭದಲ್ಲಿ ಪಿಳ್ಳಾರೆಡ್ಡಿ ನಂಬರ್ 1 ಅಣ್ಣೆರೆಡ್ಡಿ ರೆವಿನ್ಯೂ ನ್ಯೂ ತಿಪ್ಪಸಂದ್ರ ಬೆಂಗಳೂರು 75 ಇವರು ನಿವೇಶನದಲ್ಲಿ ಕೆಲಸ ಮಾಡಲು ಅಡ್ಡಿಪಡಿಸುತ್ತಿದ್ದಾರೆ ಹಾಗೂ ದಿನಾಂಕ 6/3/98ರಂದು ಕೆಲಸಗಾರ ಶೆಡ್ಡಿಗೆ ಬಂದು ಬೆದರಿಸಿರುತ್ತಾರೆ. ತಾವು ದಯಮಾಡಿ 2-3 ಮಂದಿ ಪೊಲೀಸ್ ಸಿಬ್ಬಂದಿಯನ್ನು ಕಹಾಮ ನಿವೇಶನದಲ್ಲಿ ನೇಮಿಸಿ ತಡೆಗೋಡೆ ನಿರ್ಮಾಣ ಕಾರ್ಯಕ್ಕೆ ತೊಂದರೆಯಾಗದಂತೆ ರಕ್ಷಣೆ ನೀಡಬೇಕೆಂದು ಮನವಿ ಮಾಡುತ್ತೇವೆ. ಕಹಾಮ ನಿವೇಶನದ ದಾಖಲೆಗಳ ಪ್ರತಿಯನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಲಗತ್ತಿಸಲಾಗಿದೆ. Then, my lord, what happened was, there was, my lord, a resolution. Ultimately, my lord, we can't, my lord, keep the land vacant. So, in furtherance of that, my lord, the serial number 11, my lord, in furtherance of the resolution of the board, managing director initiated action, my lord, there was a KMF, my lord, resolution was passed for, my lord, giving the property on lease, on long-term lease, so that, my lord, the KMF, my lord, gets some income. In furtherance of the resolution of the board, KMF director initiated action for appointment of a consultant to guide KMF for grant of lease of the scheduled property on long-term basis for commercial purpose. In this regard, one Wilbur Smith Private Limited was appointed as the consultant. Page 76 ali tamak sigute. He was, my lord, appointed. Then, as per the advice tendered by the said consultant, tenders were invited in accordance with the provisions of the Karnataka Transparency in Public Procurement Act of 1999. Advertisements are released in daily newspaper Hindu and Kannada Prabha, inviting bids for taking the scheduled property on long-term lease for commercial purpose, which was also sent to the state tender, my lord, bulletin board. Please look at, my lord, page 77 of the judgment, my lord, compilation of documents, if you allot to stay. Advertisements, my lord, there were advertisements in the newspaper. We called for, my lord, tenders in terms of the Transparency Act, which is, my lord, mandatory. And, my lord, the person, my lord, who gave us, my lord, the highest was, my lord, one PVK Infrastructure Private Limited. And we, my lord, granted, my lord, he offered 40 lakhs per quarter. So, my lord, that aggregates about 1 crore, my lord, 20 lakhs per year. Yes. My lord, tender process iddu innond separate adralli hakidevu. My lords get that on 10/10/2023. We have produced, my lord, all the documents pertaining to the tender process. Nodi, court of alli idea 10/10 alli. Filed in open court.
Yes.
My lords got that one. Please come to, my lord, page 14. Sorry, page, my lord, 3. Sorry. 14, 3. Wilbur Smith, my lord, was appointed as a consultant. Karnataka Milk Federation pleased to accept your offer for providing consultancy services to the property development of KMF land at Koramangala. You have been appointed as technical consultant. We request you to enter into a contract agreement with KMF containing the scope and consultancy services as discussed here and above. Then, my lord, he gives us a feasibility study presentation, page 4 onwards.
Feasibility for what?
My lord, what to do, my lord, about this land? How to go about for leasing the property? Because the board resolution was passed, my lord, saying that it should be leased. Otherwise, my lord, there are persons, my lord, who are coming, and in fact, same thing happened. My lord, we had some land, KMF had some land, my lord, near Rajajinagar. Even now, my lord, one case is pending before the division bench. There are, my lord, encroachers. They keep, my lord, any land in Bangalore, if there's a vacant land, my lord, encroachers come. So, my lord, we had no choice but to, my lord, give it on lease so that, my lord, we get an income and the land is protected. Now, my lord, please come to, my lord, the advertisement that we have kept. Please come to page 23, my lord. We put advertisements in the paper. 23 idrallene. One was, my lord, in Hindu, another, my lord, in Kannada Prabha. There were, my lords may turn to, my lord, page 24. There were 7, my lord, applicants, bidders. My lords get at the bottom, my lord, 2 anta baratte. GK, my lord, contractors, Cochin, Vijay Kumar, PVK, Bangalore, Ansal Housing and Construction, New Delhi, GBR Constructions, Hyderabad, Madhukan Projects Limited, Hyderabad, Wonderla Holidays Private Limited, Bangalore, Shilpi Constructions, Cochin. So, my lord, tender, we invited them, they came, and the highest bid, my lord, that was given, my lords get that at page 27 onwards. $40 lakhs, my lord, was the highest bid, my lord, which was offered by the PVK Constructions. And ultimately, my lord, his bid was accepted. Tender evaluation report, my lords, get that at page 39. 39, my lord. Sorry.
No, highest bidder is serial number 3, is it?
Yes, ma'am. And my lords may look at, my lord, page. There was a tender, my lord, scrutiny, all that in accordance with the tender, my lord, the Transparency Act, page 39 bandre. Entire thing, my lord, was in a transparent manner. Please come to, my lord, page 47. 47 which are the bids, my lord, which had been given. Two of them, my lord, got disqualified out of that, 7 only 3 got disqualified. 4, my lord, remained. Ansal, my lord, offered 25.50 lakhs per annum, per quarter. GVR, my lord, 18.50 lakhs. Infra PVK, my lord, 36 lakhs. And Shilpi Constructions, my lord, 22 lakhs. And all of them, my lord, are there. Then, my lord, there was again, my lord, my lord, bid. Ultimately, my lord, they offered 40 lakhs. My lords get that at page 53. 53 36, my lord, is what he had quoted, my lord. After negotiation, my lord, he agreed to offer 40. And that was the highest. Ultimately, my lord, we issued a letter of acceptance at page 55. 55. Then, my lord, that sale deed I had said, my lord, sale deed, my lords, get that at page 93 of the main petition, my lord. 93 of the main petition, my lords may come to. Sale deed there very low. If your lords just look at this, my lord, please come to, my lord, running page 99. There is no condition. It's an absolute sale. Where is it? My lords may come to, my lord, page. It starts at, my lord, page 93. 99 bandre. Accordingly, now this deed of conveyance witnesseth that in person the foregoing consideration of sum of rupees so and so paid by KMF on demand so and so, receipt of which government hereby accepts and acknowledges and acquits KMF therefrom. Government as absolute owner hereby grants transfers and conveys unto KMF by way of absolute conveyance. My lord, please mark this. I'll tell you, lords, is why. Paragraph, my lord, section 10 and 11 of the TP Act will have some bearing. All that 4 acres, 14 guntas of land, that is 1 acre, my lord, in survey number 2, 32, 1 acre, 27 guntas in survey number 2, 32 guntas in survey number 3, 27 guntas in survey number 4, 1 acre, 8 guntas in survey number 71, including 80 feet road of the then Koramangala village, Bangalore South. So and so, which are more fully described in the schedule here under written, and hereinafter referred to scheduled property, together with all rights, easement, privileges, appurtenance thereto, to have, to hold, build upon, and to enjoy the same by the purchaser KMF as absolute owner. Then, my lord, please turn the page over. Government confirms having delivered vacant possession scheduled property to KMF. Government hereby covenants with KMF as follows. KMF shall be entitled to hold, possess, build upon, enjoy the scheduled property hereby sold to it, and the rents and profits received therefrom, my lord, please mark this. I can even, my lord, rent it out. And the rents and profits received therefrom, without any disturbance or interference by the government or any other person or authority, claiming through or under it, that the government title to the scheduled property hereby conveyed is good, marketable, and subsisting, that it has power to convey the same. Scheduled property is free from all encumbrance. There are no attachments, acquisition, court, or other proceedings in respect to it. That the government shall, upon request of KMF, do and execute or cause to be done or executed all such acts, deeds, and things or whatsoever, for further and more perfectly assuring the title sums.
Why this clause?
That, my lord, is the normal clause, my lord, which is always put for, my lord. For Yella sale deedಗಳು ನಾವು ಹಾಕ್ತೀವಿ ಅಂದ್ರೆ ಮುಂದೆ ಏನಾದ್ರು ಬೇಕಾದ್ರೆ ಅದನ್ನು ಮಾಡಿ ನೀವು ಅಂತ ಹೇಳಿ ಸೆಲ್ಲರಿಗೆ. Even otherwise, my lord, can I persuade your lords, look at, my lord, the TP Act, Transfer Property Act ಇದೆಯಮ್ಮ. ಒಂದು ನಿಮಿಷ ಕೊಡಿ. Please look at, my lord, section 10 of the Transfer of Property Act. And 11. Sorry, 11th, 10 ಬೇಕಾಗಿಲ್ಲ, 11, my lord, if your lordship sees, where on a transfer of a property, an interest thereon is created absolutely, my lords have seen. Idralli, paragraph, my lord, 1, that is, my lord, Roman 6 at page 99, they transfer it absolutely. Section 11, my lord, of the TP Act, where on a transfer of property, an interest therein is created absolutely in favor of any person, but the terms of transfer direct that such interest shall be applied or enjoyed by him in a particular manner, he shall be entitled to receive and dispose of such interest as if there were no such direction. Where, subpara 2, my lord, where any such direction has been made in respect of one piece of immobile property for the purpose of securing beneficial enjoyment of another piece of such property, nothing in this section shall be deemed to affect any right which the transferor may have to enforce such direction or any remedy which he may have in respect of breach thereof. The second one doesn't apply because there's no other property, my lord. What happens is, supposing, my lord, there is one more property and, my lord, avರಿಗೆ access ಕೊಡಬೇಕು, ನಿಮ್ಮಿಂದಾನೇ ಕೊಡಬೇಕು, ಆ ಥರ ಇದ್ದಿದ್ರೆ there can be, my lord, some embargo or restriction. Otherwise, when an absolute sale is made, there cannot be anything. Now, my lord, what happened was, the lease deed, my lord, we executed a lease deed as well, my lord. Please come to, my lord, page 115, 115 of the main petition. In favor of, my lord, PVK, my lord, please look at when was it executed? In the year 2008, 29th of May 2008, my lord. Lease deed is executed. My lords get that at page 18 of my list of dates. Sale deed, my lord, 16 ಅಲ್ಲಿ ಹಾಕಿದ್ದೇನೆ. I'm sorry, my apologies, my lord. ನಾನು ಇದರೆಲ್ಲ ಇಲ್ಲೆಲ್ಲೋ ಇವ್ರು ನೋಟ್ಸ್ ಮಾಡಿದ್ರು ನಮ್ಮ, ನಾನು ಮಿಸ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡು.
No reference to the sale deed.
ಅಲ್ಲ, ಇದರೊಳಗೆಲ್ಲ ಇದೆ.
The dates and events.
Dates and events ಅಲ್ಲೂ ಹೇಳಿದೆ ನೋಡಿ. ತಾರ 16 ತಗೊಳ್ಳಿ. Serial number 16. Page 5.
Yes.
KMF requests BW to execute the conveyance. Then, my lord, serial number 17. On 19/5/2008, state government executed registered deed of conveyance in favor of KMF. Said deed empowers KMF to enjoy the property without any interruption, with absolute power to deal with the property.
Yes.
Then, my lord, we gave this. More important is, we have been, my lord, receiving the rents. I retired, my lord, in the year 2015. I, my lord, am bound by what the board resolution says. I am only a part of the board. After 9 years, my lord, serial number 21, 2008, there is a lease. On 19/5/2017, after a lapse of 9 years after the lease of the scheduled property, one Sai Datta, the third respondent, my lord, today he is no more. He was an interloper, my lord, RTI, filed a complaint with the Anti-Corruption Bureau, alleging cheating by the third parties and corruption by the board, managing directors and PW officials working in the year 2007 and 8, resulting in huge loss to KMF and the government. In furtherance of said false complaint, FIR was registered by ACB. Entire complaint is motivated and malafide complaint, garnered to get undue publicity. Therefore, my lord, we filed this petition. Ultimately, my lord, your lordships granted an interim order, and that has been continuing. My submission to your lordships is, very fact, my lord, there is a delay of, my lord, more than 9 years. Is a ground, my lord, to quash, my lord, the complaint. Can I pass on, my lord, one compilation of judgments for my lord's consideration, my lord?
Who are they accused in that case?
Please, my lord.
Who are they accused in this case?
Only the managing director of KMF, my lord. Not even where direct. Please look at, my lord, if your lords has come to the FIR, my lord. My lords get that. Sorry. Annexure, my lord. Z at running page. ಏನಮ್ಮ? 167, correct. Thank you. 167 ತಾವು ಬಂದ್ರೆ the complaint lodged, my lord, is at page 165. 2017 ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಲಾಂಚ್ ಮಾಡಿದ್ದಾರೆ. FIR is at page 167. Serial number 22 ನಾನು ಬರ್ದಿದ್ದೀನಿ. My lords, get that at serial number 22 of my list of dates.
Yes.
FIR ಹಾಕಿದ್ದೀನಿ, complaint is serial number 21.
Yes.
Therefore, my lord, I lodge this complaint. Please come to my lord page 168. ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಇವರ ವಿರುದ್ಧ my lords get at page 168, serial number 6, ಮೂರನೇ ಲೈನ್ 2007 ಮತ್ತು 2008. my lord, this complaint is lodged in 2017 after a lapse of 9 years, 10 years. 2007-8 ರಲ್ಲಿ KMF ನ ಆಡಳಿತ ಮಂಡಳಿ ಹಾಗೂ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು is my lord the managing director, and ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯ ಅಂದಿನ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು, ಕಟ್ಟಡದ ವಿಭಾಗವಾದ ಇತರೆ ಅಧಿಕಾರಿಗಳು. My submission to your lordship is, my lord, the very fact that this complaint is lodged after a lapse of, my lord, 9 or 10 years itself is a sufficient ground, my lord, to quash the complaint. Can I, sorry.
No, what is the allegation in this?
My lord, allegation is, please come to my lord page. Our complaint to, my lords get that at my lord running page 166, 65.
69 ಅಲ್ಲ.
65. Complaint is at page 165, my lord. If I am not mistaken, my lord, unless there's some pagination error. If there is, my lord, your lords may pardon me.
65.
65. ಅದನ್ನು ಹಾಕಿದ್ದೇನಲ್ಲಿ, my lords get that in the list of dates, serial number 21. My lord, allegation is, sorry.
Yes.
The allegation, my lord, please permit me to read, my lord, the complaint. ಕರ್ನಾಟಕ ಸಹಕಾರಿ ಹಾಲು ಉತ್ಪಾದಕರ ಮಹಾಮಂಡಳಿ ರಾಜ್ಯ ಸರ್ಕಾರಕ್ಕೆ ಸೇರಿದ 200 ಕೋಟಿ ಬೆಲೆ ಬಾಳುವ, my lord, ಇವತ್ತಿನ ದಿವಸ it may be worth, my lord, about 20 crores. 200 ಇಲ್ಲ. I remember, my lord, when I came to Bangalore 1961, I was still a boy of 10 years. ಟಿ ಕೃಷ್ಣರಾವ್ ಅಂತ ಹೇಳಿ ಅಡ್ವೊಕೇಟ್ ಜನರಲ್ ಇದ್ರು. ನಮ್ಮ ಫಾದರು ವಾಸ್ ಆಲ್ಸೋ ಎ ಲಾಯರ್, my lord, ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್. ಅವ್ರಿಗೆ ಹೇಳೋರು, ನಾನು ಇಲ್ಲಿ ಬರ್ತಾ ಇದ್ದೀನಿ ರಾಜ್ಕುಮಾರ್ ಮನೆ ಹತ್ರ, my lord, ಪ್ಯಾಲೇಸ್ ಆರ್ಚರ್ಸ್ ಅಲ್ಲಿ, ದಯವಿಟ್ಟು ಬನ್ನಿ. 100/120, my lord, 18,000, ₹1,200. ಅವ್ರು ಹೇಳೋರು, ನಮ್ಮ ತಂದೆಯವ್ರು ಇಲ್ಲ ಡೆಕಾಯ್ಸ್ ಬರ್ತಾರೆ ಇಲ್ಲಿ, ಬರೋದಿಲ್ಲ ಅಂತ ಹೇಳಿ ನಾವು 30 ವರ್ಷ ಬಾಡಿಗೆ ಮನೆಯಲ್ಲಿ ಇದ್ವಿ. ಇವತ್ತಿನ ದಿವಸ ಇಟ್ ಈಸ್ ವರ್ತ್, my lord, more than 50 crores. ಇದು 200 ಕೋಟಿ ಅಂದ್ರೆ ದಿಸ್ ಇಸ್ ನಾಟ್ 200 ಕೋಟಿ. ಎನಿವೆ, ಮೈ ಸಬ್ಮಿಷನ್ ಇಸ್, ಈ ತರದೆಲ್ಲ ಮಾಡಿ ಕರ್ನಾಟಕ ಹಾಲು ಉತ್ಪಾದಕರ ಮಹಾಮಂಡಳಿ ರಾಜ್ಯ ಸರ್ಕಾರಕ್ಕೆ ಸೇರಿದ 200 ಕೋಟಿ ಬೆಲೆ ಬಾಳುವ ಕೋರಮಂಗಲದ 4 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನನ್ನು ಬಿಲ್ಡರ್ಗಳ ಜೊತೆ ಸೇರಿಕೊಂಡು ನಿಯಮ ಉಲ್ಲಂಘಿಸಿ ಭ್ರಷ್ಟಾಚಾರಕ್ಕೆ ಪರಬಾರೆ ಮಾಡಿದ್ದು ಈ ಕೂಡಲೇ ಬಗ್ಗೆ ತನಿಖೆ ಮಾಡಿ ಸಂಬಂಧಪಟ್ಟವರನ್ನು ಬಂಧಿಸುವಂತೆ ಒತ್ತಾಯಿಸುತ್ತೇನೆ. 1984ರಲ್ಲಿ KMF ಅಧ್ಯಕ್ಷರಾಗಿ KB ಮಲ್ಲಪ್ಪನವರು ರಾಜ್ಯ ಸರ್ಕಾರಕ್ಕೆ ಪತ್ರ ಬರೆದು MG ರಸ್ತೆ ಖಾಸಗಿ ಕಟ್ಟಡವೊಂದರಲ್ಲಿ KMF 46,000 ರೂಪಾಯಿ ಬಾಡಿಗೆ ನೀಡಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಸರ್ಕಾರದಿಂದ ಜಾಗ ಕೊಟ್ಟರೆ ಸ್ವಂತ ಕಟ್ಟಡ ಕಟ್ಟಬಹುದೆಂದು ಮನವಿ ಮಾಡಿದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ರಾಜ್ಯ ಸರ್ಕಾರ ಕೋರಮಂಗಲ ಸರ್ವೆ ನಂಬರ್ 234 ಹಾಗೂ 71ರಲ್ಲಿ 4 ಎಕರೆ 14 ಗುಂಟೆ ಜಮೀನನ್ನು ಸರ್ಕಾರಿ ಆದೇಶದ ಮೂಲಕ ಮಂಜೂರು ಮಾಡಿರುತ್ತೆ. 19/5/2008ರಂದು ಕ್ಯಾಬಿನೆಟ್ ಅನುಮೋದನೆ ಇಲ್ಲದೆ PWD ಇಲಾಖೆ KMF 4 ಎಕರೆ 14 ಗುಂಟೆ ಜಾಗವನ್ನು ಬೊಮ್ಮನಹಳ್ಳಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಕಚೇರಿಯಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಲಾಗುತ್ತದೆ. ಅಚ್ಚರಿ ಎಂದರೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ ಕೆಲವೇ 10 ದಿನಗಳಲ್ಲಿ ಜಾಗವನ್ನು ಪರಭಾರೆ ಮಾಡಲಾಗುತ್ತದೆ. My lord, if your lords recollect, grant, my lord, was made in the year, my lord, 19, my lord, 98.
83,
Grant 98. Execution of the sale deed, my lord, was in the year 2008. 10 ವರ್ಷ ನಂತರ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು ಸೇಲ್ ಡೀಡ್. But they put us in possession, collected the entire sale consideration, So 10 ದಿನಗಳಿಗೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ 10 ದಿನಗಳಲ್ಲಿ, but then the entire process was long back. Then last paragraph ದಿನಾಂಕ 29/5/2008 KMF PBK ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಎಂಬ ಕಂಪನಿಗೆ ಜಾಯಿಂಟ್ ವೆಂಚರ್ ಇದನ್ನು ಪರಭಾರೆ ಮಾಡುತ್ತದೆ. ನಂತರ ಹಲವು ಕಂಪನಿಗಳಿಗೆ ಈ ಜಾಗ ಪರಭಾರೆಯಾಗುತ್ತದೆ. PVK ನಂತರ ಜಾಗವನ್ನು ಹಾಸ್ಕೋ ಕಂಪನಿಗೆ, ನಂತರ PVK ಕೋರಮಂಗಲ ಎಂಬ ಕಂಪನಿಗೆ, ಹಿಂದೂಸ್ತಾನ್ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಕಂಪನಿಗೆ, ಅನಂತರ ಮಂತ್ರಿ ಹ್ಯಾಬಿಟಾಟ್ ಎಂಬ ಕಂಪನಿಗೆ ಸತತವಾಗಿ ಜಂಟಿ ಅಭಿವೃದ್ಧಿ ನೆಪದಲ್ಲಿ ಭೂಮಿ ಪರಭಾರೆಯಾಗಿರುತ್ತದೆ. ಅಚ್ಚರಿ ಎಂದರೆ ಪ್ರತಿ ಬಾರಿಯೂ ಕಾನೂನು ಉಲ್ಲಂಘಿಸಿ KMF ಹಾಗೂ ಸರ್ಕಾರಕ್ಕೆ ಖಾಸಗಿ ಬಿಲ್ಡರ್ಗಳು ಕೋಟ್ಯಾಂತರ ರೂಪಾಯಿ ವಂಚಿಸಿ ಸರ್ಕಾರಿ ಜಾಗದಲ್ಲಿ ಬೃಹತ್ ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣ ಕಟ್ಟಿರುತ್ತಾರೆ. ಇದರಲ್ಲಿ ವ್ಯಾಪಕ ಭ್ರಷ್ಟಾಚಾರ ನಡೆದಿದ್ದು ಬಿಲ್ಡರ್, KMF ಅಧಿಕಾರಿಗಳು, PW ಅಧಿಕಾರಿಗಳು ಸೇರಿಕೊಂಡು ಸರ್ಕಾರಕ್ಕೆ 200 ಕೋಟಿ ಬೆಲೆ ಬಾಳುವ ಭೂಮಿಯನ್ನು ವಂಚಿಸಿ ಭಾರಿ ಪ್ರಮಾಣದಲ್ಲಿ ಭ್ರಷ್ಟಾಚಾರ ಎಸಗಿರುತ್ತಾರೆ. ಕೂಡಲೇ ತಾವು ಪ್ರಕರಣದ ಸಂಬಂಧ FIR ದಾಖಲಿಸಿ ಸಂಬಂಧಪಟ್ಟ ಅಧಿಕಾರಿಗಳು ಬಿಲ್ಡರ್ಗಳನ್ನು ಬಂಧಿಸಿ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಹಿಂದೆ ಇರುವ ಪ್ರಭಾವಿ ರಾಜಕಾರಣಿಗಳನ್ನು ಬಯಲಿಗೆ ತಂದು ಸರ್ಕಾರದ ಭೂಮಿಯನ್ನು ಹಿಂದಕ್ಕೆ ಪಡೆಯುವಂತೆ ತಮ್ಮಲ್ಲಿ ಒತ್ತಾಯಿಸುತ್ತೇನೆ. My submission to your lordship is, my lord, 1, there is an absolute sale deed saying, my lord, that I am entitled to collect the rents, etc. There is a complaint, my lord, after, my lord, a lapse of 10 years. My lord, can I persuade your lords, look at, my lord, a few judgments for my lord's consideration under almost identical set of circumstances.
Are the terms for leasing it out in favor of PVK infrastructure?
Yes, my lord, please come to, my lord, the lease deed. My lords may come to running page. After, my lord, we got the lease, the tender process, we leased it in their favor. ನೂರ 15. My lord, the terms, sorry.
Yes.
If your lordships come to, my lord, the terms start at page 126. ಅಲ್ಲಿ ತನಕ they have, my lord, defined, my lord, various terminologies used. Sorry, my lord, 122 ತಾವು ಬಂದರೆ just, my lord, to have a continuity. 122, my lord.
Yes.
Top, my lord. Accordingly, now this deed of lease witnesseth that in consideration foregoing, rent herein reserved and the covenants and conditions herein contained, and on the part of the lessor and lessee to be paid, observed and performed, lessor does hereby grant, convey, transfer by way of lease the piece and parcel of scheduled property in favor of the lessee for a period of 30 years, certain, as hereinafter provided. Then, my lord, definitions are there. My lord, I'll skip all that. My lord, can I also request your lordships, my lord, just to look at just the previous, my lord, paragraph, my lord, at page 118. The tender process, ಅದರ ಬಗ್ಗೆ ಎಲ್ಲ ಹೇಳಿದ್ದೇವೆ ಇಲ್ಲಿ. My lords may look at para B at 118, my lord.
Yes.
Whereas in furtherance, there came as larger objective of commercially exploiting its land bank on its 189th board meeting held on 17th of September 2007, resolved wide resolution number so and so to develop the project site to construct a commercial complex with private sector participation on a 30-year lease term, design, build, operate, transfer, D-bought, concession framework, extendable by an additional 10 years. The KMF board in its 192nd meeting has resolved to grant the scheduled property for 30 years lease in favor of the parties. KMF has invited the proposal for designing, building, operating and managing the project facilities. After such successful bidding process, has selected the parties and awarded the concession wide letter of acceptance dated 4th of April 2008. Lessor and the parties have entered into 3 concession agreements all dated 10th of April 2008 in respect of the properties referred to above in preamble A, setting out the terms and conditions upon the project will be implemented by the lessee. Then, my lord, all that. Then, my lord, please come to page 122 now. 122, top.
Yes.
Accordingly, now this deed of lease witnesseth that in consideration of the foregoing, rent herein reserved, covenants and conditions herein contained, and on the part of the lessor and lessee to be paid, observed and performed, lessor does hereby grant, convey, transfer by way of lease the piece and parcel of scheduled property in favor of the lessee for a period of 30 years certain, as hereinafter provided. Then, my lord, definition clause, my lord, I'll skip. Andre, ಈ words ಅನ್ನ ಒಂದೊಂದು word ಅಲ್ಲಿ ನಾವು use ಮಾಡಿರೋದನ್ನ they have defined what it means. Please come to my lord, running page 126. 127, sorry. Term of the lease. Para, my lord, para 2, sorry, possession. Parties confirm that the lessee has been put in physical vacant possession of the scheduled property on 10th of April 2008. Term of lease. The term of lease granted hereunder is 30 years certain, containing a certain commencing from the commercial operation date as defined above. Period of the lease shall be extended for a further period of 10 years on the same terms and conditions at the option of the lessor. Use of the scheduled property. Lessor hereby grants permission and consent to the lessee to use the scheduled property. Lessee agrees to use the scheduled property for the following: implementing the project, which means commercial space developed by the lessee for commercial usage and shall include all types of commercial activities such as hospitality, hotel, restaurant, bar, etc., healthcare institutions, hospital, research institutions, health tourism, other health facilities, etc., educational institutions, cultural institutions, hostel facilities. My lord, anything, my lord, they can do, my lord. All that, my lord, has been set out in para 4.1. 4.2, if your lordship sees. Next page. Lessee may, in addition to the above purpose, utilize the scheduled property for any other purpose, which in its opinion is conducive or incidental to the implementation of the project, and or conducive or incidental to the operation and management of the project, and or improve the commercial viability of the project. Lessee shall be entitled to provide, refurbish, modify, demolish, alter, procure all project facilities for better commercial utilization of the project facilities consistent with good industry practice. Lessee shall be liable to pay quarterly rent as set out in Schedule 2 of the concession agreement, which schedule is reproduced as Schedule 2 of this lease deed also. The first rent or concession payment to KMF shall become due and payable on the commercial operation date. No payment shall be payable till then to the lessor. Parties clarify that the rent and concession payment are the same and the lessee shall be entitled to pay only the rent as stipulated in the lease deed, etc.
What was the lease amount? Rent?
Rent, my lords get that, my lord, at 1 minute. Schedule 2, my lord, if your lords come to my lord, running page 159, my lord, 159. It goes on increasing, my lord, from
This is quarterly rent.
yes, my lord. Up to, my lord, the last, what's the, my lord, rent payable? My lord, there's an increase. Every year, my lord, 5% increase is there. As provided, my lord, in the sorry, once in 5 years, my lord, 5% increase. Sorry, I stand corrected. And my submission to your lordship says that, my lord, after 10 years, this kind of a complaint, my lord, is motivated and, my lord, my lord, the complaint is liable to be quashed. Court must. Adan kottira. Judgment, my lord, can I persuade your lordship? Just look at, my lord, a few judgments. My lord, the first of the judgment is page 1, my lord. This is 1989, 1 SCC 321. Please come to, my lord, paragraph 21. At running page, my lord, 14.
Now, first, let us hear them. What is their
As your lordship, please.
defense?
Very well.
If
Andre-
necessary, you can cite it.
Yeah, yes. Please.
But I'll make a feeble attempt for replying what the senior counsel has submitted. The rest of the submission will be made by my senior lordship. Lordship, as per the affidavit, it is clear, your lordship,
When, senior.
tomorrow itself, your
Huh?
lordship, tomorrow. Lordship, as per my statement of objection, it is very clear that once a land granted to any government authority, if that land is not utilized for that purpose, that land has to be granted back to the, given back to the government, your lordship. Statement of objection 13 September 2023, annexure R1, your lordship.
One. You are representing?
Lokaयुक्त, your lordship. A statement of objection dated 13 September 2023.
Yes.
Annexure R1, your lordship, kindly.
Now, what is your contention?
Lordship, it is clear that there is a irregularities and it is committed by the KMF and PW authorities. After filing FIR, before filing FIR, the preliminary inquiry has been conducted by the ACB, erstwhile ACB, in which it is found that there is a irregularities by the KMF, and that also have produced as annexure R2, your lordship, that report, preliminary report. in my-
Report by?
ACB, your lordship, please, lordship, as annexure R2, your lordship. It's a clear preliminary report, your lordship. After that, investigation was kicked in, your lordship, but still there was an interim order by this coordinate bench of this honorable court. So there needs to be a thorough investigation. And the affidavit of the government, your lordship, it is clearly stated in the para number 3. I respectfully submit that in the said proceedings, the public work department has not mentioned about the alienation or transfer of property on lease in favor of a private entity from KMF can be made. Para number 3, last 3-4 lines, your lordship. It is clearly stated even now, which is filed through an affidavit, your lordship. Rest submissions, it may be taken up tomorrow, your lordship, kindly. Some personal inconvenience, senior is not present, your lordship. Tomorrow he'll make his submission.
Specifically, it is posted 2:30 to enable the senior counsel to appear and
Please,
address
lordship.
argument.
We'll reply, your lordship. We'll reply to the senior counsel, your lordship. And another 2 petitions are connected with this, your lordship. We'll reply, your lordship.
In reply, sir, it is your argument. It is not the reply.
Lordship, only I can make a feeble attempt of
Reply he will give.
tomorrow, your lordship, kindly. Next week or tomorrow, any day.
Tomorrow. ಅದಕ್ಕೆ ಅವರು ಇದು ಮಾಡ್ತಾ ಇದಾರೆ ಇದು ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್.
Lordship, other petitioners needs to argue still.
I appear in the other matter. Tomorrow I have personal interest. Wait on Monday.
Sir, why should I would have adjourned this matter if there was a move. Why should I hear the learned senior counsel? I was under the impression that was the understanding on the last date of hearing. Everybody should come prepared and I will hear the matter. And there was no submission whatsoever from either party.
I
I would not have heard him. Why I should hear in part? And why I should remember all these things?
I understand, like, out of.
And that is why I have not taken any notes.
We will, my lord, accept, my lord, sir.
Sir, it is sheer waste of time,
Yes.
nothing else. Very sad to say that.
Accepting tomorrow, my lord, day after tomorrow, on Monday.
Exactly. Okay. Yep, next month. I have not taken down anything except noting on the dates and events submitted by the learner senior council. How can I remember all those things, details? And once again, I have to ask him, why should I do that? You address your argument at your convenience.
Monday.
Yes, next. Heard anta ಏನು ತಗೋಬೇಡಿ. I will not take it as heard.
Well,
There must be some.
My lord,
I'm very sorry, sir. Last time, that is why specifically at 2:30 it is posted. Not for any other reason. Yes, next.
My lord, I have filed the affidavit of the principal secretary. That is taken on record.
Learned HCGP filed the affidavit of the principal secretary, PWD.
It is holiday.
Yes.
Please.
Serial number 1, adjourn. Non-compliance of office subjection for first time. Serial number 2 to 5.
Serial number 3, madam.
ಯಾವ್ದು? Two, no?
That's serial number 3.
That is 2. Serial number 2.
Serial number 2, Kiran SS.
Counsel for the petitioner is absent, no representation. List on. Next.
Serial
3.
number 3, Rajesh.
My lord, I complete the office
Right.
objection.
Counsel for the petitioner submission, his objections are complied with. Office to verify and report. HCGP to take notice for private either issue notice. Then
Serial number 4 and 5.
Date may be fixed.
Next week.
4 and 5.
Your lordship, serial number 5, your lordship. So minor office objection, peak time may be granted. your
Why you
lordship.
could not comply with today?
Petition
How
filed
many
on,
objections are there?
6 objections, minor office objections, your lordship. In serial number,
Not comply with those minor objections till 3:30.
no, I didn't ask.
Huh?
Lordship, it is listed today only.
Yes, you could have done it. This serial number 3, the learned counsel has done it. Every advocate is doing that.
I didn't know that. Sorry,
No,
my lord.
I will counsel for the petitioner, praise for time.
Notice.
4, yes, it
Your
will
lordship,
be
may
adjourned.
kindly issue notice to the.
No, you first comply with the office. Next.
No, sure, lordship.
Non-compliance for second time. Serial number 6, Nagendra AV, Amar Kori.
For petitioner, my lord.
Your Honor, I appear.
Office objection complaint, my lord.
6.
Yes, my lord.
In fact, Your Honor, in this case, there are 2 petitions filed by the same petitioner. It has come on maintainability of the
Your part.
petition. I appear for the petitioner in 7954, 6.1.
6.1.
Yes, ma'am.
Same petitioner.
Same petitioner, my lords. In fact, their petition is filed on behalf of two individuals, which is number 1 and 2. Mine is
Yes,
1.
what do you say?
Your Honor,
Same
on-
petitioner cannot maintain 2 petitions.
Yes.
ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ನಾನು ಮೇನ್ ಇದು ಕೇಸಲ್ಲಿ ಕೂಡ ನಾನೇ ಇದ್ದೀನಿ ಪೇಜ್ ನಂಬರ್ 20 ಅಲ್ಲಿ ನೋಡಿ ಸ್ವಾಮಿ ಇದು ಆರ್ಡರ್ ಶೀಟ್
No, in 6.1, how many petitioners?
1 petitioner, my lords.
Huh.
1 petitioner filed by accused number 2 in the suit.
So accused number 2 is already a petitioner in 6, serial number 6.
Yes, ma'ams. Yes.
Let him continue.
My lords, on,
How your petition is maintained?
we have been instructed to file this
No,
petition, my lords,
Initially,
and
he was instructed,
in fact, upon,
file the petition first,
my lords,
first
what,
in time.
what I am instructed
no.
by the family of the petitioner is this, Your Honor. In fact, they had not even filed the Aadhaar card.
Not going to hear anything.
Yes, ma'am. May I
May
submit?
dismiss this as not maintainable since.
May I submit this, ma'am? The family has instructed that for the High Court,
I'm not
they were not
concerned. The
instructed.
petitioner is already a petition. He is representing him
Yes, ma'am.
during the pendency of the first petition. How can you file and maintain? on instruction by anybody. You cannot file it.
Lords, may I submit this? Now that they had not filed, they were instructed in, this is what my client has told me. They were instructed to appear in the lower court.
That is.
Upon rejection, Lords, they have come here is
It
what
is for the petitioners to do.
Yes,
I am not here to solve those problems. Why should I scratch my head? How I am concerned? They can engage anybody. How I am concerned?
that is what I'm telling you, Lords. They have engaged
Cannot-
me
You cannot.
in the
do
case, Your Honor, and they have not filed the
Point one.
Aadhaar card also. I have filed my,
No, no, madam, I am not hearing on that. It is 6.1. It is noticed that the petitioner as petitioner number 1 otherly, first one only. Allari in the 6th nalli, serial number 6. Petition number 2 had filed criminal petition number 7879 of 2024 seeking grant of bail under section 439 of CRPC. Later, only the petitioner has filed the present petition. Therefore, the office has raised the objections regarding maintainability of this petition.
one
On
submission.
considering the cause title, it is clear that the petitioner hearing had already filed a similar petition along with the co-accused. Else,
I can get filed the affidavit also through his.
no, I
through
am
his
not
parent.
keeping it. I will
In
not
fact,
keep
they
it
have
pending.
approached us and asked us to file this. And they are also
The
instructing us
office has
that
raised
the
a rightly raised objection regarding maintainability, as petition is dismissed as not maintainable. Yaudರಲ್ಲಿ? It's all of his objections. Yes, 6. Learned counsel for the petitioner submits that he has complied with the office objections. Office to verify. HCP to take notice for respondent. Yes, then either a note kodi private iದ್ರೆ. Yes, next.
Order. Serial number 7, Latif, Prasanna DP.
Is held up in another court, my lord. Requested for a passover, my lords.
Pass over any, next. 7.
7.
Days for time, next.
Serial number 8, Shashwat Prakash.
Bearing behalf of petitioner, my lord. Please, my lord. My lord, the petitioner hearing is accused number 2.
Now, how many accused?
Accused number 1 and 2, my lord, 2 accused. Accused number 1 have been granted bail by this honorable court. My lords can find it in page number 62.
For the offense?
My lord, under section 20 subclause A, my lord, growing of cannabis plants. The facts of the case is that, my lord, on 6/3/2024, at about 11:40 AM, Chikmagalur Citizen Police conducted a raid on the land of accused number 1, Rajendra KM, and found 8 ganja plants, my lord.
Yes.
The accused number 1 had grown ganja plant in the plastic cover, which weighs around 100 grams, my lord, worth of ₹1,000. On the inquiry made by accused number 1, he discloses that he was asked by the petitioner, the current petitioner, to grow the plant. Based on the statement made by accused number 1, the petitioner the FIR is inflicted against the said petitioner as well. Now, my lord, based on the statement made by accused number 1, the petitioner have been inflicted, as your honors are aware, it is not admissible. Moving further, my lord, during the investigation also, apart from the statement made by accused number 1, nothing have been elicited to prove that the accused number 2 have been committed.
From whom it is to be elicited?
My lord, the statement.
That stage has
That
not
has
yet
been
come.
filed, my lord.
That stage has not yet come. You are not available for investigation. It is a petition under 438.
Accepting that, my
Then
lord.
from whom it is to be elicited?
My lord, this FIR has been lodged based on the statement
Yes.
made by accused number 1.
Yes.
Apart from that, nothing, and also the
First
property.
go before the investigating officer, then come under 439, not under 438.
My lord,
It is premature.
only based on the statement, my lord, the accused have been.
The initial stage, there will be only statement of the informant or co-accused.
Apart from that, nothing have been found, my lord. Even the petitioner is the permanent resident of the said address, my lord. I've annexed the Aadhaar card as well. Accused number 1 has been granted bail, and also there is no criminal
No,
antecedents
bail,
against the.
bail was granted under 439. That cannot be parity.
Obliged, my lord, but
Yes.
also, my lord, there is no other criminal antecedents against the accused, my
Yes,
lord.
what
And
is
also
it?
section,
My lord, sir, there are serious allegations, my lord, so they have
Yes, 1 minute, yes.
my lord, also
cultivating
section.
Section 20, my lord, Section 20 NDPS Act. My lord, I'd like to read out if your honors permit me. Section 20A, my lord, cultivates any cannabis plant where such contravention relates to clause A with a rigorous imprisonment for a term which may extend for 10 years, my lord. Here, my lord, the petitioner have not grown any cannabis plant, my lord.
That is your defense.
My lord, at this stage, my lord, even he is ready to appear before the IO, my lord, even every day.
Intention
he's
of
ready
the
to-
prosecution is that you have grown the cannabis plant.
He has not grown.
It is punishable with the 10 years imprisonment.
My lord, I have not grown the cannabis plant, my lord.
That is your defense, sir.
My lord.
No accused
But-
will come and say, yes, I have grown the cannabis plant. I have committed the offense. No one
No,
will.
petitioner, accused number 1 who has granted bail, he has grown, my lord, not the petitioner herein.
He says you have grown.
No, ma'am, no, my lord. Accused number 1 doesn't say that petitioner has grown.
Then what he said?
Accused number 1 says that he has given the seats
Hmm.
to the petitioner and told to grow.
Yes.
Henceforth, my lord, any conditions, my lord, he is ready
No,
to.
no, he'll wait for some. Yes.
That's a serious allegation against the petitioner here in Millards, and they have grown the without any legal valid license, Millards. They have grown the ganja plants, Millards, and which was seized, Millards, and investigation is under progress, Millards, since his presence is required for
Any criminal antecedents?
as per the antecedents, there is no criminal antecedents.
Four ganja, 8 grams.
8 ganja plants, Millards,
What was the weight?
at 100 grams, Millards.
Total weight? Only 100 grams.
100 grams.
Huh?
Please, Millards.
So what? Petitioner being accused number 2. Before this court seeking grant of anticipated bail under section 438 of APC. Pension of being arrested. The allegations made against accused number 1 and 2 are serious in nature. Stated that the accused have grown ganja plants and 8 such ganja plants were found and seized, which were weighing 100 grams. Although the investigation is in progress, the petitioner is not available and as he has not appeared before the investigating officer. However, it is a matter of fact that accused number 1, who is the owner of the land in question, is already granted bail under section 439 of the APC as per order dated 7th May 2024, as in criminal section number 3096 of 2024. It is not the contention of the prosecution that the petitioner is required for custodial interrogation or that he is having criminal antecedents. Considering all these facts and circumstances, and allowed subject to conduct of it.
Serial number 9, Naushad Pasha.
Reason for the petitioner is observing representation. Order sheet dated 8/8/2024 reads as under. In spite of that, there is no representation. It appears petitioner is not interested in prosecuting the petition. His petition dismissed.
Serial number 10, Arjun. 11, Suyogerale, Prasanna Kumar PP. Prasanna Kumar P.
Respondent, my lord. My senior is held up before court on 17, my lord. This matter may kindly be taken up in the next week, my lord.
Learned as PP praise for time. Learned a special PP, yes, PP, special PP praise for time. This stuff. The interim order granted earlier is extended till disposal of the petition. Yes.
Okay.
Pass over matters.
My lord, can I kindly make the submission in regards to the 230 matter, my lord? There's an interim order that has to be extended.
The interim order is extended. Yes. ಏನು ಅರ್ಥನೇ ಇಲ್ಲ ಏನು conflict ಇದೆ? Speak up, sir.
Passed over matters. List one, serial number 10, Rahmatullah Sharif.
Counsel for the petitioner is absent, no representation. Learned and additional is speaking, submission. Even though the FIR registered by the police is challenged in this petition, now the charge sheet is filed. The matter is pending in CC number 3186 of 2020 for the trial court. In view of the petition is dismissed as the same is rendered infectious.
List two. Serial number 7, Anand Mutalli.
Counsel for the petitioner is absent, no representation. Yavoga. And the copy to the. It is noticed that the amendment is carried out and is filed. List for preliminary review. Next.
Serial number 10, Hassan Kumar.
Counsel for the petitioner is absent, no representation.
For the petitioner minutes. Kindly have it on Monday minutes.
No, finally posted, ma. No further adjournment. Petition.
Minutes, kindly have it tomorrow minutes. I have briefed the senior council minutes, so kindly have it tomorrow, Monday minutes.
Yes, what is the stage in this?
My lord, we have filed the B report, my lord. The petition is by the complainant, my lord. And the allegation in the complaint is that, my lord, the petitioner was a lecturer in the Government College of Law, my lord, in Ramnagara. And the accused is also a lecturer in the same college, my lord. And it is the allegation that, my lord, the petitioner has not been given the UGC scale. And because of the discrimination on the basis of his caste, my lord. And we had filed the B report and the court has also accepted the B report.
Yes. Next.
Serial number, list two, serial number 19, Manjunath H.N.
Yes, it is adjourned.
Very clear.
Counsel for the petitioner is absent, no representation. The appeal is of the year 2015. The order sheet dated 21/12/2023. 5/2/2024. 25/7/2024. Discloses that the
19.
counsel for the petitioner was
19.
absent.
19, sir.
Respondent.
Absent. There was no representation. What is the offense?
138, man.
The appellant is challenging the judgment of acquittal
Acquittal.
of the respondent for the offence punishable under section 138 of NA. It appears the appellant is not interested in prosecuting the appeal. However, to afford final opportunity, list on. It is listed finally.
Yes.
Next date of hearing, I will hear you and pass out.
Much of.
Serial number 20, Venkat CS, R Shashidhara.
Yes, paper 15. Appellants are sister and
1 minute. How much time you may require?
10 minutes.
10 minutes.
10 minutes.
Aste.
ಅಷ್ಟೇ ಏನಿಲ್ಲ ಸರ್ ಇದು ಮೇಲ್ ಅಲ್ಲ their sister and husband sister the sister and brother-in-law. In this case, may I request your lordship, in this case, what has happened?
Tell me who are the petitioners.
Petitioners are sister of the
Their accused number.
accused number 3 and 4. 3 and 4, your lordship. Accused number 3 and 4.
He is the sister of
Sister of the husband.
accused number 1.
Accused number 1.
Then 4,
4 is her brother-in-law, the sister's husband.
husband of accused number 3.
Husband of petition number 3, your lordship. Husband of petition number 3, your lordship. In this case, your lordship, in this case, the marriage was happened on 17/2/2020. Earlier, they filed a mutual divorce petition on 25/6/2013, your lordship. That I produced the copy of the mutual divorce petition, your lordship. On 25/6/2013, that was filed, your lordship. Then there some alimony was understanding was entered. According to the
Mutual consent divorce in MC number.
MC number 60, MC number 29 of 2013, your lordship. MC number 29 of 2013. That I have produced at page number 36, your lordship.
Yes.
Subsequent, in that petition, mutual divorce petition, my claim was that I have paid them 13,50,000, but
Not your claim. Claim of accused number 1.
sorry, petition of 1 was that I have paid 13,50,000. In the petition, they have written 9,50,000, your lordship. So the dispute arose. Then the husband filed another petition in Bhadravati, that is MC number
So
63.
what happened to this 29 of 13?
That was withdrawn, dismissed. That was dismissed, your lordship. Your lordship, no, during the subsistence of that petition only, he husband filed another petition on 1/8/2013. Lordship, I'm stressing on the dates, your lordship. That is MC number 63 of 2013, seeking divorce, your lordship.
See number
63 of 2013, your lordship.
by accused number 1.
Accused number 1, your lordship. In
On what ground?
13 the desertion and all this. May take your lordship to page number 39, your lordship.
Page number ಎಲ್ಲ ಬೇಡ ನಾನು.
Then your lordship subject
This was filed MC 63
1/8/2013, your lordship.
when mutual consent divorce was
25/6/2013.
56.
2013. Lordship, subsequently what happened, in 1/8 in MC 63 of 2013, I deposited 7 lakhs in the court that this is the alimony. So then they rejected. In that context, so after filing this petition, they filed, if this FIR was filed on 25/8/2013, your lordship. The
25.
8/2013, your lordship. This FIR was filed, your lordship. May I submit, subsequent to this, your lordship, on 28/9/2015, wife filed an again MC petition 6/2015, your lordship.
For
She filed divorce. In that, the petition, the husband remains ex parte. May I request your lordship to 62. In page number 62 is the petition judgment in that 62 year.
what happened to this MC 63 of 13?
63, I withdraw, that also withdraw, I withdraw it. That also withdraw it. That was withdrawn.
I withdrawn, you are not.
Sorry,
representing
withdraw,
accused
humble,
number one,
sorry,
sir.
husband, accused number withdrawn it. Accused,
You are
sorry,
under the impression you are representing accused number 1.
sorry, humble, sir, sorry. Husband withdrew it.
What happened to MC 6 of 15?
16, in this, may I request, in this what has happened? In this, accused number 1 was placed ex parte and divorce was granted, your lordship.
Yes.
My humble submission to you, that is that in this petition, there is no, she had made allegation against the husband only, not against this petitioners, your lordship. This appellant's petitions before this honorable court, your lordship. That is at page number 62, your lordship.
Page number,
62, your lordship.
what is that?
That MC 6 of 2015 judgment order, sir. May I take your lordship to page number 60, the next brief facts of the case, next page. The petition legally wedded wife, the marriage was solemn so and so, so and so. They lead happy marital life.
That allegation is only confined to the MC petition.
Howದು?
That is why allegation is only against you. Means accused number 1.
Yes, your lordship.
Not against you.
Yes, your lordship.
Because you are not a party there.
Yes, sir, that is my ambition, that is my submission, your lordship, but that is my submission. Here, what my humble submission to your lordship is that, simply they have made me a party in the.
Come to the charge sheet now. Charge sheet is already filed.
Yes, your lordship.
What is the allegation?
I take the lordship to charge.
Page number 19.
19, your lordship.
Yes.
ಈ ದೋಷಾರೋಪ may I take 19. ಈ ದೋಷಾರೋಪಣ ಪಟ್ಟಿ ಕಾಲಂ ನಂಬರ್ ನಮೂದಿಸಿದ ಆರೋಪಿತರು ಈ ಬಗ್ಗೆ 2 ವರ್ಷಗಳಿಂದ ಸಾಕ್ಷಿ 1ರವರೆಗೆ ಮಕ್ಕಳಾಗಿರುವುದಿಲ್ಲ ಎಂಬುವ ವಿಚಾರದಲ್ಲಿ ಮಾನಸಿಕವಾಗಿ ಮತ್ತು ದೈಹಿಕವಾಗಿ ಹಿಂಸೆ ನೀಡುತ್ತಿದ್ದು, ಸಾಕ್ಷಿ 1ರವರು ಸಹಿಸಿಕೊಂಡು ಹೋಗುತ್ತಿದ್ದು ಸಹ ಪದೇ ಪದೇ ಕಿರುಕುಳ ನೀಡುತ್ತಿದ್ದು, ಸಾಕ್ಷಿ 1ರವರು ಆರೋಪಿತರು ಕಿರುಕುಳ ತಾಳಲಾರದೆ ತನ್ನ ತವರು ಮನೆಗೆ ಬಂದಿದ್ದರೂ ಸಹ ಅಲ್ಲಿಗೂ ಬಂದು ಪದೇ ಪದೇ ಕಿರುಕುಳ ನೀಡುತ್ತಿದ್ದು, ದಿನಾಂಕ 24/8/13ರಂದು ರಾತ್ರಿ 8 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಹೊಳಲ್ಕೆರೆ ತಾಲೂಕ್ ಮಲ್ಲಾಡಹಳ್ಳಿ ಗ್ರಾಮದ ಸಾಕ್ಷಿ 1ರವರ ತನ್ನ ತಂದೆಯಾದ ಸಾಕ್ಷಿ 4ರವರ ಮನೆಯಲ್ಲಿರುವಾಗೆ ಎಲ್ಲ ಆರೋಪಿತರು ಸಾಕ್ಷಿ 1ರವರ ಬಳಿ ಬಂದು ವಿನಾಕಾರಣ ಜಗಳ ತೆಗೆದು ನೀನು ಇಲ್ಲಿಯೇ ಇದ್ದು ಕತ್ತೆ ಸೋ ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದಾಡಿ ಕೈಕಾಲುಗಳಿಂದ ಮೈಕೈಗೆ ಹೊಡೆದು ಮಾನಸಿಕವಾಗಿ ಮತ್ತು ದೈಹಿಕವಾಗಿ ಹಿಂಸೆ ನೀಡಿ ಪ್ರಾಣ ಬೆದರಿಕೆ ಹಾಕಿರುತ್ತಾರೆ ಎಂತ ತನಿಖೆಯಿಂದ ದೃಢಪಟ್ಟ ಮೇರೆಗೆ ಆರೋಪಿತರ ವಿರುದ್ಧ ಮೇಲ್ಕಂಡ ಕಲಂ ರೀತಿಯ ದೋಷಾರೋಪಣ.
Yes.
My humble submission, your lordship, there is no specific overt act against the second and the third of this petition, your lordship. Even my humble submission, your lordship, this because they have filed an divorce petition at the first instance, second instance, and also in the divorce petition, there is no allegations, your lordship. This is only an FIR as afterthought, your lordship. That's what my humble submission.
FIR was filed earlier, sir.
No,
FIR is dated 25/8/2013.
May I request your lordship, prior to that petitions was for that mutual divorce was filed. Suppose if they have any allegations, they should have.
Sir, mutual consent divorce, generally no allegations will be made.
Yes, I accept your lordship. I admit that on that.
Only the husband and wife are the parties and no allegations will be made.
Yes, your lordship, my humble submission. That is, but the allegation is only to rope in all these parties. They have made this allegation subsequently, your lordship. The charge sheet says this only. There is no specific overt act against the petitioners, your lordship. My humble, after 5, if they have any grievance, if they're in 498, they should have raised that allegation at the first instance.
Date of marriage is 17/2.
2010, your lord. 17/2/2010, your lord. In this context, my husband is absconding and she is also married, your lordship. After getting the divorce, she is married.
Who?
Complainant is married, your
Be
lordship.
married.
That we are not getting the information, your lordship, but
Yes.
Page number 15, my lord. The complaint is clearly mentioned, my lord. ನಾನು ಮೇಲಿನ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಿರುತ್ತೇನೆ, ನನ್ನನ್ನು ನನ್ನ
ಇದಕ್ಕೆ ಮೇಲಿಂದ ಓದೋದು ಬೇಡ. Yes. What is the allegation?
ಕ್ಲಿಯರ್ಲಿ ಹೇಳಿದ ಸರ್, ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಹೇಳಿದೆ ಸರ್. ಕೃಷ್ಣವೇಣಿ ನನ್ನ ಗಂಡನಾದ ಅಕ್ಕ ಅನಿತಾ, ಗಂಡನಾದ ಪ್ರಹ್ಲಾದ್ ಹಾಗೂ ಪ್ರಹ್ಲಾದ ಡಿ.ಕೆ, ನನ್ನ ತಂದೆ ಕೃಷ್ಣಪ್ಪ ಇವರುಗಳು ನನಗೆ ಬಾಯಿಗೆ ಬಂದಂತೆ ಬೈದು ಇದುವರೆಗೂ ಮಕ್ಕಳಾಗಿಲ್ಲ,
ನೀನು ಡೇಸ್ ಸೋ ಅಂಡ್ ಸೋ ಎನ್ನುತ್ತಾ ಬಾಯಿಗೆ ಬಂದಂತೆ ಮಾನಸಿಕವಾಗಿ ಹಿಂಸೆಯಾಗುವಂತೆ ಮಾತನಾಡುತ್ತಿದ್ದರು. ಇದನ್ನು ನಾನು ಪ್ರತಿಭಟಿಸಲು ಹೋದಾಗ ಅವರುಗಳು ಸೇರಿ ಕೈಕಾಲುಗಳಿಂದ ನನ್ನ ಮೈ ಕೈಗೆ ಹೊಡೆಯುತ್ತಾ ಹಿಂಸೆ ನೀಡುತ್ತಿದ್ದರು.
ಯಾವಾಗದು?
ಮಲಡ 25/8/2013 ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್.
ಇನ್ಸಿಡೆಂಟ್ ಯಾವಾಗ ಸರ್?
ಮಲಡ ಇನ್ಸಿಡೆಂಟ್
From the day one, my lords, as per the awareness of the complaint, my lords,
5 years, no complaint.
she was subject to harassment, my lords, because she is not getting conceive ಆಗ್ತಿಲ್ಲ ಅಂತ ಒಂದು allegation ಇಂದ every day they used to ask.
See, you have heard
harass.
him addressing the argument.
Please, my lord.
The petition was filed for seeking divorce by mutual consent.
But in that, my lords, the
And
ex
thereafter,
parte order was
husband has filed
against.
the petition for divorce. And again, you filed the divorce, got the divorce. According to him, you are already married the second time.
They abused with a filthy language and they used to
Is it not
assault her.
called allegations? What is there in it? Bandru, baidru, ಅವಾಚ್ಯ ಶಬ್ದಗಳಿಂದ ಬೈದ್ರು, ಕೈ ಕಾಲಿಗೆ ಹೊಡೆದ್ರು, ಹೋದ್ರು. What is there to support that contention?
As per the charge sheet allegation, my lords, she was subject to mental and physical harassment, my lords.
Is it sufficient?
And as per the allegation made against the assault, my lords, there is no material regarding.
Own certificate?
No own
Nothing.
certificate.
Then
Yes. my lords.
nothing, ಏನಿಲ್ಲ. ತಗೊಳ್ಳಿ. Petitioners being accused number 3 and 4. Now, CC number?
CC number ಮಲಡ 113 of 2016, word 623 of 2014.
Now, CC number?
Now 113 of 2016.
16. Which court?
Principal Civil Judge and JMFC Oralkere.
The petitioners being accused number 3 and 4 in CC number 1 and 2016 on the file of the learning principal civil judge and JMFC Oralkere are seeking to quash the criminal proceedings initiated against them. The facts of the case are that respondent number 2 as informant filed the first information against accused numbers 1 to 4, alleging commission of the offence punishable under sections 323, 504 of IPC, alleging commission of the offence punishable under section 498A, 506, read with section 34 of IPC. It is the allegation made in the first information that the informant married accused number 1 on 17/2/2010. Thereafter led marital life. A few days, accused number 1 went to Maharashtra to pursue his studies. The informant started residing in the matrimonial house along with accused number 2 to 4. After about a year, accused number 1 to 4 started abusing the informant in filthy language. As she had not begotten any children, and also assaulted her with hands. About 2 months earlier to the first informant, the informant came to her matrimonial, came to her parental house and started residing there. The accused came to her parental house and abused her in Hindi language. Assaulted her and gave life threat. On 24/3/2013. Therefore, she requested the police to register the case and to initiate legal action. Accordingly, the FIR in the time 6/15/2013 of Cruelty police station is came to be registered for the offence under section 498A, 506, read with section 34 of IPC. Now it is stated that after investigation, charge sheet came to be filed. And the matter is pending in CC number 113 of 2016 on the file of Principal Civil Judge in JMC for the offence punishable under sections 498A, 323, 504, 506, read with section 34 of IPC. Third, sir, accused number 3 and 4 are before this court seeking to quash the criminal proceedings initiated against them. Also, when a counsel for the petitioner contended that number 1 married respondent number 2 on 17/2/2001. They led marital life for some time, and they filed MC 29 of 2013 seeking mutual divorce by mutual consent. Subsequently, the same was going to be dismissed. During dependency of MC 29 of 13, accused number 1 filed MC 63 of 2013 seeking divorce on the ground of desertion. However, later it was withdrawn. Some counsel further submits that it is only the withdrawal of MC 63 of 2013. Present complaint has been confirmed. Broad and general allegations are made against these petitioners. There is no specific word act. Number 3 is the sister of accused number 4 is her husband. They are proceeding separately in the address mentioned in the petition. They have nothing to do with the family affairs of number 1 and respondent. Only to tease and arrive the petitioners, they was going to be filed against them. Even in the petition, in the MC 6 of 2015 filed by the petitioner seeking divorce, was filed on 28/9/2015. Respondent number 2 had not made any allegations against these petitioners. Such circumstances, initiation of the criminal proceedings against the petitioners is only in abuse of process of law. Accordingly, place for allowing the petition. Counsel, learned executive, learned counsel for respondent number 2, opposing the petition submitted. These allegations are made against the petitioners and accused number 1 and 2 for having committed the offence. The informant specifically stated that the petitioners, along with other accused, abused her, assaulted, gave life threat. And such specific allegations are made, the petition is liable to be dismissed. Accordingly, pay for dismissal of the petition. Review the material, find consideration, and answer to the defendant affirmative for the following reasons. The informant filed the first information alleging that she married accused number 1 on 17/2/2010. She stayed in the matrimonial house for some time and came back to her parental house. After coming back to her parental house on 24/3/2013. The accused came to her house, abused her in the language, assaulted with hands, and gave life threat. It is pertinent to note that initially on 25/6/2015, accused number 1 and respondent number 2 have filed MC 29/13 seeking divorce by mutual consent. Same was came to be dismissed. During pendency of MC 29/13, accused number 1 filed MC 63/13 seeking divorce from respondent number 2 on the ground of divorce. Subsequently, the same was completely withdrawn. In the meantime, the present first information was filed and the FIR was came to be. It is not in dispute that during 2015, respondent number 2 filed the MC 2015 seeking divorce, where accused number 1 was placed as partner. And it is stated that the petition is already allowed and divorce not granted. However, it is the specific condition of the petition. No allegations were made against these petitioners in the side. Same was not controverted by the respondents. Admittedly, respondent number 2 has not sustained any injuries in the incidents that had occurred. Stated that the petitioners have the permanent residence of the address mentioned in the petition. And they have nothing to do with the family affairs of accused number 1 and respondent number 2. In such circumstances, I am of the opinion that since there was a marital discord between accused number 1 and the respondent number 2, it is an attempt to rope in all the family members by making broad and general allegations. Continuation of criminal proceedings against these petitioners would amount to abuse of process of law, and therefore the same is liable to be questioned. Accordingly, I answered the point in the affirmative. Petition is allowed, so also. Petition allowed.
Serial number 21 disposed, 22 HP Rudresh, Harish HV, P Nataraju.
Case I'm appearing for petitioner members. The petitioner is a
Other matters I may not take up today. All other matters, you can take the convenient date.
serial number.
958, who is the petitioner?
I'm appearing for the first matter.
HP Rudresh.
Yeah, 958, I'm appearing for a petitioner.
Who is the petitioner?
I'm the petitioner.
Petitioner accused number 1, my lord.
And in 5431?
Accused number 2, my lord.
Two. In all, how many accused?
Only two cases.
Only two. So the offense alleged.
420, read with section 34 of IPC.
Only 420.
420.
Where is the charge sheet?
Charge sheet, what sheet? Page number 52, my lord.
Yes.
Annexure F.
Yes.
Lordship, the petitioner is the proprietor of the Angels and Dimension construction company.
Owner of?
He is the proprietor of Angels and Dimension company, my lordship, which is a construction company.
Yes.
The respondent number 2, who is the complainant herein, has filed a complaint before the respondent number 1 police station,
Yes.
stating that the accused number 1 and 2 have not paid the unfinished construction bill, estimation bill work, my lordship.
Please read column number 7.
Which one?
Column number 7 of the charge.
7. ಈ ದೋಷಾರೋಪಣ ಪಟ್ಟಿ ಕಾಲಂ ನಂಬರ್ 2 ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಆರೋಪಿ ಒಂದರವರು ಬೆಂಗಳೂರು ನಗರ ಹೈಗ್ರೌಂಡ್ ಪೊಲೀಸ್ ಠಾಣೆಯ ಸರಹದ್ದಿಗೆ ಸೇರಿದ ಕ್ರೆಸೆಂಟ್ ನಂಬರ್ ರಸ್ತೆ 26/3 ರಲ್ಲಿ 2009-10 ಸಾಲಿನಲ್ಲಿ ಆಂಜಲ್ಸ್ ಅಂಡ್ ಡೈಮೆನ್ಷನ್ ಎಂಬ ಕಚೇರಿ ಇಟ್ಟುಕೊಂಡು ಗುತ್ತಿಗೆ ಕಾಮಗಾರಿ ನಡೆಸುತ್ತಿದ್ದು, ಆರೋಪಿ 2ರವರು ಆರೋಪಿ 1ರವರ ಅಸೋಸಿಯೇಟ್ ಆಗಿದ್ದು, ಇವರು RT ನಗರದ BDA ಕಾಂಪ್ಲೆಕ್ಸ್ 2ನೇ ಬ್ಲಾಕ್ 3ನೇ ಕ್ರಾಸ್ 547ರಲ್ಲಿರುವ ದೇವರ್ಷಿ ಕಾರ್ಪೊರೇಷನ್ ಮಾಲೀಕನಾಗಿರುತ್ತಾನೆ. ಆರೋಪಿ 1 ಅಂತಾರಾಷ್ಟ್ರೀಯ ವಿಮಾನ ನಿಲ್ದಾಣದ ಹತ್ತಿರ ಇರುವ ಸಾದರಹಳ್ಳಿ ಪೋಸ್ಟ್ ಚೌಡೇನಹಳ್ಳಿಯಲ್ಲಿ ಅರ್ಧಂಬರ್ಧ ಕಾಮಗಾರಿಯಾಗಿ ಸ್ಥಗಿತಗೊಂಡಿದ್ದ ನಿರ್ವಾಣ್ ಮೆಟ್ರೋ ಕಾರ್ಪ್ನ ಮನೆಗಳ ನಿರ್ಮಾಣದ ಗುತ್ತಿಗೆಯನ್ನು ಸಾಕ್ಷಿ 17ರವರಿಂದ ತೆಗೆದುಕೊಂಡು ಈ ಕಾಮಗಾರಿ ಕೆಲಸವನ್ನು ಉಪಗುತ್ತಿಗೆದಾರರಿಂದ ಸಾಕ್ಷಿ 1 ಮತ್ತು 4ರವರೆಗೆ ಜೂನ್ 2ರ 20 ಮನೆಗಳನ್ನು ನಿರ್ಮಿಸಲು ದಿನಾಂಕ 29/11/2010 ಸಾಕ್ಷಿದಾರರಾದ 11 ಮತ್ತು 12ರವರ ಸಮಕ್ಷಮ ಸಾಕ್ಷಿ 2ರವರೆಗೆ ಜೂನ್ 1ರ 22 ಮನೆಗಳನ್ನು ನಿರ್ಮಿಸಲು ದಿನಾಂಕ 20/10/2010 ಸಾಕ್ಷಿ 13 ಮತ್ತು 14ರವರ ಸಮಕ್ಷಮ ಸಾಕ್ಷಿ 3ರವರೆಗೆ ಜೂನ್ 5ರ 16 ಮನೆಗಳನ್ನು ನಿರ್ಮಿಸಲು ದಿನಾಂಕ 29/11/2020 ಸಾಕ್ಷಿ 15ರವರ ಸಮಕ್ಷಮ 1 ಚದರ ಅಡಿಗೆ 225 ರೂನಂತೆ ಮಾತನಾಡಿ ಆರೋಪಿ 2ರವರೇ ಉಪಗುತ್ತಿಗೆದಾರರ ಕಟ್ಟಡಗಳ ಕಾಮಗಾರಿ ಹಣ ಕೊಡುವಂತೆ ಒಡಂಬಡಿಕೆ MOAಯನ್ನು ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ. ಸಾಕ್ಷಿ 1 ಮತ್ತು 4ರವರು ನಿರ್ಮಿಸಿದ 19 ಮನೆಗಳ ಕಾಮಗಾರಿ ಮೊತ್ತ ಒಟ್ಟು 20,89,421 ರು ಆಗಿದ್ದು, ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ 4,50,000 ರೂಗಳನ್ನು ಮಾತ್ರ ನೀಡಿ ಬಾಕಿ 14,39,451 ರು ಸಾಕ್ಷಿ 2ರವರು ನಿರ್ಮಿಸಿದ 11 ಮನೆಗಳ ಕಾಮಗಾರಿ ಮೊತ್ತ ಒಟ್ಟು 14,36,946 ರು ಆಗಿದ್ದು, ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ 3 ಲಕ್ಷ ರೂಗಳನ್ನು ಮಾತ್ರ ನೀಡಿ ಬಾಕಿ 11,36,946 ರು ಸಾಕ್ಷಿ 3ರವರು ನಿರ್ಮಿಸಿದ 14 ಮನೆಗಳ ಕಾಮಗಾರಿ ಮೊತ್ತ ಒಟ್ಟು 11,37,590 ರು ಆಗಿದ್ದು, ಇದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ 2 ಲಕ್ಷ ರೂಗಳನ್ನು ಮಾತ್ರ ನೀಡಿ ಬಾಕಿ 9,37,590 ರೂಗಳನ್ನು ಒಟ್ಟು ಸುಮಾರು 35,13,987 ರೂಗಳನ್ನು ಆರೋಪಿ 1 ಮತ್ತು 2ರವರು ಕೊಡದೆ ಸಾಕ್ಷಿ 1ರಿಂದ 4ರವರು ಇಮೇಲ್, SMS ಹಾಗೂ ದೂರವಾಣಿ ಮೂಲಕ ಆಪಾದಿತರನ್ನು ಸಂಪರ್ಕಿಸಲು ಪ್ರಯತ್ನಿಸಿದರು. ಸಿಗದೆ ಯಾರಿಗೂ ಗೊತ್ತಾಗದಂತೆ ಕೇಳದೆ ಮಾಹಿತಿ ಇಲ್ಲದೆ ತಲೆಮರೆಸಿಕೊಂಡು ಪರಾರಿಯಾಗಿರುವುದು ದೃಢಪಟ್ಟಿರುತ್ತದೆ. ಆಪಾದಿತರು ವಂಚನೆ ಮಾಡಬೇಕೆಂಬ ಏಕೋದ್ದೇಶದಿಂದ ಈ ರೀತಿ ಮಾಡಲು ತನಿಖೆಯಿಂದ ದೃಢಪಟ್ಟ ಕಾರಣ ಆರೋಪಿತರು ಸದರಿ ಕಾಯ್ದೆ ಮತ್ತು ಕಲಂಗಳಡಿ ದಂಡಿಸಲ್ಪಟ್ಟಿರುವ ಅಪರಾಧ ಎಸಗಿದ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ
Is it not a civil dispute?
It is not a civil dispute, not be.
How can it be a criminal dispute?
Nada. Initially, Malada, petitioner and complainant has agreed to verify. Please, madam.
There is a memorandum of understanding.
And also given the Malad checks Malada. For a moment, Malad,
State 138,
Malada, but what had,
spill suit,
Malad, what had happened, Malada?
say 420.
Malad, they are not producing the entire charge sheet material, Malada. I presented the check, Malad, produced by the A1 and A2, Malada, that came to the bouncer, Malada. Thereafter I approach, please, madam.
138,
Thereafter I approached the,
138, but
Malada, because of why I should not produce that, Malada, in the, Malada, that time I produced, Malada. In that thereafter I given a complaint to the concerned police station, Malada. That time checks are given to the police, Malada. And also produced in the charge sheet material, entire charge sheet material, Malada. In charge sheet materials, Malada.
38 illa 420 ಇದೆ.
Yes, madam.
The where allegation is that there was a contract, there was a memorandum of understanding
Yes, madam.
between the parties.
But
There
madam,
are witnesses to it, but 35 lakh is due.
yes,
They are not responding. They are the defaulter.
yes, madam.
File a suit for recovery.
Malada, in insurance, there is already, Malada. We are doing the construction on Malada and also pay the labor, Malada, in own Malada. And now also I'm difficult to do the all these things, Malada.
May have 101 difficulties,
Yes,
sir,
ma'am.
but that does not mean to say that you can file a criminal complaint. How can you invoke 420? Breach of contract.
Yes, for the,
You have to go before the civil court. A classic case of misuse of, it is abuse of process of law.
in complaint also, we are clearly stated, Malada, they are not come forward, Malada, and pay the amount, Malada. And also, Malada, they are closed the company, Malada, gone to the native places, Malada. After filing of this complaint, Malada, they come back to the,
Parallel. Covered.
One more submission. So far as this 5431 is concerned, and I am not even associate of A1. I have not even executed any kind of contract with the.
If at all, according to him, there is a memorandum of understanding.
I am not even the signatory.
Malada,
I have nothing
for
to
a-
do.
Malada, for a moment, Malada, kindly come to the grounds taken by the A1 and A2, Malada. Also, in the petition, Malada, they state, Malada, A2 to pay, Malada. And for a moment, kindly come to the,
Sir, whatever may be the ground, but
the allegation made by the Malada.
420 will not be attractive.
No, no. Please, Malad, I will, for a moment, kindly see the Malad. In criminal petition 958 of 2018, Malad. In ground number 20 taken by the accused, Malad.
If you venture to waste the time of the court,
No, Malad, I will
will
only brought,
I will permit them for malicious prosecution against you.
only I will brought to the notice of the Malad, how they are mislead the court, Malad, that's it.
It is a fit case for permitting them for malicious prosecution.
I brought to the notice of this court,
Classic
Malad.
example.
They are clearly mentioned in that, Malad.
Yes, how can a charge sheet be filed in this case?
Milords, as per the charge sheet allegation, Milords, it has stated, Milords, or at the end of the charge sheet, Milords, ತಲೆಮರೆಸಿಕೊಂಡಿದ್ದಾರೆ.
ತಲೆಮರೆಸಿಕೊಂಡ ಕೂಡಲೇ 420 ನಾ?
420, no, Milords.
How can you assume jurisdiction in those cases?
It's as per the MOU, Milords, they came into a contract,
Are
Milords.
you
with the-
authorized to enforce MOU, terms of MOU?
No, Milords.
Then what is your authority?
Thing is that, Milords, in the charge sheet, Milords, they have stated, Milords, as per the charge sheet, Milords, there are some 35 lakhs ರೂಗಳನ್ನು ಆರೋಪಿ 1 ಮತ್ತು 2 ಕೊಡದೆ ಸಾಕ್ಷಿ 1ರಿಂದ 4 ರವರೆಗೆ ಇಮೇಲ್
Madam, please
SMS.
understand what I am saying.
Please, Milords.
It's very sad state of affairs. You are the HCGP, you should understand.
Yes, Milords.
Otherwise, I may have to observe something against the HCGP also
No, Milords.
for having supported such cases. You are assisting the court.
Please, Milords.
You are not a counsel for an a party.
Please.
I can understand he is submitting. Absolutely baseless charge sheet is filed.
420 doesn't arise, Milords.
Then how can you justify that? Are you acting as a middleman to recover this amount, 35 lakhs?
No, Milords.
Is it the role of the police?
No.
Then there are better work to do. So good. The petitioner in criminal petition number 358 of 2018 is accused number 1. Petitioner in 5431 of 2019 is accused number 2. CC 20408 of 2012 pending on the file of the learned 8th additional CMN Bengaluru, registered for the offence punishable under section 420. Read with 34 of IPC. The facts of the case are as stated by the informant is that accused number 1 is the owner of construction company and accused number 2 is the associate. Also the owner of one corporation. The accused number 1 and 2 have entrusted the work of construction of several houses to CWs 1 and 2 now. CWs 1 and 2. And there was a memorandum of understanding between the parties entered into in the presence of witnesses. Accordingly, CWs 1, 2, the charge sheet witnesses and charge sheet witnesses. According to the prosecution, the accused 1 and 2 are due a sum of rupees 35,13,987 under the memorandum of understanding to be paid to CWs 1 to 4. But they were not responding to the email, SMS, and even telephone call. The accused remained absconding, and thereby they have cheated CWs 1 to 4. With these allegations, the charge sheet was came to be filed against accused number 1 and 2. And the matter is now pending in CC so and so. Or so and so. Reduce the materials filed for consideration. My answer to the point in the affirmative for the following reasons. The informant logged the first information against accused number 1 and 2 alleging commission of the offence punishable under section 420, with section 34 of RPC. After investigation, charge sheet was came to be filed. The only allegations made by the informant as well as by the investigating officer while filing the charge sheet is that accused number 1 and 2 have entrusted construction of houses to accused number to CWs 1 to 4 as agreed up as per the terms of memorandum of understanding. Accordingly, CWs 1 to 4 have constructed and completed the construction work. In terms of the agreement, the sum of rupees 35,13,987 was due to be paid by accused number 1 and 2. But the same was not paid. On the other hand, they are not responding to CWs 1 to 4 and remained absconding. By no stretch of imagination, this will attract section 420 of IPC. It is purely a civil dispute based on an agreement referred to by the informant as memorandum of understanding that was entered into in the presence of the witnesses. In such circumstances, continuation of the criminal proceedings against the petitioners would amount to abuse of process of law for the purpose of arm twisting accused number 1 and 2 to recover the amount alleged to be due to CWs 1 to 4. Unfortunately, the investigating officer proceeded to file the charge sheet on the basis of the same without any basis. Hence, I am of opinion that the proceedings Well, I think to be crushed. Also, for me. Hello, both the petitions. Yes, sir. Which is your matter?
Serial number 23, my lord. Next matter.
29. Sir, it is agent to 29, sir.
29.
Yes.
Sorry, I was not knowing it.
Yes.
Orders matter. Orders matter. Serial number 7 password tong.
Number 11.